mentioning a
Minute.
yes from that side. Or the applications and order 41s, please hand over without mentioning. Then we'll take up the other mentions.
My lord, may we permit?
Yes. Which one?
Please, my lord, my lord.
Which one?
My lord, first.
Inclusion.
No, my lord, for release.
Any item in the list?
No, my lord. It
Hand
has.
over.
I'm grateful.
Yes.
My lord, may I have my lord, your lordship kindly to mention a matter, my lord, item number 26, my lord. I have the respondent number 1 on caveat, my lord. I'm praying, my lord, if this matter could be adjourned, my lord. Mr. Surajit Mitra is leading me in this matter. He's
Who's leading
unwell.
you?
Mr. Surajit Mitra is leading me in this matter. He's unwell, my lord. He's, my lord, if you
What do you say? Because order 41, they don't have a right of hearing, but immediately after that, in
My lord, since my learned friend is my lord, because my lord, I am
against
suffering.
injunction order.
Again, lordship will recollect, my lord. I had first round of litigation. Well,
No, this is only against injunction order.
Yes.
Injunction.
Then we can dispose of the appeal also. So we'll keep it on Monday. Then what's the use of admitting and keeping?
My lord.
Very well, adjourn till Monday, 26.
26.
My lord, only one
Item
submission.
number
My lord.
26, my lord.
Item number. If it may retain its position, my lord.
Yes, my lord.
What order 41 will
Or-
take up? 26 Monday.
Grateful, my lord.
Bracket
Grateful.
Monday date দিয়ে করে দেবে। Yes.
Grateful, lord.
Lordship praying for leave to file the appeal with a net copy. Lordship, the fact is that appeal is arising out of an order of dismissal of the Krishnanagar court. The
Of?
Lord, Krishnanagar court.
Dismissal of Krishnanagar court.
No, Lordship, dismissal of an order in the Krishnanagar court. And Lordship, there the fact is that their only Xerox machine is inoperative for last 3 months.
Where leave is granted. At a leave দিয়ে দেবেন তো? Yes.
May I have your lordship leave to mention a first appeal, my lord? Why am on behalf of the respondent? Upon notice, because I am suffering it's a partition suit.
The
The
hearing we are not including.
preliminary decree
Hearing no
against-
use
it will
including
take the lordship's 10 minutes time. Nothing in the first appeal.
No. Yes.
Compelling circumstances, item number 90,
90.
90 in today's list.
Yes.
The appellant number 1 is terminal patient diagnosed as colon cancer. So the lordship kindly take up the matter any day.
This will appear as the first matter under the hearing list on on February 18th. 18th February as the first matter under the hearing list. Note করে নিন।
Actually, may I
Yes.
mention one matter? Under Order 7, Rule 11 allowed appeal. We have informal paper book prepared, but every
Not right now. We have many other appeals on our roster.
party interest is being created. Lord.
Not now.
Permitted to mention a matter, your lordship. The suit has been dismissed for non-joinder of parties.
You are asking for inclusion of what? As an application or?
The appeal as well as the stay
So
application.
appeal no. Yes.
The stay application, your lordship.
Application. First appeal.
The stay application, your lordship.
Stay application we can take out, but not the appeal. Write it as application then. Yes, call on the list. Accordingly, FA number 180 of 2025 and FA number 181 of 2025 are allowed on contest without any orders to cost, thereby setting aside their respective impugned orders being such and such. Any subsequent extension of such interim order of injunction, if granted, stands automatically vacated and set aside as well. Can 1 of 2025 filed in connection with FMA number 181 of 2025 stand dismissed as well?
Grateful, my lord.
That for the applicant appellant.
I am for the respondent.
Was it appearing as?
The last question, my lord, your lordship was pleased to direct to, my lord, the state authority to deposit the shortfall amount 1 crore 40 lakhs and 43,000.
So you have deposited.
You have deposited.
Very well. So the appeal is now ready for hearing.
My lord, I am praying for my lord, the restoration of the stay appeal. My lord, otherwise, my lord, it is vacated, my lord, automatically.
Restoration of stay application means?
Stay, my lord, which
It
was
was
earlier granted. My lord, kindly see, my lord, page 24 of the application order.
Accordingly, can 5 was allowed, granting extension of the time for depositing. All right.
My lord.
So stay application has to be listed
Stay,
then.
my lord, we have prayed for in this application restoration of the stay.
No application is appearing before us. It is appearing
Non-deposit of, my lord, the shortfall amount, my lord, it is automatically vacated, my lord.
by which order? By which order?
My lord, 18th, my lord, August 2023, page 24 of my application. Last portion, my lord, accordingly, the time to deposit shortfall such and such period 4 weeks. In the event non-deposit of the shortfall.
Yes, we'll accept the shortfall and revive the stay. From the office report dated February 5, 2025, we find that the shortfall amount has been deposited pursuant to the orders of this court, although beyond the extended time. Push up next para. On the oral prayer of learned counsel for the state, we condone the delay in depositing the same and accept the said deposit as valid. Pushed up. Consequentially, on the prayer of the state, the stay order granted previously stands revived as on today. First. This one.
Paperbook is ready, my lord.
We are not adding any matter for hearing right now. We'll wait for some time.
Deeply obliged.
Any date, my lord?
Not right now. So many appeals, we cannot reach even the appeals.
We are deeply obliged.
Thank you.
Miller, I am appearing for the appellant. By mistake, I have not deposited the requisite.
Give us half a minute, we'll just see the report, then we'll hear. Subsequently, you have deposited.
No, virtually I have not deposited it.
So we'll give you time till when?
3 weeks time will be sufficient.
3 weeks for depositing requisites.
2 weeks will, but as
You can do it tomorrow.
Yes, Miller, I can do
I will give you 1 week's time.
1 week time.
On the prayer of learned counsel for the appellant, the time for putting in the deposits is extended till February 13, 2025. First up, upon such deposit being made, a revised report shall be furnished by the office. First up, the matter shall be listed under the same heading on February 18, 2025.
Notice be served by speed post.
Whatever was the previous direction remains. You just put in the requisites.
Okay.
Thank you.
Much obliged.
Thank you.
Item number 5, my lord, I am for the respondent.
Respondent.
Now, my lord, 2 applications are pending. The appeal has been filed by the Union of India.
This has come up on your mentioning.
My mentioning, my lord. My lord, specifically, my lord, tried to, my lord, serve on Mr. Anirban Mitro, appearing for the Union.
What are the applications for?
Section 5 and restoration.
Section 5 is for restoration.
Section 5 is for
What is the delay? I will just check up.
There is a substantial delay, and my lord, the other problem is, my lord,
if you want to file opposition to these applications,
no, my lord, I want to get this hard out. My lord, kindly, my lord, gives me an opportunity.
Since it has come up at your instance, just give another notice.
Yes,
we'll give a last.
Certainly.
The none appears for the petitioners at the time of call, although the respondents are represented through counsel. First up, since the matter has been enlisted on the prayer of the respondent, the learned advocate for the respondent is requested to serve a notice on his counterpart appearing for the appellants, indicating that the matter shall be taken up for hearing tomorrow. First up, it is made
Day after tomorrow.
very well. Taken up for hearing on February. Oh, tomorrow we cannot.
Tomorrow, the difficulty is, the only problem.
Tomorrow we are sitting singly. That's right. On February 10, 2025. Push up next para. It is made clear that in the event none appears to move the applications on the next returnable date and/or an adjournment is sought on behalf of the appellants, ex parte orders may be passed in the absence of the appellant.
My lord, in this matter, my lord, previously the learned ASG also appeared along with Mr. Mitro. My lord, may I also serve a notice on the learned ASG's office?
We have not specified.
My specific, my lord, problem is Mr. Mitro, my lord, is somewhere, my lord, I feel, my lord.
Serve everybody of the Union of India, from the Prime Minister to the ASG. We don't care. We want to see that good service has been effected. We will decide if they don't appear. Yes.
But I appear on behalf of the applicant.
Yes,
here.
Mr. Banerjee. What is the application for?
Yes,
I appear for the response.
Here for the other side, yes. Can 1, what is can 1 and what is can?
My lord,
There is a delay of 2447 days delay.
In filing the appeal?
Fine.
Only 244 days, you're not living up to the mark of Union of India.
I cannot
Or the
go-
state for that matter. Both are equal. So that is can 1. Yes, what is your answer
my
to
lord,
this?
on the last occasion, my lord, the lordship had directed for application, filing of the
Opposition.
oppositions, my lord.
You have given copies to them
Yes.
and no reply. So you are sure of the fate.
Not a
Any-
single word.
What is your explanation, Mr. Banerjee? Let us see. Read the relevant paragraph.
My lord, there is no
At least let us go through the formalities before dismissing.
that can be.
What is the explanation in your application? You have to move your application first. The opposition for stay, we directed you to file both. We directed you to file opposition for both the applications.
My lord.
But 7 delay, my lord, in merit, my lord, there is only one point I have that
Now the Supreme Court has held. Justice, I don't recollect whose judgment.
section 5.
Two judgments.
Two
Justice
judgments.
Padiyala one.
Yes. Pardon.
Anyway, what is your explanation? Let us see that. No explanation. So we'll dismiss it. Which explanation? Can 1 of 2021 is taken up for hearing. Push up. The said application is for condonation of delay in preferring the appeal. Push up. We find, comma, upon, tar age, we find take it. The affidavits in opposition filed to the said application and the stay application are kept on record. Push up next para. Upon hearing learned counsel for the parties and going through the averments made in the condonation application and the affidavit in opposition thereto, comma, we find that no cogent explanation whatsoever has been furnished for the inordinate delay of 2447 days. First up, it is well settled that the Union of India is not a favored litigant, and also that although the span of the delay is not important, comma, the sufficiency of the explanation matters. First up, we find that no explanation has been given whatsoever for the said delay. First up, accordingly, can 1 of 2021 is dismissed on contest without any order as to cost. First up, accordingly, FA number check.
My lord, my lord,
number?
FMA number.
FA 250.
Accordingly, FAT 250 of 2018 stands dismissed as time barred. Full stop. Consequentially, can 2 of 2021 is also dismissed. No order as to cost.
I'm great.
My lord, this is my.
Yes, Mr. Meena, what is the matter? Appearing for the first time or served?
No, my lord, served, my lord. I have served notice on 31st of January 2025.
You have already filed that receipt in court? Receipt of service?
No, that is with me, my lord.
This is an application for what? This is
But, there are application for alimony. Can 2, my lord. Can 3 is for.
You have challenged, you are the wife,
My lord, I am the wife, my lord.
challenging a decree for divorce. You have filed what are the 3 applications? 1 for alimony. Can 3 we find?
1 for injunction that was disposed of. 2 for alimony.
Dispose of a granting injunction, obviously.
Injunction. 2 for alimony.
So can 1 is disposed of.
Disposed of.
2 is for alimony. 3
Alimony.
is for recalling of an order. What is that?
Recalling of that not to contact second marriage. That order recalling they have filed along with section 5.
Oh, they have filed.
They have filed, my lord. Husband. On the ground, they have contacted a second marriage, my lord. And my lord, fourth one is my application for stay of operation of the impugned judgment and decrement.
That has become infractuous if they have contracted a second marriage, Mr. Meena.
My lord, they have the knowledge, my lord. Section 15 of the Hindu Marriage Act operates, my lord.
But stay would not help you. I mean, stay, we cannot grant stay.
Stay of the
Because
judgment and decrement.
stay of that has already been rendered infractuous by a second marriage. We can at best, at the time of final hearing of the appeal, if we allow the other applications, then we'll decide that.
My lord, on that application, my lord.
What is your application number? Stay application number?
Stay
Can 5?
uh,
Yes, can 5.
last occasion?
What is your objection to the do you deny that they have contracted a second marriage?
My lord, they have filed one certificate, my lord, of their marriage, second marriage.
Special marriage. Certificate of marriage under which, let us see.
Can 3, my lord, it is annexed at page 9, my lord. এটা কোন act এ? Special marriage.
বিশেষ বিবাহ আইনে. So special marriage act.
Special marriage, my lord.
So therefore, this is proof of marriage, conclusive proof of marriage.
My lord. But they have the knowledge, my lord. Because, my lord, from the record itself, my lord, when I filed this appeal before this honorable court, my lord, it is within the statutory period of
Samina, that
limitations.
marriage,
They have filed one.
we understand. The marriage may be irregular, but it's not an invalid marriage under any law. So we'll definitely consider the effect of that while hearing the appeal. But where is the scope of grant of stay? Because stay means the divorce is nullified. Kept in temporary abeyance. The divorce has been given effect to by contracting a second marriage. There is no scope of stay.
My lord, section
We
50
can at best dispose of the stay application by saying the second marriage will abide by the outcome of the appeal. That we can do. That will in any event happen. And regarding the alimony, you have not filed your affidavit of asset.
Yes, yes.
You have
Affidavit of
separately
assets
filed?
complete, my lord. I have filed. They have also filed, my lord.
Oh, that has been filed separately.
Separate. Opposition and reply already been
Give a
done,
notice to them. Let us come back.
my lord. And I shall file a.
Because alimony we have to hear on merits. Who is
My lord,
appearing for the other?
absolutely, my lord.
Who is appearing for the other side?
Onit Day. One Onit Day is now appearing.
Can 5 misdemeanor we are disposing of right now, saying that is
My
a
lord, kindly hear me, my lord. They have shot for an affidavit, my lord. Last occasion, probably they have shot for an affidavit, my lord. There was a direction, my lord, by the earlier bench for filing affidavits, my lord. On 9th of September 2024, my lord.
very well. Give a notice and come back. None appears for the respondent husband at the
One
time of
affidavit in opposition in connection with CAN 4 I am filing, my lord, today, my lord. Let it be taken on record, my lord.
very well. None appears for the respondent husband at the time of call. Fullstop. Learned counsel for the appellant wife files affidavit in opposition in respect of CAN 4 of 2024, which is kept on record. Fullstop. Next para. The learned counsel also files a receipt of service of notice of the pendency of the applications on the learned advocate for the respondent. Full stop. As a last chance to the respondent to appear and contest the applications, comma, the same is adjourned till February 10, 2025. Full stop. The learned advocate for the appellant is requested to serve a further notice regarding the next returnable date on his counterpart appearing for the respondent by tomorrow and file a receipt in that regard on the next returnable date. If they don't appear, we'll take up the matters expert. Yes. Appellant is the petitioner. Yes. What is the application? What is the appeal against?
The fact is that why not the appeal was dismissed for non-payment of court fees.
Oh,
now my lord, subsequently I have paid the court fee. Now application for recalling of the order dated 9th February 2023, my lord, CAN 2 and CAN 3
for accepting that deposit. What is the reason for the delay?
My lord, no delay. Well, actually, my lord, I was not present due to my personal inconvenience. I was not able to appear at that time. I missed the list. That's why, my lord, the payment was not.
Where have you annexed that order in CAN 2? The order of which you are seeking recall?
My lord,
this is your. This is whose medical papers?
My lord, my medical paper.
Your own?
Yes.
Due
to
whatever.
my latches, my lord, the payment.
Absolutely. Where is the order?
Page 7, my
page 7. So you have now put in the deficit court fees?
Page. page 29, 28, 29. Subsequently, after.
There should have been a report by this time people. Let's check. Allow করে দিচ্ছি dismiss for non-payment of recall for check. Can 3 of 2023 has been filed for extension of time to deposit deficit court fees. Full stop. We find that by an order dated February 9, 2023, a coordinate bench had dismissed the appeal for non-payment of deficit court fees. Full stop. Learned counsel for the petitioner submits that the deficit court fees could not be paid at the relevant point of time due to his personal illness, in support of which several documents have been annexed to the two applications before us. Full stop. Next para. However, subsequently, such deficit court fees have been put in, which is borne out by the annexures to the applications. Full stop. Accordingly, can 3 of 2023, accordingly, we are satisfied of the sufficiency of the reasons for the delay in depositing the deficit court fees. So accordingly, can 3 of 2023 is allowed, thereby accepting the deficit court fees. So can 2 of 2023 is also allowed, recalling the order dated February 9, 2023, passed in FAT 109 of 2022, whereby the appeal was dismissed for non-payment of deficit court fees. Full stop. The appeal is therefore restored to its original file and number. There's any connected stay application? Can one is also appearing today?
That is not in the.
Not in the list. Very good. Next para. Can 1 of 2023 be listed on February 10, 2025 under the appropriate heading for hearing? পোকা রয়েছে বই, এটা কিছু কাপড় টাপড় দিন তাড়াতাড়ি, এটা সব খেয়ে দেবে। নয়তো আপনার রুমালটা দিন আমি। Sorry. Give us up. Formally call করুন একবার 9. Yes.
Defendant is the appellant, my lord. Appeal arising out of a suit for partition. Decreed, my lord.
Final
Preliminary decree. Against that, my lord.
This is appearing for the first time?
No, my lord. There was an application for condonation of delay. Delay is of 7 days. In pursuant to the order passed by this honorable court, we have served a copy. Affidavit of service is there, my lord. 7 days delay, my lord.
Good service, Mr.
My lord, one of the plaintiff have received from the.
The other has not.
My lord, they were husband and wife.
Very. Affidavit of service filed today be kept on record. Stop. Since one of the respondents has been properly served and the respondents are spouses, we deem good service to have been effected on both the respondents, since the interest of one is represented by the other. Who's up next para? Can 2 of 2024 has been filed for condonation of the delay of about 7 days. You have checked up 7 days, Vijay?
My lord.
Of about 7 days in preferring the appeal. So what is the reason given?
My lord, initially the certified copy was handed, but copy of decree was not been
Very well.
handed.
Being
Lord, we have
satisfied
to
of the
make-
sufficiency of the cause of the delay, comma, can 2 of 2024 is allowed, comma, thereby condoning the delay in preferring FAT 91 of 2024. Full stop. The appeal be accordingly deemed to stand registered and admitted. Full stop. Next para. Can 1 of 2024 is an application for stay of operation of the judgment and preliminary decree passed in a partition suit. Full stop. Next para. The appeal arises out of the said partition preliminary decree and as such is required to be heard on merits. Full stop. Accordingly, you have served both copies of both the application.
Section 5.
Only
to
section 5. So accordingly, the learned trial judge shall continue with the final degree proceedings, but shall not draw up any final decree without the leave of the court, comma, till disposal of the appeal. Full stop. The petitioners shall serve copies of the application bearing can 1 of 2024 on the respondents, indicating that the application shall be listed under the heading applications in the monthly list of March 2025, comma, when an affidavit of service to that effect shall be filed by the applicants. Thank you.
Now, there is a plaintiff's appeal in a suit for injunction
Appear for the
with regard to
respondent.
construction of a boundary wall. My lord, injunction application has been finally dismissed on contest.
But the suit has been dismissed.
No, the injunction application.
Oh, FMAT, yes.
Yes,
Appeal was admitted.
I apologize for the
yes.
occasion.
Appeal is admitted. My lord, only one thing. In the impugned order, there were certain documents which the defendants handed over in court in course of arguments but were not annexed. My lord, despite directions by your lordship's coordinate bench as well as your lordship, my lord, those documents have not been given to us. So your lordship will kindly ignore that. They are not in a position possibly to disclose those, despite possibly 3 directions of
That-
this honorable.
Those documents were the basis of the order.
For the basis of the order.
I apologize. The last occasion, I somehow missed the list, my lord, so I could not appear.
What are these?
Those documents which we have filed through PDC, my lord.
So why didn't you give copies to them earlier?
May I say, my lord, before the matter, they came up with the coordinate bench. They have prayed for directions for placing out, handing over the documents to them. The coordinate bench stated that let the document be first placed before the court, then it be handed over. That's the reason for which we did not hand it over.
By order dated?
So, my lord, this is standard, my lord.
Possibly thereafter, your lordship had directed it to be handed, but that was the order by the division bench presided over by Justice Standard.
Anyway, hand over copies to them. Come prepared.
Because I've never seen those documents.
No, come prepared on the next. Name. Learned counsel appearing for the respondents hands over photocopies of documents which were apparently relied on by the learned trial judge while passing the impugned order of injunction. Injunction was granted.
No, refused.
Impugned order of refusal of injunction. Full stop. Next para. Copies thereof are handed over to the learned advocate for the appellant here and now. Full stop. Next para. The application is still pending. Mr.
No,
Gupta,
application is disposed of. Application.
can 1
Order 13-1 to application.
Appeal has been admitted, my
here before this
Can 1 is it's pending
Pending.
because I have a prayer for injunction.
in view of the what is your prima facie case? Let us see.
Yes. My lord, before
That
I
those
say-
copies were not given to you. That is
No, that is not the only case, my lord. That is one of my grounds. My lord, in a
we will
nutshell,
take up the appeal and the application together on Monday. Come prepared on
put
these
it to you on
papers.
Tuesday instead of Monday, my lord, if
Yes,
if it is
Tuesday, yes, why?
possible.
All the relevant papers are annexed here.
Everything is
Apart-
annexed. There's only order 13 rule 1 and 2 application, the objection and the reply.
Next para. In view of the short conspectus of the appeal, comma, formal paper books need not be prepared. Full stop. Records also need not be, the trial court records also need not be called for. Full stop. The appeal along with the pending application bearing can 1 of 2024 shall be heard together and be listed for such purpose on February 10, 2025. একটা কথা লিখে আড করে দাও আন্ডার দ্য হেডিং অ্যাপ্লিকেশন এটা অ্যাপ্লিকেশন হেডিং এই দেবেন
Grateful.
remind us that it is appearing under the application heading but we'll take up the appeal for it.
On a very short point.
That's why we kept it
Yes,
under the
yes,
heading
absolutely. On a very short. Yes.
Right, I'm for the appellant, my lord.
Right.
Appellant is the defendant in this matter, my lord.
Yes.
The plaintiff preferred and partition suit.
Is this appearing for the first time, this application?
Yes, my lord.
No service of copy was
No, my
directed.
lord, because stay is there. Stay application, I am also filed the stay application. So
No,
stay may be heard, my lord.
Yes, understood. But stay application was never directed to be served on the other side.
No, my lord.
What is the appeal against?
Appeal against the partition suit. Partition suit.
Preliminary degree or final degree?
Preliminary degree, my lord.
So you'll pass the usual order and
My
serve
lord,
copy.
stay may be given in this situation because, my lord,
Yes.
the court will proceed the case because before that I'm just kindly come to page number in the stay application 26 and 54. Why the gift deed was given by the father of the both the parties, মানে appellant and defendant. Already gift deed was given. That is a gift deed is registered.
Father
gift
was
deed.
the exclusive original owner.
Yes, my lord.
Father was the sole owner.
Sole.
Original owner.
Yes.
So he demarcated the property and gave to you, both of you.
No, not demarcated.
Acha.
But
Undivided
undivided
share.
property gifted both the parties, both the
Very well,
appellant and defendant.
Then what is your difficulty?
So difficulties, my lord, if the partisan suit will partisan
Preliminary degree was granted in terms of the gift deed. It was given equally.
equally 1/4.
So,
But in the
what is your grievance in the appeal then?
appeal by my lord, gift deed is in the from the gift deed. My portion is more than the other my sister's portion. That is the plaintiff. Here is a defendant, a respondent, my lord.
But it has been given equally by the
Yes, yes, that's the reason, my
No,
lord.
that will be decided in the final. Let the proceeding continue.
Wait, kindly
No, the usual order.
short stay may be given so that the
We'll grant you
because
short.
lower court below may be proceed will proceed the case, my lord. I will be my
Lower court will proceed with the case, but no final degree. The present appeal has been preferred against a preliminary decree passed in a partition suit. Full stop. The primary grievance of the appellants is that the shares declared in the preliminary decree are contrary to the gift deeds executed by the original owner stroke father of the parties, predecessor in interest of the parties, comma, which granted more than 1/4 share to the appellants. So next para, since the appeal is required to be heard on merits, comma, the learned, since the appeal is required to be heard on merits, comma, the appellant shall serve copies of the application on the respondents, serve on all the respondents, but on the respondents, why the bank managers are parties?
bank managers, there is a loan.
BLLRO bank manager.
Yes, my lord.
Anyway, on the parties indicating that the application shall next be listed for hearing in the monthly list of March 2025, when an affidavit of service to that effect shall be filed by the appellants. Full stop. In the meantime, the learned trial judge shall continue with the final degree proceedings, but shall not draw up a final decree without prior leave of the court, comma, till disposal of the application.
Okay, good.
Next. Yes.
Affiliate.
May I please, Your Lordship?
Yes, please.
Mr. Somo Mujumdar, my lord, he was the my lord.
Mr.
Mr. Somo Mujumdar, my lord. My lord, he was there before Your Lordship yesterday, my lord. Today, my lord, he's on his leg.
Because he was there before me today, you are sufficiently capable, no? You are the petitioner or the...
I'm the applicant, my lord. My instruction is his application, this is his appeal, and I have taken out a preliminary objection.
So your
related
learned
to the
friend may be
maintainability.
in difficulty
Yes,
from adverse order. Because
Can you
difficulty, he will be embarrassed only.
Yes, even yesterday, my lord, I was on my leg, so I
Oh, yeah, so then
yes,
it's
yes.
balanced out. That's
For
why
the
he said
bar,
it.
my lord, I cannot say.
An adjournment is sought by the appellant. Let the matter stand adjourned till February 10, 2025, Monday. So, but next time, whoever prays for time, refuse. Because it has been cancelled out now.
Grateful, my lord.
Yes. Defective. What is a defect, Mr. Mathur? There is a defect. Defective marked.
I applied for certified copy prior to the final decree was drawn up.
Oh.
Therefore, my lord, the authority, the department, my lord, could not calculate the limitation. That is the report.
No, you have
It was
not.
sent down to the trial court for correction, but that has also not been done.
Just check up once.
Agencies, my lord, taking advantage of the final decree, my lord, they are dispossessing me. They have taken forceful poison, some property. I have lodged complaint before the police stations, police authorities, but nothing has been. And KVL has been lodged, my lord, advocate is Paripur court, therefore I also could not serve upon. I have to serve by.
But you have filed the judgment and decree.
Yes.
You cannot suffer for that. So this is against what? Preliminary degree?
Final decree.
Final degree.
My lord, a revision application was filed challenging the application, rejecting the application for appointment of account commissioner by the defendant number 2. By the plaintiff, my lord, that has been allowed, and my application was rejected. And my lord, the final report was accepted. Challenging these two orders, I filed a revision petition. Initially, stay was granted, and still revision application is still pending. But subsequently, my lord, since the final decree has been drawn up, my lord, interim order has not been extended.
You are seeking injunction now?
My.
In the meantime, Mr. Mahato, you know what to do. Get that revision.
Caveat is there, I should serve, but my, he is in the Baruipur court. This is
No,
the
caveat is there, you should.
Yes, caveat is there.
Then you have to serve before we pass an order. Not pass an order.
আরে caveat filing এর সঙ্গে সম্পর্কিত নয়, কতবার বলবো।
Copy to the other side. And one thing, you can get the revision disposed of in the meantime with leave to take those grounds in the appeal.
Or my lord, revision may be tagged with this.
It will be better if you take that leave. And
Very difficult, man.
no, put it as to to be mentioned and for this leave only.
I shall try.
You try. We won't advise you on. The caveator. What is the address of the caveator? Barashat Court. Baripur Court. But since there's a caveat, have a copy and come back, Mr. Mahato.
Man, can take it on Monday.
Within Monday, you can serve.
Yes, man, I send a person my lord to serve upon him.
We'll keep it on Tuesday then, because you'll need those.
Monday,
You cannot prepare the affidavit of service. Learned counsel for the petitioner submits that although there is a caveat lodged, comma, the same has been lodged by a learned advocate at the address, at an address of Baruipur, which is beyond the territorial jurisdiction of this court, and as such, no copy of the injunction application could be served. Next para. However, comma, for the ends of justice, we are of the opinion that a prior copy of the application ought to be served on the caveator. Accordingly, the petitioner shall serve a copy of the application on the caveator and file an affidavit of service to that effect on the next returnable date. The matter shall next be listed on February 11, 2025 under the same heading.
The caveat has been filed by the opposite party number 2 and 3. So far 1, he is the plaintiff.
Then you have to serve. So we'll direct you to serve and
Mr. Phalguni Bandyopadhyay appeared in the revision petition on behalf of the plaintiff. If your lordship.
No, Mr. Mahato, we are not doing that. What we'll do is we'll take up the matter on Tuesday. Caveators will appear, and since nobody lodged a caveat for plaintiff, we'll pass orders till disposal of the application and then.
I'm good.
Yes.
My lord, Mr. Parthopratim Rai is appearing for the appellant, my lord.
So what, you are also appearing?
In court number 5, my lord.
What is the matter about?
My lord, I don't have the brief.
No, then we won't grant time. We'll dismiss the matter.
My lord, kindly.
The person who is appearing and asking for time has to know a minimum about the matter. Otherwise, we are not granting time. Sorry.
Lord, I don't have the brief. Kindly sort pass over.
No passover. No passover. Take our brief, prepare yourself. Right now. Move the matter. Eta din to. Injunction application.
He has given. His clerk, my lord, has given.
His clerk has given you consent.
The brief, my lord.
Brief. Fair din. How long are you practicing?
4 months.
4 months. Very good. Ripe enough. What is your name?
Comrade Chakraborty, my lord.
Mr. Chakraborty, open the brief and find out the injunction application. There's a section 5 application also. Not allowed yet. But then take up the section 5 application first. There's a condonation of delay application, take up that first. Section 5 application. The injunction application. Oh, yes, can. Delay কতদিনের দেখতে পাচ্ছেন? For condonation of delay?
My lord.
Open can 2.
Yes, my lord.
Mr. Banerjee, you are allowing the section 5. Mr. Chakraborty, led by his senior Mr. Roy, submits in support of the application for condonation of delay that in view of the grounds as made out in the application, in particular paragraphs 7 to 9 of the same, the delay in preferring the appeal may be condoned, full stop. We, upon hearing learned counsel for both sides, we are of the opinion that sufficient cause for the delay has been sufficient cause for the delay of about 29 days in preferring the appeal has been made out in the application. Full stop. Accordingly, Can 2 of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 364 of 2024. Full stop. The appeal is deemed to be registered and admitted. So, what is the appeal against? Probate. Probate. Injunction should be run.
Other one, in fact, kindly dispose of the application. We're keeping it pending. Say that I am not admitting any of the allegations and put us into paper books as soon as possible.
Anything else, Mr. Bell?
Only good wishes.
Write it down, we'll send. No, you are a senior advocate, you can do that now.
I dare not. still now, Milord, wings are not yet dry.
Next para. Can 1 of 2024 has been filed, praying for injunction. Push up, the appeal arises out of the grant of probate in respect of the subject matter of the concerned will. Full stop. Next para. Heard learned counsel for the parties. Full stop. We are of the opinion, that, in order to maintain the subject property of the will in statu quo, status estabad, during pendency of the appeal, which is required to be heard on merits, the injunction is sought for or to be granted. Full stop. Accordingly, Can 1 of 2024 is allowed on contest, thereby restraining the respondent from changing the nature and character of the suit property and or transferring, alienating and or encumbering the suit property in favor of third parties in any manner till disposal of the appeal. Full stop. Next para. You are appealing for the only respondent, right? In view of the appearance of the respondent through learned advocate, service of notice on the respondent, service of notice of appeal on the respondent is dispensed with. Full stop. The trial court records be called for by special messenger at the cost of the appellants. Would you like to put in the?
Otherwise, they will hold it up.
You will also prepare the paper books. Next. The trial court records be called for at the by special messenger at the cost of the respondent, full stop, on the prayer of learned senior counsel appearing for the respondent, the respondent is directed to put in such special messenger costs within a week from date. Full stop. Next para. The respondent shall within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the respondent, prepare and file the requisite number of paper books. Full stop. For such purpose, upon the records being received by this court and found and examined and found to be complete, comma, a notice of arrival of such records be served on the learned advocate for the respondent as well. For sub next para, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you, Mr. Give Mr. Rai's name as well. We have mentioned his name also. Yes.
In my lord, I appear for the appellant.
Yes,
My
Mr.
lord, I
Vardhan.
beg to appear for the plaintiff respondent. My lord, I am raising.
Are you in a position to?
Yes, yes, I'll do the matter. My lord, I am raising preliminary objection as to the maintainability of the appeal, my lord. My lord, may I be requesting your lordship to hear me first, my lord, since it's a question of maintainability of the appeal.
This is the reply. Where is your opposition?
My lord, on the earlier occasion we have
File.
My lord,
Opposition to page.
my lord, admittedly, it's a commercial dispute.
Admittedly.
Yes, admittedly, it's a commercial dispute.
Mr. Banerjee, come back on month. Because this requires some hearing and you are not in a position. Mr. Vardhan, come back on this. We are just making it not today. Your name, sir. Although learned counsel for both the parties are ready for hearing, ready for arguing the matter, comma, we find that in view of the hoarse voice of the learned counsel for the respondent, comma, we are not in a position to properly appreciate the contentions of the respondent. So accordingly, let the matter stand adjourned till February 10, 2025, Monday. Let everything be transparent and on board. Because otherwise, he will be guilty of not representing his client today. Yes. Next. Order 41.
I am appearing on behalf of the appellant.
Thank you. Yes, appellant. Last chance given to you because you are not appearing deliberately avoiding the court. Yes, why are you deliberately avoiding the court? There is nothing in your matter, obviously.
This matter was mentioned by the opposite party, my lord.
Opposite party?
My lord.
নতুন practice শুরু হয়েছে. Order 41 they cannot mention. They don't have a right of hearing. But that is not a ground for you not to move the matter.
My lord, in the meantime, my lord, appellant number 1, 2, and 4, my lord, died, my lord.
1?
Liberty. 1, 2, and 4.
Appellant numbers 1, 2, and 4 have died. Why didn't you take any step in the meantime? And there is a section 5 also.
My lord.
Have you served a copy of the section 5?
No, my lord. In the meantime, I shall prepare, my lord, then.
Very well. Then these applications have to go before the single judge. At the time of call, comma, learned counsel appearing for the appellants points out that during pendency of the appeal, comma, appellant numbers 1,
2, and 4.
No, they have already, their names are in the section 5 application. You have entered their names in the section 5 application. What are you saying?
Section 5, my lord. Then, my lord, 1 only, my lord. 1 only, my lord.
যা বললাম তাই, appellant number 1 has died. Full-stop. Accordingly, leave is sought by the learned advocate for filing a proper application for substitution. Full-stop. Next para, we also find that there is an application, there is a pending application for condonation of delay bearing Can 1 of 2021. Full-stop. Next para. Accordingly, leave is granted to the appellant to mention the application for condonation of delay as well as the substitution application, comma, as and when filed, comma, before the appropriate learned single judge having determination to take up applications in connection with second appeals. Push up. Leave is granted to the parties, comma, subject to such applications being disposed of, comma, to mention the matter for inclusion in our before this bench for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Leave is given to the parties, bollam na? Last day, leave is given to the appellant.
Good.
Thank you. Right of sharing নেই তো ওরা মেনশন করতে পারেন
My appeal against refusal of an ad interim order of injunction in a suit for cancellation of a deed of sale in respect of a Devotar property obtained on an application under section 34 of the Indian Trust Act.
Before my lord, my learned senior friend starts, this appeal was heard, my lord, in extenso by the Honorable Division Bench presided by Justice Harish Tandon. The lordship may check, my lord, in the order. I don't have any order.
I'm not disputing
Perhaps-
it. If it
perhaps
was heard
hearing-
in
no,
extenso,
perhaps if hearing has not been closed, there is no issue. If it had been closed, because it was
it's not. I'll tell you what.
consecutively, it had been heard. Just
Yes,
check
yes,
that.
I agree. I went back to him. I went back to the learned judge, asking him to please have it listed. He said, since I have not marked it as CAV, it will be contended that I have assumed jurisdiction, therefore I will not take it. I said, you've heard in extenso.
It has been heard in extenso.
I agree.
We have no problems, my lord, if the matter is heard before your lordship.
No, I don't have any problem. I'm just pointing it out. In the event, it is marked CAV and your lordship
No,
starts
it is
hearing
not, because I went back to him. He said,
I don't
because
have any
I have not
problem
marked
at all.
it CAV, I will not do it. I pleaded in for 5 minutes. He still didn't agree.
It was heard in extenso.
Absolutely.
In fact, the impression given was that the matter is being reserved for orders.
Yes.
It then came up for orders. I do not know whether, my lord, in the final order, my lord has recorded anything to the extent that the hearing stands closed or anything.
It's not
If
there.
it isn't, then no, there's no difficulty. Otherwise, not maybe the court's time would have been wasted.
Justice Tandon's last order records on the prayer of the appellants, let this matter be listed on 30th of April. Justice Madhuresh Prasad.
That was prior. Justice Tandon was thereafter. Justice Tandon heard us in extenso.
Absolutely.
Almost for 2 days. Oh, তার কোনো order
তার
হয়নি।
কোনো order হয়নি।
Very good. Records speak for themselves.
Yes. Then we'll take up the order.
Ballot can take the.
So this is appealing first for order 41. I mean, for admission hearing. Let us see.
The impugned order, you would find at page 35 itself. You do not need to travel between.
What is the other application? Can 2?
Can 2.
Addition of parties.
Yes, that's the application for addition.
So subject to admission of the appeal. Yeah. So page 25, you said. Page 35, this is the entire order.
That is the entire order.
Let us see.
The Cali looks to the date of the order.
Yes. I have approached within time. If I have not been able to get it heard, and there are reasons for that, that's not my fault.
And this is an ad interim order.
Yes, I've said so. I believe they've got a better point than that. I mean, at least I hope so.
Mr. Chatterjee doesn't believe that.
He doesn't.
No, my lord, he doesn't have a case anywhere, my lord. He's completely an interloper coming up and saying that he wants to protect the Devotar property. I have better points, much better points, but that doesn't mean, my lord, that he carries on with this forever.
It's my application. My lord will hear me first.
The sale was secular. I mean, not pertaining to, not for the.
No. Devotar property was sold.
Devotar property was sold,
Yes.
but the sale was to a secular person. I mean, not.
The sale was to a secular.
Not for the benefit of.
No, I believe that's our contention. A property worth 70 crores was sold for 2 crores.
No, you said they took permission under section 34.
Yes. Firstly, section 34 doesn't apply.
Why?
Section 1 of the Indian Trust Act clearly says it doesn't apply to religiousness. And
Because it's a religious endowment or what?
Yes, the Devotar property, admitted case, settled up to the Privy Council. My lord will see his bullets. He says.
Literally.
Huh?
Literally, bullets.
Exactly. I mean, I make an application for recalling that order. That application remains pending. I've not been able, in spite of 2 directions from the High Court to dispose of it, the trial court does not. I mean, is not allowed to. That's the first ground, that till date the order of district judge has neither been set aside nor declared as ineffective. The disputed matter pertaining to the said sale deed is pending. Yes, that is the only, this suit, there's no other proceeding challenging the sale deed. The said deed is a registered one, totally material. It says, be that as it may, the said dispute at best be decided after giving the opportunity of being hearing to the other side, not at this early stage. Don't decide it now, but that doesn't mean you can't give me an identity motive injunction if I have the facts. And he says during the pendency of this suit, if there is any transfer, there is list pendants. List pendants can never be a defense.
No, what about the first A, bulletin?
Yes.
What is your answer to that? Because the district judge order still stands. You have not challenged that.
District judge order may stand, but district judge order is a nullity in any case. But even be that as it may, I have applied immediately for vacating this application. My lord will see my application at page 217.
But that is kept pending. I mean.
My lord, please see the orders at page 247 and 249. This was applied for not by me, of course, but by another Shabai. But whatever it is, the application was pending.
So the revisions are against that. What against what?
This refuse the revision. I have now come up.
These revisions are against what?
This was for recalling of that order, granting permission to sell.
Section 34 order.
Yes. And see the orders at page 249 and 247 and 249.
So the first one directs the judge through. Oh, the recall order is for recall of that section 34 order.
Yes.
Oh. So what happened after this direction of Justice Chaudhary?
Nothing. Still pending. See the next order. Still pending.
They are taking time.
Yes, we
can
can
know
know
that. Yes.
Any case, whether I'm taking time or not, I mean that firstly I'm denying that I'm taking time. There was a direction to do something by this court. That's not the subject matter here, any case.
But Justice Chaudhary's second order says it is made clear that the opposite party shall not take any step in the matter of disposal of the Uttar. Page 250.
Yes.
So that order remains.
Yes.
So why do you need another injunction?
Exactly.
No. This was after sale.
They've now applied for mutation. They're going to put up a multi-story building. The third party. And my lord will see the order. This order was obtained. The judge was getting transferred in 3 days. They apply for preponing, and the judge prepones it and passes the order and leaves office. By 3 days, preponed by 3 days. It's recorded in the order itself. Who applied?
What is this application of yours, Can 1? An application for orders, you want a setting aside of that impugn order. You have not even asked for injunction. Can 1? What sort of an application is this, Mr. Chaudhary? We cannot pass any order on this application. File a proper injunction application. To ask for orders. Application for stay of operation. We will grant stay of operation. We are granting stay. We allow this application, we are granting stay.
My lord, we see the last part at page 31 before ad interim orders.
Yes.
Further restrain the respondents and on their main agents, servants, and assigns from dealing with the said premises.
But that is an ad interim order which is not in connection. Oh, very well. Pending hearing there.
Yes, pending hearing of this appeal. Yes. The appeal will.
But the principal prayer we cannot grant. You ask for a setting aside, and this is in aid of that. We are not being technical, but this is the application you have filed.
My lord can modify the appeal always. My lord is here.
We'll admit the appeal, Mr. Chatterjee, and why not grant injunction for a limited period? We'll place the appeal and application for
I'll tell your lordship why Mr. Banerjee is there in court. He'll be easier for him to tell your lordship. And if he gives me 10 minutes tomorrow or on Monday, it'll be very, very grateful.
We'll keep it on Monday. We are admitting the appeal and keeping the appeal application together for disposal on Monday.
Yes.
We'll do that.
My lord, could it be on Thursday?
Yes, absolutely. Why not? Thursday then. We are not granting an interim order now.
But let it be understood they will not do anything.
No, now understanding.
No, then we'll pass an injunction order, Mr.
Please do not do that. Kindly hear us on the returnable date, and then for these 3-4 days, nothing will happen. We are not doing it.
You cannot deal.
Let him undertake. I'm not asking.
You cannot deal with the property in the meantime. We have found a prima facie case for it's arguable.
Yes.
The plaintiffs in a suit.
My submission was not without hearing us on that day. Kindly not pass any order of injunction. Hear us any day.
Pass it for a limited period, Mr.
No, my lord, we will not do anything in the meantime. That's our word. Lordship did not pass an interim order.
Then we'll record that.
Yes. Then kindly bears with me for a minute. Then kindly cease, my lord, with respect to, I don't know.
Yes.
I have not addressed my lord on facts till now. I mean,
with respect to what?
My lord, your lordship will find if he wants an ad interim order,
yes,
it had to be very quick. It is my lord's division bench order which says that even 7 days delay, you are not entitled to an ad interim order. My lord, kindly see the sale is of 2015. He has come to know in 2019, and he has arrived in the High Court, my lord, in 2022 and not prayed for an interim order, my lord, any time. The matter was being heard finally before Justice Prasad. No prayer was made for an interim order. Was being heard before Justice Tandon. Heard completely. No prayer for an interim order.
Absolutely.
So today suddenly, my lord, today
No
suddenly,
interim order has been granted to you at any point.
never prayed for. Never prayed for.
We'll keep the appeal application together on Thursday. We'll hear.
Can you hear us out?
Keep it under the application heading so that it's not.
Yes, it can be heard out.
Heard.
Well, let it be understood, my lord, as Mr. Chatterjee submitted, that he will not do anything.
We find from the records that the matter was taken up by different different coordinate benches at different points of time, apparently with the intention to dispose of the appeal at the time of admission hearing. However, since there is no formal order of admission of the appeal, we take up the matter under Order 41, Rule 11 of the Code of Civil Procedure. The appellants have taken several raised several cogent questions which are required to be answered in order to properly adjudicate the appeal. The appellants challenged a sale effected in respect of an allegedly Devottar property by the respondents. There's
no dispute, it's
Devottar. Next para.
There is a dispute.
Such sale was effected pursuant to an order passed under Section 34 of the Indian Trusts Act, which the appellants argue to be a nullity in the eye of law in view of the provisions of the said act not being applicable to a Devottar property. Next para. That apart, the appeal is required to be heard on the other grounds taken in the memorandum of appeal and is hereby admitted. Next para. Since the relief sought in the application pertains to the merits of the appeal as well, in order to avoid unnecessary unnecessary and full-fledged hearing at the injunction stage, we fix the appeal for hearing along with the application on February 13, 2025, when the matter shall be listed under the heading applications. It's made clear that the appeal will be heard without calling for the trial court records and on the papers already before us. Filing of formal paper books is dispensed.
will record with the challenge in the show. Meet volunteers.
But thank God your lordship kept it on the 13th of February. 14th February, a lot of people around your lordship would have been busy.
No, it doesn't affect a Devottar property.
Might affect Mr. Chatterjee.
It affects all of us. We don't admit. But it's a foreign concept. It's alien to us. Now we are making in India. So Saraswati Puja is more of an appropriate occasion than Valentine's Day for Indians.
That's why there are
At least Bengali.
There are 2 days of holidays for Saraswati Puja in
Yes, but that was unnecessary probably the second. It's a personal opinion.
Mr. Banerjee Millard would have been really.
Mr. Chatterjee will express an expectation then at least that he will not deal with the property.
Lordship need not. I'll talk to my team.
Lord, if you do anything like that in the meantime, it will get the wrath of your lordship's Lord. So therefore, Lord, it will not be done.
Do not even, Millard, kindly do
Accept.
not.
Accept. Yeah. Yes.
Do we dare do anything with the court having fixed it within 4 days? We'll be calling our own downfall. Lord.
Grateful.
8. Yes.
Lord, I'm appealing for the appellant.
What is the defect? First, let us check. করে দিয়েছি ওদের। To the certified copy of trial court may send down for necessary rectification. Very well. The defect has to be cured before the trial court will hear the appeal under Order 41. Yes, what is the matter? Move the matter under Order 41. Admission here.
I have lost both the courts.
Please take the microphone a bit closer to you.
Millard, I have lost both the courts, Millard.
The suit is for?
The suit for Millard ejectment, Millard. Ejectment suit, that's Millard.
Suit for?
Suit for ejectment.
Ejectment.
Under the Transfer Property Act.
Acha. So under, you gave a notice under 106?
Lordship. Every issue was decided in my favor, Millard. Appellant's favor, Millard.
It's a judgment of reversal.
Lordship.
Trial court granted the decree to you.
No, no, Lordship. Both the courts, my lord, junior division I have lost.
Why
and my
did you
lord,
lose? What was the findings of the courts, Miller?
Your Lordship, kindly come to
Take the microphone, sir. We cannot hear.
Lordship, order of my lord, senior division, Lordship.
Yes.
Lord, I am reading, my lord.
Yes.
Lord, have you Lordship got? Lordship?
Got it.
Lord. And having stood consideration to this day, the court delivered the following judgments. The
Can you hear yourself? We can't hear you.
Be loud. My lord, the brief fact.
Take the other microphone, please. Take the other microphone. Just bend it towards you and yes, better.
Lord,
Why was this 106 notice held to be invalid? Why? Manufacturing purpose.
Manufacturing purpose. My lord, that is, my lord, my lord.
Manufacturing purpose requires a 6 months notice, probably.
No, 6 months.
6 months. And you gave a 15 days
15
notice.
days notice, my lord.
What is the finding of the appellate court regarding that it's used for a manufacturing purpose? Lease given for a manufacturing purpose?
My lord.
Otherwise, it's a concurrent finding of fact which goes against you. If both the courts have held that it's given for a manufacturing purpose, then the other
Lordship, at that time there was no manufacturing unit, my lord.
let us see substantiate from the appeal court judgment that it is wrong. Merely because another view is possible, we won't interfere in appeal. It has to be shown that the appeal, the findings
there was no
wrong.
record, my lord. There is no agreement, no bill, my lord.
What is the basis on which it was held? Let us see that. ESI Corporation identity card, employee, cotton mills were being run. There is no written lease deed. No written
no
lease
lordship.
agreement.
Only rent bill was there.
Rent bill was there. So let us see the basis of the findings of the appellate court.
Lordship. My lord, decision with reason, my lord. I'm reading, my lord. There were points are taken from
Which page? Which page of the
my lord
appeal court? Internal page?
No, internal page, my lord. Lord, just my lord. Degree of my lord, judgment of my lord, senior division and third page, my lord.
That's a judgment of senior division.
Decision with reason, my lord.
Yes, yes. We are looking into the other. Wait.
My lord, point number 1 and 2. The above points are taken up for convenience and consideration. The learned advocate for the appellant submit that the learned trial court decided the issue that whether the plaintiffs are the owners of the suit property and is there any relation of landlord and tenant between the parties are decided in favor of the plaintiff. With the regard to the defect of the parties, learned trial court decided the issue in favor of the plaintiffs regarding the issues related to the notice to the learned trial court has observed that the notice is invalid and bad in law, bad in the eye of law, and the
Transfer of Property Act. Yes, please continue.
And the lease has not yet been terminated by the said notice. And the learned trial court observed that the bakery business is manufacturing business and required 6 months notice. Accordingly, the orders issue, that is issue number 1, 2, 5, and 6 are decided against the plaintiffs. It is also argued that admittedly the suit premises is a shop room and is governed by Transfer of Property Act 1982, and plaintiffs have created the tenancy. It is stated further that rent receipt issued by the plaintiff number 2 shows the original defendant Sakina Bibi was the only tenant, and after the death of her husband, as such, what her husband used to do in the premises is immaterial. The Millard, kindly mark it, Millard, it is observation of the learned court, Millard. As such, her husband used to do the premises immaterial, Millard. Millard,
that is your argument. That is
Origin-
not the observation of the court. Your arguments are being recorded.
Original defendant did not
Learned
show
advocate for the appellant submits, it's a continuation of that. The finding of the court is at page 5. Internal page 5 at the bottom, after hearing both parties. You are reading your own arguments before the appellate court.
Lords, I'm reading, Millard. After hearing both the parties and perusing the written argument filed by both the parties, I find that the suit has been filed by the appellant plaintiff for eviction of the defendants. The case record also reveals that original one Aurobindo Jana, the predecessor in interest of the plaintiff number 2 and 3, had inducted one Sheikh Nasir Nasir as a tenant in the said suit, shop room. And the tenant, nature of the tenancy was non-residential, that is for bakery. After demise, there was no agreement, nothing was there, beyond pleading. They are
When
only
you filed the suit, you gave the notice. The original tenant had died.
Original tenant died.
You gave the notice for the first time to the wife.
Lordship.
And she was not running any manufacturing unit.
Lordship, right.
But the language is that if the lease was granted for manufacturing purposes.
They could not show anything, my lord. Beyond pleading, this order was passed.
If the original lease was granted for manufacturing purpose, even if she subsequently discontinues, then it remains a lease for manufacturing purpose.
Actually, my lord, they have to prove something. No, my lord, that is the
Before that manufacturing was going on. Yes.
But they could not, my lord. After demise of Sheikh Nasir, his wife used to pay rent on behalf of the defendants, and she was considered as a tenant. According to the plaintiffs, the plaintiff number one has purchased the person of suit property, and he become the owner, landlord of the suit.
But it says admittedly the suit premises is a shop room and it was used for bakery.
My lord, they claim, my lord. My lord, when I issued notice, my lord.
Admittedly means you have admitted. Must have come up from the evidence. What is the dictionary meaning of manufacturing?
Manufacturing, my lord, something, my lord, to produce, my lord.
Something new has to be created. Bakery, why isn't bakery manufacturing? It is manufacturing. Something is being manufactured from the raw materials differ from the finished product. So why isn't it manufacturing? The definition is manufacturing is the process of turning raw materials, as you said, or parts into finished goods through the use of tools, human labor, machinery, etc., and chemical processing. The bakery is precisely that. The dough is used for manufacturing the finished products. It said that you have admitted, it's admitted that it was a bakery or pottery business. And it's a finding of both the courts. What did the trial court say? Let us see the trial court judgment on this. Where is your plaint? Have you annexed your plaint anywhere?
Milord, in my application, Milord,
have you admitted that it was given for bakery purpose? Let us see that.
No, Milord, nowhere I have admitted.
Let us see your plaint. You have annexed your plaint at page 14 of the application. Let us see that.
Lords, suit for ejectment valued at rupees.
Need not start from there.
Milord, para 1, Milord, that one shop room, common bath and privy, have been.
They've admitted only shop room.
Lord.
Shop room need not necessarily mean a manufacturing business. Let us see where they have pleaded. You as PW1 have admitted that originally Sheikh Nasir was inducted for bakery business. Page 12 of the trial court's judgment, para B. In your evidence, you have admitted food license has been shown.
At that time, Millard, when the notice was issued, and suit was filed,
But that is not the relevant time because section 106 does not say at the time of issuance of the notice. Section 106 starts with in the absence of a contract or local law or usage to the contrary, a lease of immovable property for agricultural or manufacturing purposes.
And
shall be
Millard,
deemed to be a lease from.
And that may
If
be
the
Millard,
lea-
but
the relevant point is the grant of lease. That
but
point.
Millard, defendant could not show any document that
You have admitted that it is for a bakery business. Exhibit E is a food license showing it's a bakery business.
Millard, that license was not up to date, Millard.
Bakery to manufacturing নর্মাল ইয়েতে আসে না মানে ইন্ডাস্ট্রি আমরা ভাবি কিন্তু ম্যানুফ্যাকচার তো যে কোনো র মেটেরিয়াল কে যদি
It is Millard same
র মেটেরিয়ালটা কনভার্ট করছে টু সামথিং এলস সো ইটস আ ম্যানুফ্যাকচারিং sorry it's a concurrent finding we don't want to impose we don't want to substitute our views for that we agree in the facts of the case whether bakery is a manufacturing business there is some doubt on that but it's settled you know the settled law that if there's a concurrent finding even if you are the first appellate court we cannot substitute our views for that of the trial court one of the plausible views has been taken so sorry no interference
Millard, there is they could not show Millard any documents.
No, they showed exhibit E. Exhibit E is a food license, and you admitted PW1 in your evidence that he was inducted for bakery business. You admitted.
Millard, there is a good ground, Millard. You also kindly admit this, Millard.
No question of admitting. The present second appeal has been preferred by the plaintiff in a suit for eviction under the Transfer of Property Act 1882. Puts up learned counsel for the appellant argues that in the absence of any evidence to indicate that the lease was granted for a manufacturing purpose, both the courts below erred in law in holding that the notice under section 106 of the Transfer of Property Act, issued for 15 days, was invalid, since a 6 months notice was necessitated under the said section for a manufacturing lease. Push up next para, it is further argued that at the point of time when the notice was issued, the wife of the original lessee who was in occupation of the property, was not running any manufacturing business and as such, the very premise of the impugned judgments is wrong, is erroneous. Push up next para. However, we find from the language of section 106 of the Transfer of Property Act 1882 that the same envisages the relevant point for ascertaining whether a lease is for manufacturing purpose is not the time of issuance of the notice under section 106 but the juncture when the lease itself was granted. Full stop. Section 106 within bracket 1 commences with the expression double inverted a lease of immovable property for agricultural or manufacturing purposes shall be deemed to be a lease from year to year. Double inverted close. Full stop. Next para. Thus, the second argument of the appellant cannot be accepted. Full stop. Next para. Insofar as whether the lease was granted for manufacturing purpose, it is admitted in the plaint that the lease was given to run a shop room. Full stop. The learned trial judge considered Exhibit E, a food license in respect of the shop room issued in the name of the defendant, of the original defendant by the government of West Bengal. Full stop. Besides, it was recorded by the learned trial judge that in his cross-examination dated December 7, 2016, the plaintiff stroke appellant number 1, as PW1, admitted that originally the original tenant, that is husband of the present tenant, tenant গুলো lessee করে দাও, lessee, was inducted in respect of the shop room for bakery business. Full stop, next para. Both the courts below dealt with the issue as to whether a bakery business can come within the purview of double inverted manufacturing within the contemplation of section 106 of the Transfer Property Act. Full stop, next para. Although it is arguable as to whether a bakery is a manufacturing business, the view taken by both the courts below that it is so, is undoubtedly one of the plausible views on the facts on record, since even in a bakery business, raw materials are converted into finished products which are then sold, which may come within the broad purview of manufacturing. Full stop, next para. It is also well settled that the appellate court, particularly the second appellate court, shall not substitute its own views for that of the courts below, merely because another view is possible on the same set of facts, particularly in the teeth of concurrent findings of both the courts below that the lease was granted for manufacturing purpose, and as such, the notice of 15 days under section 106 of the Transfer Property Act was invalid. Full stop. Hence, we do not find any substantial question of law involved in the appeal. Accordingly, SAT number 96 of 2024 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2024 also stands dismissed without any order as to cost. Sorry, you argued very well, but we cannot interfere here. It's a plausible view taken by the trial. Please give it, please.
Responded.
Condonation application has been served.
Yes, that has been served. Last date, not that has been served.
They did not appear. The sought for adjournment on the last petition.
Yes, my lord. Mr. Trivedi appeared, my lord, for the.
Mr. Yes.
My lord,
you are given an adjournment to the last occasion.
my
Move
lord.
the matter.
My lord, led by Mr. Dhiraj, he's on his lady.
So what? What can we do? We cannot wait indefinitely for any person.
My lord,
Sorry, no adjournment was granted on the last occasion. You have to move the matter or you dismiss it for default. Move your matter immediately.
my lord, pass over, my lord.
No passover. Sorry. We are dismissing it for default then.
My lord, kindly.
This is the second occasion when an adjournment is sought on behalf of the appellants.
My lord,
Stop.
there is a section 5 application, my lord.
Section 5, you are allowing. Move your order 41.
Kindly give up 10 minutes pass over, my lord. He's on his 37, my lord. Kindly, my lord.
We are passing it over, Mr. Mukherjee. এটা কিছু লেখার দরকার নেই। পাস ওভার করে রাখুন। Ask him to come when we come back from that 12 noon respite. We'll take up the matter.
Yes, there is some defect. I don't know what is defect.
Defect. You have not checked up. Your junior has not.
Yes.
First name of the trial judge furnished in the preamble of the instant memo does not tally with the certificate copy. Annoda Shankar Mukhopadhyay have written and the name in the trial judge Arif Alauddin.
Huh?
Yeah, nominal error. The first name of the trial judge was something else, not Arif. Anyway, we'll give you leave. We'll correct the first name. In the memo of appeal, Mr. Ghosh, the first name of the learned trial judge, Mr. Asif Alauddin, you have written Arif. So correct that. We are giving you leave immediately. Move the matter.
Another kindly take up next day.
Why?
Lord, the matter.
You are appearing, Mr.
Lord, I am appearing, but I will give yesterday matter appeared today. Only one day, Lord. I'll do it.
Well, kindly direct half the copy of the application.
Not entitled.
I have filed the caveat after before
They have filed the application before, my lord. Thereafter, I have filed.
Then give a copy of the application list.
Yes, I will give it. And my lord, on the next day I will do, my lord.
Very well. Leave is granted to the learned advocate and record for the appellant to carry out the necessary amendment to the preamble of the memorandum of appeal, comma, by inserting the correct first name of the learned trial judge during the course of the day. Do it immediately instead of Arif Asif. Push up next para. A copy of the connected application be served on the learned advocate for the respondent.
This number 1.
All respondent number 1 be served on the caveator stroke respondent number 1 during the course of the day.
Here and now.
Full stop. Next para. On the prayer of learned senior counsel appearing for the appellant, let the matter stand over till February 10, 2025.
Is Maiti appearing for the respondent also?
Give the names. Mrs. Usha Maiti. She's
Your
in.
Lordship, Your Lordship, I am here.
Oh, you are online. I said, Ms. Maiti, you have been elevated to online appearances also.
My lord, I am not my lord, well now, my lord. I am under
No,
treatment.
it's all. It's all.
That is
Your
it.
name is recorded. Your name is recorded. We will take it up on Monday.
Man, grateful, deeply obliged to your lordship.
Before the next matter, we'll take that break and come back. Is your matter?
If I render unqualified apology,
Accepted.
I was on my legs. Millard, I was here, Millard, but then
No,
I
he
thought
told
the
you,
70
junior sir.
would go for a longer.
We won't ever get you before the civil courts unless we put some pressure. You'll have to be here,
my
but
antecedents,
there are
Millard,
other callings also.
This is
The condonation of delay application is there first.
My lord, it is there, Millard, but as I understand what my lord, if my lord finds merit in my appeal.
No, what is the delay?
Delay is
14
not much,
days.
Millard. Yes.
So we'll treat this as an application in connection with order 41. So we'll, you are for the other side. We are allowing the condonation of delay and taking up the order 41 matter.
My consent may not be.
No, definitely not. You're right. Heard learned counsel for the parties. First up, we find that sufficient cause for the delay of 14 days in preferring the appeal has been made out in the application. First up, accordingly, Can 2 of 2024 is allowed, thereby condoning the delay in preferring SAT 160 of 2024. First up, the appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes, sir. There is no other defect, Mr. Tiwari.
The defects have been removed,
Removed, very well,
by
yes.
my
Very well.
advocate record, Millard. It has
Yes,
been
yes.
removed.
Well, what is the matter about?
My lord, this is a case, Millard, an eviction suit, Millard. I am the defendant in the eviction suit, Millard, defendant tenant.
Lost in both courts.
Yes, Millard, on the ground of reasonable requirement, but then that is quite strong ground as the trend now goes, Millard. Prior to 2012, trend was slightly different, but Millard, it is now different. But here, Millard, I have got only three grounds, Millard, on which I would like to beseech before your lordships that as to whether I can make. Otherwise, Millard, it's only on point of law, Millard. Millard, here, Millard, just what is the factual matrix of the case, Millard? Just, Millard, will give me 2 minutes first. Millard, the plaintiff's case in the plaint is that he purchased this property in 2013, waited for that 1-year period, and then after that filed a suit against me in 2015, saying that I do not have any other property in and around Calcutta, and I have 3 dependents, one my daughter, my son-in-law, granddaughter, and my wife. For them, 10 rooms are required, and that was the case made out. In between that, he also makes a statement in the plaint that he is staying with his daughter at present. He doesn't have any property of his own. So it was admitted that the daughter has a residence here, but whether tenanted or ownership, nothing was stated in the plaint. We, in our written statement, came up with the defense that the premises which they are staying at present, which belongs to the daughter, is sufficient, one.
No, daughter is staying there, or plaintiff is also staying.
He was also staying there, but we said, Millard, that is that at the very beginning, Millard, I gave Millard.
So that is sufficient, you said, yes.
Sufficient, and Millard, that there are other properties also. This was my statement in my written statement. Then, Millard, what happens was that issues were framed, and I was also another ground which I took is that notice was not served on me properly. Now, Millard, after that, in my evidence, I come up with 2 properties, both of them belonging to the daughter and the son-in-law. The other property.
In evidence, you come up with 2 properties.
Yes. I come up with one deed, which was admitted basically by the plaintiff. That was 12 Bidden Street, where he is residing with his daughter. And the second property, we could lay our hands on the documents. So we exhibited the tax bill or the letter of intimation issued by the Kolkata Municipal Corporation, where it was
in the name of the plaintiff.
Daughter.
Now,
the case which I was
daughter is a married daughter.
The case which I was trying to make out before the learned trial court was that once there may be other properties also. So, my lord, the carriage of proceedings is on the plaintiff, and when he comes to court with unclean hands, and he is not entitled to any relief either in equity or in law. Now, my lord, what my contention was that I also took out an application under Order 39, Rule 7 for inspection of the premises.
Who took out? They?
They took out. My premises was only inspected.
Oh.
They did not take out. I took out an application where I took this plea that there are these 2 flats which belongs to the daughter, and they are benamdars. Because in cross-examination, the plaintiff admitted that he was also residing in Bardhaman. where he had a house. He
Bardhaman house is irrelevant for
my lord, why I'm trying to make out a case, my lord. Even I call wasting my lord's time because, my lord, it's a tall order, but my lord, let me climb that order, my lord. Just let me try to, my lord, for my satisfaction, my lord will bear me for another 30 seconds, my lord. Now, my lord, now he came in the cross-examination, my lord. It was said that he sold off his properties in Bardhaman and then he came to Kolkata.
No, his requirement is for himself and his daughter.
Daughter, son-in-law, and daughter-in-law. And son-in-law and granddaughter.
So his requirement is also focused on that daughter and you said they have separate premises.
Yes.
How many rooms were under your occupation and their occupation?
4 rooms. I was not given a chance.
No, a plaintiff had otherwise how many rooms in that? Oh,
Only
he's residing there only.
Residing there.
And you are, what is the tenanted premises?
4 rooms. 2 joint tenants, 2 cousin brothers. The entire family is residing there. Milord, I am only on that point, Milord, that my commission to their premises ought to have been allowed. Milord, if my lord kindly takes up my grounds once, Milord, I am just pressing. My lord, I am just pressing. If my lord kindly takes up my memo of appeal. My lord, round number 6. 7. 8, 9. And my lord, 10. Milord, that commission was not allowed, Milord, and I came up with and they did not even come up with the statement that the daughter has, and daughter has purchased those 2 premises in 2011, the 2 flats.
Let us see how the appeal court dealt with this.
Appeal court, my lord, I will first place, my lord, the trial court's judgment.
This, the plaintiff is, his wife is alive also. So he and his wife
Are the plaintiffs.
Both of them are the plaintiffs.
Because this is a property purchased by them.
So in any event, even without the daughter, they would require 4 rooms. I mean, husband, wife, bedroom 1, 3 other rooms.
My lord, officer, my lord, I cannot go beyond what is legitimate. But my lord, I am saying if I could have been given a chance, a more better opportunity to fight on the same plane, if I would have given an opportunity of taking my application, allowing my application on order 39 rule 7. And my lord, the Benamdar factor is also there because my lord, very peculiar circumstances.
Who was a Benamdar of whom?
My lord, the father, the daughter,
plaintiff,
only daughter.
Plaintiff purchased in the, what proof did you?
My lord, Bardhaman property was sold off by him.
So?
Tall order, my lord. Tall order, my lord, but I'm trying to climb it very.
Yes. The defendants in a suit for eviction under the West Bengal Premises Tenancy Act 1997 have preferred the present second appeal against a judgment of affirmance whereby both the courts below granted eviction on the ground of reasonable requirement of the plaintiff stroke respondents. For the next para, learned senior counsel appearing for the appellants argues that the appellants had applied for a local inspection of the 2 houses owned purportedly by the daughter of the plaintiffs, which was refused. It is submitted that since the requirement projected by the plaintiffs is also for the said daughter, her husband and son, the alternative accommodation of the daughter also ought to have been inspected. Next para, secondly, it is contended that the appellants furnished evidence during pendency of the suit regarding the alternative accommodation of the daughter, which was suppressed by the plaintiffs, and as such, the plaintiffs are not entitled to any relief in law or equity. Next para, thirdly, it is argued that the plaintiffs have admittedly sold a Bardhaman property of theirs, which gives rise to the presumption that the properties of the daughter were purchased in the benami of the daughter by the plaintiffs. For some next para, however, we find from the records that that both the courts below have concurrently found that there was sufficient requirement of the plaintiffs for the suit premises. For sub next para, the suit property comprises of about 4 rooms, comma, which would, comma, in any event, comma, be required by the plaintiffs themselves, comma, even without the daughter and her family coming to stay with the plaintiffs. First of that apart, comma, the plaintiffs are at present residing with their daughter despite owning the suit property, comma, which itself is sufficient ground uh, within the contemplation of reasonable requirement under the 1997 Act. Full stop. Next para. As to the question of Benami is concerned, comma, the sale of the Bardwan property of the plaintiffs is too remote a connection to automatically give rise to the presumption that the daughter's properties were purchased by the plaintiffs in the Benami of the daughter. Full stop. Next para. Also, comma, we do not find any relevance of inspection to show the accommodation in the premises owned by the daughter in her name, comma, since the same cannot come within the ambit of within double inverted alternative accommodation double inverted clause of the plaintiffs stroke respondents themselves. For sub next para, hence, comma, we do not find any substantial question of law involved sufficient to entertain the second appeal against in the teeth of the concurrent finding of facts of the courts below. Full stop. Accordingly, SAT 160 of 2024 is dismissed under order 41 rule 11 of the Code of Civil Procedure. Full stop. Can 1 of 2024 stands dismissed as well accordingly. No address to cause.
That property is not only daughter's property, daughter and son-in-law, both joint. They did, they have.
My lord, we cannot go to Supreme Court without even.
Enough.
He is recording it. I, at the very onset, my lord, I narrated the facts, my lord, because I did not want my lord to go through all those.
Thank you.
documents. I'm
Thank
great.
you.
Good. And once again, apologies, my lord.
Accepted it once again. Yes, Mr. Mukherjee. You're appearing or just smiling? I mean, just like that. For the next matter, maybe.
My lordship, Supratim Dhar, Mr. Leonard.
No, you are for the respondent. That's why smiling. Yes. Yes.
Lordship,
What does Supratim Dhar has to say?
My lordship, he instructed me to appear in this matter. My lordship, we are for the petitioner in this matter.
How long are you practicing?
In first year.
First year, yes. You continue.
2 months.
You have?
2 months.
Good enough. Yes. Carry on.
My lordship, this is a suit for partition matter.
The appeal has been. What have you challenged here?
My lordship, we have challenged the trial court has directed us to maintain status quo.
All right.
In the order dated, which appears in page number.
What is the suit for? Can you tell? What is your name, please? Your name?
My name is Gaurav Sarkar.
Sarkar.
Yes.
Yes, Mr. Sarkar. What is the suit for?
Suit for partition, my lordship.
Oh, you said suit for partition. In that injunction has been granted. Status quo has been granted. So, what is your ground of challenge? Should be maintained status quo? Shouldn't it be?
Should be maintained, but we were defended in that case with the trial court before the trial court.
What is the ground of challenge? Why should you set it aside? Mr. Mukherjee's name won't be recorded. You are not recording this matter.
My lordship, kindly come to.
Who is the junior most among you? All of you are appearing. All 4 of you.
I am appearing.
You are not the junior most.
No, I am appearing on behalf of the plaintiffs. My Mr. Mukherjee is appearing on behalf of.
Oh, then you cannot be dispensed with. You are the only advocate. Yes. Please come to the grounds. Yes.
Lordship, come to page number 24 of the stay application.
Yes, 24.
Yes, ground number 8. The plaintiff has prima facie failed to prove that the suit schedule property is joint property and injuncting the applicant says defendant number 1 from exercising his right over the suit schedule property is not sustainable in the eye of law, as the said order will prejudice the substantive right of the applicant and the defendant number 1. Number 9, the civil judge senior division Bakura has failed to exercise the jurisdictions who vested on him for not tuomoto appointing the advocate commissioner in order to ascertain the nature and character of the suit schedule property prior to directing the parties to the suit property to maintain status quo in respect of the nature, character and possession in the suit property in the disposal of the suit.
No, Mr. Shorkar, we are not admitting the appeal. We are giving our reasons. Mr. Shorkar, Mr. Dhar is also there in this matter.
Yes,
He is also to appear in the matter. Mr. Shorkar, comma, appearing for the appellant, comma, led by his senior, Mr. Dhar, comma, argues that the learned trial judge erred in law and in fact in granting an order of in passing an order of status quo, comma, thereby restraining the defendants stroke appellants from changing the nature and character as well as possession of the property. Push up next para. However, comma, we find from the impugned order that sufficient reasons have been attributed by the learned trial judge for granting status quo order. Push up, moreover, comma, since the suit is one for partition
I'm sorry to butt, my lord. I'm for the appellant, my lord.
and it is required that the properties it is required that the nature and character of the properties ought to be maintained in status quo established during pendency of the suit, comma, we do not find any illegality in the impugned order. Full stop. Accordingly, FMAT 25 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2024 is also dismissed without an order as to cost.
My lord, may I? And I'm sorry.
Over.
My lord, the entire property has been sold.
Maybe.
The entire property has been sold.
One of which, my lord, we have
Those
already.
deeds are not under challenge. My lord, kindly, kindly hear me, my lord.
They are making
My lord,
construction.
kindly hear me, my lord.
And my lord, in a
We have heard the matter. Next matter.
The entire property has been sold, my lord. The plaintiff has sold the entire property.
Yes. Yes. Who is appearing in item number 22? Yes. Yes.
Lord, in this matter, I am led by Mr. Surajit Nath Mitram, Lord. Lord, he is indisposed, Lord, today, Lord.
Yes, Mr. Mukherjee, what should you do?
So, Lord, actually, Lord, this matter was heard by another bench, Lord, and almost for 5 or 6 days, Lord.
So it should go before that bench. Substantially heard means.
No, Lord.
It was
Let
not
it be taken up by this bench, Lord.
Substantially heard means.
No, Lord. We will let this matter be taken up here, Lord, but only not today, Lord.
On the prayer of the appellants, the matter is adjourned till February 10, 2025.
I'm grateful, Lord.
Your Lordship, this is my appeal.
What is the defect? Preamble is bereft of the name of learned judge. Delay of 28 days, you have filed a section 5.
Yes, sir.
And you insert the name of the learned judge, trial judge also during the. Can you do it during the course of the day? We'll give you that leave.
Yes, sir.
Would you get the name of the judge? Ask your counterpart in the court, will give it.
Your Lordship, I'm being led by Mr. Datta. I'll ask my learned advocate on record.
Well, we'll give you that leave.
Have it corrected.
First, the section 5 application. Acha, acta line record kono. Leave is granted. The learned advocate on record for the appellant shall rectify the preamble of the memorandum of appeal by tomorrow, comma, inserting the name of the learned trial judge. Push up. Now the section 5 application first. What is the delay? You are appealing for the other side.
Affidavit on service, Your Lordship had directed on the last.
What is the span of delay?
28 days, Your Lordship.
You are appealing for both the respondents. Are you appealing for both the respondents? One.
Respondent number 2. One is the bank.
You have served one.
Your Lordship, I have served both. Your Lordship, paragraph
There was
1
a
and paragraph 2.
caveat lodged by some of them. Oh, R2 year. No, this is a service only on R2.
No, Your Lordship will find.
Oh,
Paragraph 1
The bank has also received, right?
and paragraph.
Yes, both have
Okay.
received. The delay is of how many days you said?
Your Lordship, 28 days.
What is the reason?
Your Lordship will kindly find paragraph 7 to 14 of my application.
Anyway, we are condoning the delay. Upon hearing learned counsel for the parties, we are satisfied that sufficient cause for the delay in preferring the appeal have been made out. Accordingly, can 1 of 2024 is allowed, thereby condoning the delay in preferring FMAT 466 of 2024. No orders to cost. Now, what is the appeal about?
Your Lordship, I am being led by Mr. Dotto. Kindly.
Yes, Mr. Dotto, come on.
My lord, I am challenging, my lord, an order by which, my lord, a notice for, my lord, holding AGM of a trust has been stayed. Application at the instance of the respondent number 2 in my suit, which is really for declaration that I am the, my lord, elected trustees, valid trustees. Now, in the meantime, what had happened, my lord, the trust did contemplate.
Was the bank involved?
My lord, they had, my lord, issued a notice. Respondent number 2 had issued a notice, my lord, asking the bank not to, my lord, allow operations in the, my lord.
Right,
So
right.
there is a relief query bank also in the suit.
All right.
Now, my lord, what had happened, my lord, before I take your lordship through the papers, my lord, under the trust deed, my lord, it's recorded, my lord, the manner in which, my lord, election has to be done. For quite some time, my lord, elections were not held, my lord, of the, my lord, trustees. So in a,
You said you are the plaintiffs.
I am the plaintiff. So in a, my lord, proceeding under the, my lord, Charitable and Religious Endowments Act, my lord, this honorable court under the, my lord, aegis of a special officer directed election to be held because there were only 6 office bearers then, which was below the minimum under the trust deed.
This is relating to what?
Relating to the same trust. So that has been done. The trust deed contains a provision which says every 2 years extended 1 more year, my lord, within that, my lord, term, the election has to be redone, my lord. Now, my lord, the suit has been filed essentially, my lord, challenging this action of the, my lord, respondent number 2 in trying to intermeddle with the, my lord, affairs of the trust. He has, my lord, tried to, my lord, issue letters to the bank. He has issued letters to the bank so that, my lord, operations of the bank account of the trust, my lord, is stopped. Now, my main principal, my lord, grievance here is that this respondent number 2 has resigned from the office of the trust. My lord, he was the vice chairman once. He has resigned. He has also resigned from being a trustee. I have the, my lord, letters annexed. I have the resolution of the trust annexed. The learned judge, my lord, has on the 151 application filed by the respondent number 2, my lord, allowed stay of operation of the, my lord, notice by which AGM is being conducted, in which one of the agenda was again election. The ground, my lord, which the learned judge takes is that in the plaint, in one paragraph, it has been written that he is still an ordinary trustee. The respondent
You have
number
admitted that he is still in.
in my plaint, there is an averment. According to us, it's a mistake, but I proceed with that mistake for the time being. My lord, even if he wants to participate in the election,
Auditory trustee means?
Ordinary trustee. My lord,
Ordinary.
ordinary.
I said auditory.
No, ordinary.
Ordinary trustee. Right.
So, my lord, I proceed on the, for the time being, I proceed on the premise because it's my plaint case that he is still is an ordinary trustee. At best, my lord, he will get a right to participate in the, my lord, process of election. How can, my lord, in the
But
suit?
if there is an irregularity in the election process, Mr. Dotto,
There is
he
no
has a right.
irregularity in the election process. Kindly, my lord, first takes the plaint, the reliefs in the plaint, and then takes his 151.
They have filed that written statement.
I'm sorry, my lord.
Have they filed the written statement?
Yes, my lord, written statement has
What
been
is their stand there?
My lord, their stand is that they remain as a, my lord, trustee of the, my lord.
And
trust.
what is the relief claimed in the suit? Let us see that.
Kindly comes to page 116, my lord. Plaint starts at 108. Kindly comes to 116. This had got nothing to do with, my lord, the application and the, my lord, interim relief which had been prayed by the respondent number 2.
No, but your relief in the suit is against them from creating an obstruction or hindrance.
In any manner whatsoever in the functioning of the trust by the duly elected office bearers of the trust. Now kindly sees one provision of the trust. Kindly comes to page 65, my lord. The trust deed starts at 58. Kindly comes to page 65, my lord.
Yes.
Clause 5. The chairman, vice chairman, secretary, assistant secretary, and treasurer after their election of appointment as such shall hold office for a term of 2 years. The term or tenure of trusteeship shall not be extended further by more than 1 year at a time, even by the continuing to act as such till the next election or another term of office bearers in their place, notwithstanding the expiry of the period of 2 years term. So this, according to me, my lord, 2 years, at best 1 more extended term if they continue to act. So 2 plus 1, 3. Now this committee was elected, my lord, kindly comes to page 99. The present, my lord, body who is representing the board kindly comes to page 99, the minutes of the general meeting of the trustees. Also kindly marks the name of the trust, my lord, Shahu Samaj Trust, West Bengal. This is also important. I'll tell your lordship why. Minutes of the general meeting of the trustees of Shahu Samaj Trust, West Bengal, held on 10th November 19. My lord, kindly comes to clause 2 at that page, to appoint co-op new trustees in terms of the deed of trust dated so and so. By unanimous resolution of the trustees
So
present.
you are elected as long back as on 10th of November 2019.
So, my lord,
Yes.
and the next, my lord, page 100, chairman, vice chairman, all persons who are the concerned persons, their names are there. Kindly marks, my lord, clause B at page 100. He is plaintiff number 3. Plaintiff number 2.
Right.
And clause C at page 100, he is the plaintiff number 3. So from 10th November 19, if I calculate 2 years term, it takes us
So
to
Rajendra Prasad Shaw is the plaintiff number 2.
plaintiff number Rajendra Prasad Shaw is 3. And if your lordship is looking at clause B, last sentence, President Sri Indradev Gupta was elected vice chairman. Rajendra Prasad Shaw had proposed the name.
Sudhir Gupta proposed, sorry, yes.
So one of them proposes and for appointment of another person. So B and C, my lord, 2 names are appointed. Indradev Gupta, who is P2, and my lord Rajendra Prasad Shaw, who is my lord P3. So their term, my lord, is for 2 years. When, my lord, there was COVID, another they continued to act. So at best, I can go up to, my lord, November 2022. I institute the suit in June 2022, saying that I am an elected office bearer. In the meantime, I cross November 2022. So there is an AGM notice. AGM notice, one of the agenda, kindly sees the AGM notice, my lord. Notice at page double. My lord, this is at page 121. My lord, kindly comes to page 121. 7th September 2024. Notice is hereby given to all members of the trust that an annual general meeting of Shahu Samaj Trust, West Bengal, shall be held on 29 September 2024, Sunday at so-and-so, to consider the following. It should be, my lord, agenda. To consider and pass the account of the trust for the period commencing from so-and-so. My lord, it should be again appoint the trustees, a new trust body for formation in terms of the deed of trust, to form amongst the trustees and appoint from amongst them the following: chairman, 2 vice chairman, 1 secretary, 2 assistant secretary, 1 trustee. 4th entry, my lord, 4th agenda, to demolish the building and to construct a new building at premises number such and such. This is, my lord, a property of the trust. Which trust, my lord? Shahu Samaj Trust, West Bengal, which is created under the 1981 deed, the provision which I drew my lord's attention to at page 65. Now, my lord, kindly takes, my lord, his resignation first. He had, my lord, because one of my grounds in the appeal is that he did not have any locus to, my lord, take out this application. Kindly comes to page 88 first. This is in Hindi, my lord. I'll just read it for your lordship. It's 19 September 2018. Sriman Adhyaksh Mahoday, that is, my lord, addressed to the, my lord, chairman, Shahu Samaj Trust, Kolkata, Paschim Bengal. मैं ठाकुर प्रसाद गुप्ता, पुत्र स्वर्गीय फेकुराम गुप्ता, निवास सो एंड सो, अपने होशो हवास में साहू समाज ट्रस्ट के उपाध्यक्ष पद से त्याग पत्र देता हूँ. उपाध्यक्ष एज इन, माय लॉर्ड, वाइस चेयरमैन. मैं इसके प्राथमिक सदस्यता ट्रस्टी से भी त्याग पत्र देता हूँ.
ठाकुर प्रसाद गुप्ता is
defendant number 2, respondent number 2. My lord, this is addressed, kindly marks the name of the trust, Sriman Adhyaksh Mahoday, Shahu Samaj Trust. There is another trust in the name of Shahu Samaj Trust created by respondent number 2. That was done in the year 2018. The property or the election with which we are concerned is of Shahu Samaj Trust, West Bengal, and not Shahu Samaj Trust per se. kindly takes the, and I will clarify this, that this resignation is pertaining to my trust, which is Shahu Samaj Trust, West Bengal, if Lordship takes page 89. My lord, this is the resolution passed in the meeting of the trustees. This is dated 19 September 18. At the top, my lord will find the date. Aaj dina.
Resignation pertains to Shahu Samaj Trust,
Yes.
which is formed by him.
No.
Not a resignation from your body.
Resignation is from my body.
But it
Not-
does not appear so, because you yourself said Shahu Samaj Trust is different from Shahu Samaj Trust West Bengal.
Correct. Shahu Samaj Trust, West Bengal was formed in 1981.
He writes to the Adhyaksh of Shahu Samaj Trust, tendering his resignation from Shahu Samaj Trust, with which you are not concerned. You are West Bengal.
Because of the, my lord, way the letter has been addressed, an impression is being created that it is Shahu Samaj Trust. I want to demolish that impression from the resolution itself. Kindly permit me.
Your resolution.
Yes, but my lord, he was a signatory to that, and in that was
He writes to his own authority.
He was a signatory there.
Achha, that resolution.
Yes.
Or let us see that.
My lord, kindly comes to page 89, signature.
Yes. Signature barcode will be first.
My lord, page 93.
93, which item?
My lord, item number 28.
28.
He was present in that meeting, and this meeting was of Shahu Samaj Trust, West Bengal. Kindly sees the date also at 93, my lord. At the top, meeting date 19 September 2018.
So
And the
even
stamp at-
irrespective of that previous page, page 89 says where the underlined portion that ठाकुर प्रसाद गुप्ता जी ने आकर साहू समाज ट्रस्ट से उपाध्यक्ष पद एवं ट्रस्टी के सदस्यता से
Absolutely.
त्यागपत्र दिए.
Yes.
So irrespective of that,
Irrespective of that,
त्यागपत्र
I
is
can establish
recorded.
that he had resigned from this trust.
All right.
Now, my lord, kindly comes to page 92. One more sentence. Lordship has already seen that. Just for completion. Third line. ठाकुर प्रसाद गुप्ता जी ने कहा कि उन्होंने त्याग पत्र दे दिया है. ट्रस्ट के द्वारा ठाकुर प्रसाद गुप्ता का साहू समाज ट्रस्ट पश्चिम बंगाल के उपाध्यक्ष पद से एवं ट्रस्टी सदस्यता से त्याग पत्र दिया है.
So accepted. Resignation is accepted.
So this is accepted. So this is the position. Now sees, my lord, his 151 application. Kindly comes to page 122.
First, we'll look into your pleading.
My pleading in the plaint,
that
my lord.
pleading regarding his being.
Yes, my lord. Kindly comes to, my lord, plaint at 108. It starts. I'll show, my lord, two paragraphs.
Present elected chairman and secretary. You have said
It
present.
was, my lord. I understand my difficulty there. That is why I said, my lord.
You cannot go beyond your pleadings.
I can't.
You cannot look into evidence beyond your pleadings.
No, there is another pleading. I want to show you, your lordship, that also. My lord,
That first.
kindly takes, my lord, page 111, para 8.
8, yes.
Subsequently, in the general meeting of the plaintiffs held on 19 September 2018,
Very well. So
Thakur-
this has to be read with that. Very well. Let us see his application.
his application now kindly comes to page 122, my lord. First, I want to show your lordship the prayer at 127.
Yes.
Outside, first is locus, then is this is beyond the, my lord, reliefs in the suit. There's no counterclaim in the suit. My lord, this is, my lord, not maintainable. Now see, my lord, what is the basis if I go into the merits? Kindly comes to page 123, para 6. One trust deed was registered and executed on 25th September 2018 before such and such.
Mr. Dato, wait for a second.
Yes.
Would you like us to dispose of the appeal as well? Because otherwise, if we are satisfied with his prima facie case, and upon hearing you, we'll grant injunction, stay of this order, which means the appeal is virtually decided. So if you agree, we are hearing the appeal now.
The suppression the facts.
Very well.
They
Then we are hearing under order 41 only and connected injunction. Very well. Please take it. Yes, please continue.
My lord, page 123, paragraph 6.
Yes.
One trust deed was registered and executed 25th September 81. This is, my lord, Shahu Samaj Trust, West Bengal, the one which I showed to your lordship. Then, my lord, fourth line, defendant number 2, Thakur Prasad Gupta is one of the settler and founder member of the trust. Defendant number 2 was also appointed as one of the trustees in the aforesaid trust. Trust is known as Shahu Samaj Trust, West Bengal. No dispute here. Next para, it is mentioned herewith that another trust deed was executed on 21st February 2018 before such and such. Well, it kindly turns the page. It is also mentioned herewith that in the deed of trust, defendant number 2, Thakur Prasad Gupta, is one of the settlers and founder of the trust, and he is also one of
Sorry,
the
you are
trustees.
reading which page?
My lord, I just after 123, 124 at the top of that page, my lord. It is also first line, my lord.
Oh, acha, we skipped over. Yes, right.
There's signature, my lord.
Right. No.
It is also mentioned herewith that in this deed of trust, defendant number 2, Thakur Prasad Gupta, is one of the settlers and founder of the trust, and he is also one of the trustees. So, my lord, he resigns from, my lord, Shahu Samaj Trust, West Bengal. He, my lord, forms another trust by this 2018 document, where he is, my lord, one of the settlers as well as one of the trustees. The respondent number 2.
Right.
Then, my lord, if your lordship kindly takes note of the last 2 paragraphs of this page. It is further stated that there are 2 trusts. Naturally, there are 2 separate letterheads. He talks of 2 separate letterheads. Then kindly turns the page at 125. My lord, he admits that the trust property, my lord, first para, after the first 2 lines, it is also mentioned that since the purchase of the trust property situated at so-and-so, by virtue of the trust deed which was executed on 25th February 81, paying property tax to KMC. So, my lord, he admits that the property is also trust property under the 81 trust deed. Then his allegation is, when the defendant number 2 observed the trustees of Shahu Samaj Trust, which was executed on 21st February 2018, with ulterior motive trying to grab an immovable and movable asset of Shahu Samaj Trust, West Bengal, which was executed on 1981. And also when defendant number 2 observed that trustees already changed letterhead from Shahu Samaj Trust to Shahu Samaj Trust, West Bengal, without consent and permission of the trustees. Defendant number 2 then and there with protest tendered his resignation by a letter.
No, but he says the converse. He says Shahu.
Exactly, my lord. I also fail to understand why is this pleading there, because he is telling the converse.
Yes. If Shahu Samaj Trust is trying to grab property of
it would have
West
been
Bengal,
the other way around, my lord. If my lord,
that is their mistake
that
in pleadings.
possible. The next, my lord, allegation 125. When the trustees of Shahu Samaj Trust with ill motive tried to sell and tried to develop the trust property, Shahu Samaj Trust, West Bengal. Where is this case, my lord, in a, my lord, written statement also?
It is not there in the written statement.
But I have not annexed, my lord, I have not annexed the written statement here.
But
But if lordship
he-
wants to see,
he
I will.
says the trustees of Shahu Samaj Trust, which he formed with ill motive, is trying to sell
Which
the
means
property.
he is the settler, he is the trustee,
He is
and
trying to
he is
illegally
trying to, my lord, doing
sell
it.
off your property.
Because we say we are no longer, we are not concerned with Shahu Samaj Trust, which has been formed in 2018. We are only concerned with protection of the property. My lord, I will indicate why, my lord, this is important. My lord, this property has to be, my lord, reconstructed after demolition. We will not deal with the property. It is only for the members of Shahu Samaj. But it is in a dilapidated condition for which the board of trustees, my lord, they will take a decision
No,
in the
Shahu
meeting.
Samaj Trust, West Bengal is the owner of that property.
Yes.
It's admitted.
Yes.
You can deal with your property, and this relief is not sought in connection to the property. How does he connect it to this? No, let us.
The learned judge says that you are trying to deal with the property.
Let us look at the next paragraph also.
Yes, my lord.
7.
Present plaintiff has no right and power to proceed the trust processing under the name Shahu Samaj Trust, West Bengal, inasmuch as they are not trustees, not any holding any post in connection with Shahu Samaj Trust, West Bengal, which was registered in 1981. That is why I showed, my lord, page 65, that provision. And my intent that before expiry of 3 years, I go to the suit court seeking a declaration. Post expiry of 3 years, my lord, we issue that, my lord.
Now you only issue a notice for holding the.
And my lord, whoever is elected, my lord,
done by
as
an
the vote-
AGM.
Yes, it's done by an
So the notice is for holding that AGM.
AGM. An agenda, main 2 agendas,
Election.
one for election, one for, my lord, taking decision. The elected board will take a decision with regard to the property. And, my lord, it's, my lord, the property vests in the, my lord, trustees through, my lord, in the trust through the trustees. Trustees will act in the best interest, my lord, for the best interest of all the trustees. The office bearers will act. Now, my lord, this was the basis of the allegation. I take, my lord, in my written objection. At page 130, my written objection starts.
Yes.
My lord, para 7. First objection I take is, my lord, locus. Because it is no way connected with Shahu Samaj Trust, West Bengal. My suit pertains to something, my lord, Shahu Samaj Trust, West Bengal. He is trying to, my lord, allege that property of Shahu Samaj Trust is being, my lord, dealt with. Then, my lord, kindly takes note of para 11 at page 132. Petitioner state that present plaintiff number 1 is a registered trust created in 81, which is known as Shahu Samaj Trust, West Bengal. Defendant number 2 at present have no connection whatsoever after he submitted his resignation from vice chairmanship as well as from primary membership of the association in 2018. And since then, defendant number 2 has got no connection whatsoever with the plaintiff number 1. And
Let us see the reasoning of the court.
My lord kindly takes the impugned order now. If lordship takes the memo, lordship is looking it from the
Memo.
My lord, I think memo whether lordship's copy has it correctly, my lord, ordered.
Yes. But there is no internal page.
There is no internal page.
Anyway, refer to the first, second, third, fourth page.
My lord, I'll start from the first page, my lord. It is important, my lord, otherwise the chronology would be lost.
Very well.
Peruse the application of defendant number 2 under section 151 of the Code of Civil Procedure filed on so and so with written objection thereto and other materials. Then, my lord, I skip the first last line. The trust is known as Shahu Samaj Trust, West Bengal. Another trust deed was executed on 21st. Then, lordship, there will be a page with February 2018. That should be, in my copy, it's the third page. But that is actually the second page.
Oh.
That's the mistake, my lord, there.
Acha.
So the second page is the third page is the second page.
All right.
I'll just place the third page, which is actually the second page now.
Right.
February 2018. Defendant number 2 is one of the settlers and founder of the said trust, and he is also one of the trustees. The name of the trust is Shahu Samaj Trust. So he talks about his trust. Then, my lord, next paragraph, skipping first 4 lines. When the defendant number 2 noticed that Shahu Samaj Trust was trying to grab the immovable and movable asset of Shahu Samaj Trust, West Bengal, and the trustees changed their letterhead from Shahu Samaj Trust to Shahu Samaj Trust, West Bengal without consent of the trustees, he on protest tendered his resignation from the post of vice chairman of the said trust executed on so and so. Shahu Samaj Trust with ill motive was trying to sell or develop the property of Shahu Samaj Trust, West Bengal. But I am trying to protect my property, the trust property. His allegation is that the other trust created in 18 is trying to deal with the property. And on that basis, my lord,
No, we don't understand the finding in the actual third page. Here, second page.
So as per plain government, kindly takes from there, my lord.
Yes, exactly.
Yes. So this is contrary
to the next para. The next para also.
Yes, I'll just place these 2 paragraphs.
Very
so, as per the plain government, defendant number 2 is still a trustee and a member of Shahu Samaj Trust, West Bengal.
But
This
the
is
previous
only,
paragraph,
he does not take note of para 8. He does not, learned judge does not take note of, my lord, the documents tendering resignation, particularly the minutes, my lord, which has his signature.
And the next paragraph, the plaintiffs have not disputed the genuineness of the notice dated 7/9. You are the
plaintiff. Why would the plaintiff, my lord, dispute the, this is my notice.
And categorically denied that the AGM is going to be held on, you denied. We don't find any denial of yours.
English language, my lord, sometimes, my lord, the way it's reproduced, my lord, it's really not making sense here. But what possibly the learned judge wanted to say was that I have not denied issuing the notice. I have not. I am actually wanting the AGM to happen. And why should I, my lord, deny my own notice?
Let us hear.
The next para also is important. Rights of the parties are to be determined in trial on evidence if the trust property is demolished. Pending determination of the rights of the parties and defendant number 2 succeeds to establish his right in trial, it would be a great difficulty for him to restore the original state of affairs. And on this basis, my lord, the notice has been stayed. 19th September, last page, my lord, kindly takes now.
Yes. Let us hear your other side.
Very well, madam.
Yes, sir. What is your contention? You have asked for a stay of this.
I have asked for a stay of operation of this order.
Yes.
May I have 5 minutes, my lord, leave from your lordship.
There are 2 trusts. One registered in the year 1981.
Right.
Another registered was 280. The defendant number 2 is the founder member and scheduler of the trust executed on 1981. and another trust which was executed 280. At that material time, the defendant number 2 was also settled and founded. Two parallel 2018, there are no any property. Only 20,000 allotted for expenses. 1981, they purchased the property after execution, the trustee. At that material time, the present plaintiffs are not there. Trust, founder member and others, at that material time, there was 28 members. And their membership is like
This is the 81 trust.
81 trust.
You are one of them.
And I'm doing. With line.
তাহলে ফার্স্ট দিক থেকে রাখা ফার্স্ট দিক শুরু হয়েছে
Page 62. Para 3. All the 31 trustees will be ordinarily trustee for lifetime. Para 3. 1, 2, 3, 4.
Yes, we have seen.
6th line.
Right, right. Yes.
And this trust is going on. Till the plaintiff was the trustee under 218.
2018 or 19? 2019.
Another
because
trust.
that document shows 2019. That minutes of
I'm showing this.
page 99. Page 99 is the minutes of the general meeting of the trustees of South Samaj. Oh, the trust was formed in 2018.
Yes.
And this page 99 is probably the agenda of the election. All right, we get your point.
Yeah, I'm sorry.
But you have admitted in your application that the property belongs to West Bengal.
I am the chairman of the Sahu Samaj Trust West Bengal. There are two trusts.
But your resignation prima facie proof has been shown. That minutes your signature.
Trust, not West Bengal.
West Bengal. They come to that Hindi.
I tendered my resignation from the post of vice chairman, not for the trustee.
No. Mr. Dotto, please come to page 89. 89 is the minutes of the West Bengal, this trust. Page 88 is addressed to 81 trust. Page 88 is in respect of the other 81 trust. We agree. But page 99 is the minutes of this West Bengal trust. So there, the underlined paragraph, fourth or fifth paragraph, that says Thakur Prasad Gupta ji ne, page 89, I'm sorry. ठाकुर प्रसाद गुप्ता जी ने आकर साहू समाज ट्रस्ट के उपाध्यक्ष पद एवं ट्रस्टी की सदस्यता से त्यागपत्र दिए। उन्होंने स्वयं त्यागपत्र लिखा एवं अध्यक्ष को दिया एवं कई उपस्थित ट्रस्टियों ने भी विटनेस के रूप में दस्तखत किए। Not only this,
Their resolution, mine.
Their resolution, but your signature at page 93.
No, I deny at mine.
But there is prima facie proof that there is, and what about this? Because you have sought for stay of a notice, right? That notice has two agendas. One is election. You have not even leveled any allegation regarding their election. So there cannot be any stay on that part.
They have no right to issue this notice as they are the member of the Sahu Samaj Trust. not South Samaj Trust West Bengal. I am the chairman till date.
They are also members of this House of.
They are the member of the South Samaj Trust, not West Bengal, my lord. They are misleading this court. And as such, the trial court, rightly without proper adjudication,
Has anything been annexed regarding the Sahu Samaj West Bengal Trust West Bengal that trust deed? Is there anything to show that they are trustees of this which page?
My lord, apart from the trust deed and the minutes I showed, kindly see page 83, my lord. Pursuant to the order of the High Court, which I was referring to, election conducted by the special officer, where my learned friend's client was also there. Kindly takes page 83. Last name, my lord, 16. That is respondent number 2.
Yes.
And this was, my lord, in this election, my lord, my learned friend, my lord, lost. Kindly comes to page 87.
at that material time, my lord.
Page
the
86,
second-
87.
Yes, sin.
Second task was not executed. Well, this is the second task. Kindly. This is the second trust. They have suppressed all along. And
But
my-
they have participated in the minutes in the elections. They have participated in everything of the West Bengal chapter. Here also, I mean, if you come to this, the minutes of page 99, that's the minutes of the South Samaj Trust West Bengal.
Is their regulation.
Their resolution you are saying every time, and you are saying they are not they. Every time you are referring to the resolutions, you are saying it's their resolution, and you are saying they are not a member of they.
I am the member, founder member.
You may be a founder member, but they are also members of trustees of that, the portfolio holders of West Bengal Trust. That is there. I mean, in the minutes everywhere. There is not a single allegation of any irregularity regarding the election notice in your application.
I see my application.
Yes, yes, yes.
22.
Yes.
Page 120.
One, we are there. Yes.
What was my allegation?
Suit is by West Bengal Trust, release sought by West Bengal Trust regarding their property, and you have admitted at page 124 in your application that the property, that's how much is a different trust.
Prayer of the plain. Prayer of the
Yes, yes. Prayer of the plaintiff. That their election is legal valid.
declaration that the present executive committee of the said trust duly elected in the election held at the annual general meeting of the said trust on 10th of November 2019 is legal, valid and operative. It is their prayer.
Have you filed any suit or counterclaim challenging their election of 2019?
Written objection, written statement.
But in the absence of, since 2019, they are there. You have not challenged till now. So, as of today, that remains unless that is set aside by a valid court in a suit or a counterclaim. So, they are till date the valid elected members, unless you have a declaration that that's invalid. So, as of today, whatever you may be, we are not on your locus standi so much. It's debatable whether you gave your resignation or not, but they are members. They have asked for an AGM for an election. What? There is no allegation against any irregularity.
They are the
This stay order is bad in law. We cannot.
If they able to demolish the property, my lord.
Is property of the West Bengal Trust.
They are not the member of the West Bengal Trust. What they prove?
They have produced sufficient evidence to show.
It is their regulation.
Then why didn't you seek for an injunction regarding the properties of the trust?
Property.
That entire agenda, yes.
If they able to hold election, they sold out the property.
That's a presumption which you cannot. That's an apprehension which is in future, and there is no basis for that apprehension. Whatever they may do, they may do. They are operating since 2019. Today we are in 2025. For 6 years they are there. Now they are wanting to hold an election.
Samaj Trust has no property, my lord.
Exactly. And the suit is regarding South Samaj Trust, West Bengal.
West Bengal has property.
The suit is by South Samaj Trust, West Bengal.
Yeah.
You see, the suit is for protecting the property of South Samaj Trust. Yes, demolition has been sought in that issuance of meeting, but in this suit, they are espousing the cause of.
Not to develop.
Have you asked for that injunction? That is precisely what we are saying. That if you ask for that injunction, we could not understood. You have not asked for, prayed for that even. You ask for stay of operation of that AGM meeting notice. And that is premature regarding demolition. They will take a demolition decision in the meeting. So this is premature to stay that notice. That's an agenda, sir. An agenda need not be carried out. That may be opposed by their members also. You may oppose if you are a member.
Parallel trust is going on.
Yes, yes.
Two parallel trust.
Maybe, but we don't find any reason for staying operation of that agenda, of that notice of meeting. So we'll stay operation of this order till disposal of the appeal, and we file it opposition, and because you did not agree to the disposal of the appeal. So we are admitting the appeal, we are granting stay till disposal of the appeal. Stay of operation of the stay.
Till date, this. Now,
What?
till date, restraint not to hold any.
No, we will not do that. We will not do that because you have not asked for that. An arguable, আচ্ছা বাকিটা আগে দিয়েছিলাম হ্যাঁ ওটার সঙ্গে কন্টিনিউ yes an arguable case has been made out in the present appeal. Push up next para. The brief facts of the case, comma, as evident upon hearing learned counsel for both the an arguable case is made out in the appeal. Push up accordingly, the appeal is admitted to be heard on the grounds as taken in the memorandum of appeal. Push up next para. The injunction application is now taken up for hearing. Push up. Upon hearing learned counsel for the parties, comma, the brief factual conspectus appears to be that the plaintiff stroke appellants have filed a suit inter alia for declaration that the present executive committee of the said trust, within bracket including the plaintiffs stroke appellants, in the election held at the AGM of the said trust on 10th November 2019 is legal, comma, valid and operative, comma, for permanent injunction, restraining the defendant number 2 stroke respondent number 2 from creating any obstruction, hindrance, etc. in the smooth functioning of the trust and operating its bank account, and for other consequential reliefs. Push up, in connection with the said suit, comma, the present respondent number 2 within bracket defendant number 2 in the suit bracket closed filed an application under section 151 of the Code of Civil Procedure seeking the stay of operation of a notice dated September 7, 2024 issued on behalf of the Sahu Samaj Trust, comma, West Bengal, comma, which is the plaintiff number 1 in the suit. Full stop next para. The moot contention of the defendant stroke respondent number 2 is that the defendant number 2 is a member and founder trustee of the Sahu Samaj Trust, comma, which was formed in the year 1981. Pushed up, the Sahu Samaj Trust, comma, West Bengal has been formed subsequently in the year 2018 and has been operating parallelly with the other trust named above. Pushed up next para. The defendant stroke respondent number 2 claims also to be a trustee and a portfolio holder in the Sahu Samaj Trust, comma, West Bengal. Push up next para. By the notice, comma, which is challenged in the application under section 151 of the code, comma, an annual general meeting was called on September 29, 2024 with primarily 2 agenda. Hyphen first, comma, holding an election of the said trust and demolition of a particular building and construction of a new building at the premises named therein. Push up next para. it is contended by learned counsel for the respondent number 2 that the plaintiffs have no locus standi to espouse the cause of the Sahu Samaj Trust West Bengal, since they are not members of the said trust at all. Push-up, it is submitted that in the garb of the said notice, the property of the Sahu Samaj Trust, West Bengal, of which the defendant number 2 is also a member, is being sought to be demolished. Push-up, next para. On the contrary, the appellant contends by placing reliance on the documents annexed to the stay application that the respondent number 2 tendered his resignation not only from his portfolio held with the Sahu Samaj Trust West Bengal, but also as an ordinary member trustee of the said trust. Stop. Learned counsel for the appellant places reliance on a meeting dated September 19, 2018 of the West Bengal Trust, which is annexed at page 89 of the present application of the stay application, as well as a notice of resignation issued purportedly by the respondent number 2 on September 19, 2018, annexed at page 88 of the stay application. Push up next para, it is further submitted that apart from the respondent number 2 having no locus standi, in the absence of any allegation regarding any irregularity of the irregularity in issuance of the impugned notice, the prayer sought in the section 151 application could not have been granted, more so since it is beyond the scope of the suit itself. Full stop. Learned counsel for the appellant takes us through the averments made in the application under section 151, where it has virtually been admitted that the property in dispute belongs to the Sahu Samaj Trust West Bengal, which is the plaintiff stroke appellant number 1, as well as represented by the other plaintiff stroke appellants. Full stop. Hence, it is submitted that the impugned order ought to be set aside. Full stop. Next para. We find prima facie that a strong case for hearing of the appeal on merits has been made out. First, although there may be some doubt as to whether the notice of resignation dated September 19, 2018 was in respect of the West Bengal Trust, being addressed to the chairman of the Sahu Samaj Trust Simpliciter, there is prima facie evidence to show that from the minutes dated September 19, 2018, the respondent number 2 had tendered his resignation, more so since his signature also appears as item number 28 of the said minutes, although such signature is disputed by learned counsel for the respondent number 2. Pushed up next para, that apart, we find from the annexure at page 99 of the stay application that the present functionaries, who are also plaintiffs, were elected as portfolio holders in the Sahu Samaj Trust West Bengal, that is plaintiff number 1. Pushed up next para, that apart, in the application under section 151 filed by the respondent number 2 himself, it has been admitted that the trustees of the Sahu Samaj Trust is trying to sell, with ill motive, and to develop the trust property of the Sahu Samaj Trust West Bengal, which is the plaintiff number 1 in the suit. Hence, since the plaintiffs espouse the cause of the Sahu Samaj Trust West Bengal in the plaint and have furnished sufficient prima facie material to vindicate their stand as portfolio holders and trustees having locus standi to file the suit in respect of the West Bengal Trust, the respondent number 2 has clearly admitted that the Sahu Samaj Trust does not have any interest or title to the property in question. Next para, that apart, no specific illegality in issuance of the impugned notice dated September 7, 2024 having been made out in the application under section 151, we do not find any reason for the learned trial judge having granted a blanket stay of operation of the said notice, full stop. Moreover, comma, the other component of the said notice, that is demolition of the building in question, comma, is merely a part of the agenda of the said notice, and it would be premature at this stage to stay the notice itself before any decision is taken in the AGM, which would actually be held on the said agenda as well. Full stop. Hence, comma, apart from being premature, comma, the impugned order suffers from the fact that the the prayers made in the application under section 151 of the Code of Civil Procedure are somewhat beyond the purview of the suit itself. Full stop. In such view of the matter, we find strong prima facie case for a stay order having been made out by the appellants. Full stop. Accordingly, the operation of the impugned order bearing order number 29 dated September 27, 2024, passed by the learned judge, 9th bench City Civil Court at Calcutta, in title suit number 1209 of 2022 till disposal of the appeal. Full stop. Next para. Would you like to file any opposition to this application? Till disposal of the application. Full stop. The respondents shall file their affidavits in opposition within 3 weeks. Within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing next on March 17, 2025.
Wait for my.
প্রথমেই affidavit of service filed today. Thank you. Yes.
May I please, Your Lordship?
Yes, please.
I appear, my lord, for the defendant appellants, my lord. In
Right.
peculiar state of circumstances, my lord, I have to file this appeal. Normally, my lord, we do not file an appeal when an injunction is passed ex parte and been served upon the defendants. We go and file an application for vacating. But, my lord, in this case, my lord, I was constrained. Why I tell your lordship, before, my lord, coming to the order impugned under challenge, my lord, I was in possession of the suit property till 23rd December, 12 o'clock. Or what they do, on 20th December, they file a suit. Now I have come to learn after taking the certified copy of the entire order sheet. They file the suit. On 23rd December, they take an order of injunction from the City Civil Court. They break open my iron gate. They install their iron gate. And thereafter informs the police. And I'll show your lordship, no documents of possession. They say, my mother, our mother, not my, our mother, has surrendered her possession. Very well. In 2018. No document of surrender. Lordship knows better than me. If I had surrendered my tenancy, there must be a document where I will say, yes, I have surrendered. And that is a very important document for showing that the plaintiffs are in possession. They have stated that neither they have annexed it in the plaint.
The plaintiffs are the landlords.
They are the owner of the property, admittedly. I'm not on that. I'm not questioning their ownership right, my lord.
So they have filed the suit for what? Declaring what?
For declaration that they are in possession and injunction against me that I am trying to grab the suit property.
In that plaint, they say they have said that the surrender has also been said.
They have stated that,
Your
but
mother surrendered.
yes, my lord. They have annexed title deed. They have annexed. I am not
As
on
per
that.
them, when did your mother surrender? As per their.
As per them, they are saying that in 2021, by signing a rent receipt where I have given rent till September 2018. But that is also, my lord, there is no signature on that counterfoil. No signature of mine, nothing. A blank counterfoil. That is what they have produced. No document of surrender of possession. They say, even they do not say that they crave leave. Lordship will kindly come to the order impugned first.
Yes.
It is dated 23rd December, my lord. First, my lord, 20th December 2024, they filed this suit before the City Civil Court,
Right,
second bench.
Status quo has been granted.
Status quo, because they have taken the possession forcefully. Status quo is sufficient for them. And now, my lord, I'll show prima facie, my lord. On 17 December also, I have, my lord, shifted certain goods, my lord. We are into this MS5 business in that go down. With proper GST, I have documents with proper GST payment.
But wouldn't this be a proper case for vacating under Order 13 Rule 4? Because
I tell you, Lordship, my lord.
Because then the court has to proceed on the premise of injunction application.
Lordship will kindly, my lord, appreciate my predicament, why I have come. I have been told by my learned junior, my lord, the second bench is not there anymore. That bench is lying vacant. Now, Lordship knows this injunction will continue for ages. Whatever I do. My lord, I can understand, my lord. Of course, if you even your lordship, my lord, stays this order, I will not able to go into possession because I cannot break that there is an order of status.
And status quo generally
they are
don't
in
stay
possession.
at this stage.
Why I have come before your lordship?
You may have a very strong case in the appeal. We appreciate that. But the difficulty is we have to proceed on the premise as the trial court did on the basis of the injunction application and the plaintiff as sacrosanct at this stage.
Lordship.
Unless you bring in those materials.
Lordship.
And show the court that you are in possession, PVC pipe and all.
So far as my materials are concerned, my lord, I have annexed those. Even I have annexed the plaint and injunction.
Probably cannot look into your. I mean, we can.
I can understand, my lord. If
but as per their annexure shows that they could not get an injunction on
my
their.
Lord, because lordship knows the doctrine, my lord, set by Supreme Court: no possession, no injunction. Prima facie, I have to show the code that I am in possession. Now, if your lordship kindly takes the plain first, page 17.
Now, have they annexed any document?
The documents they have annexed. What documents I'll show you, lordship.
Show the documents first, yes.
Lordship. My lord, first, my lord, if your lordship kindly, my lord, come to my lord, page 17 once. And now, my lord, the plain starts from there. Paragraph 4 and 5. This is, my lord, these are two paragraphs. These are their cases standing on these two paragraphs, 4 and 5. In the month of November 2021, they said Vidya Devi Jaiswal.
Paragraph 4 and 5 of which page?
Plain, page 18. Running page 18, internal page 2 of the plain.
Yes, 4 and 5.
In the month of November 2021, they said Vidya Devi Jaiswal has delivered peaceful, vacant and khas possession in respect of the suit premises to the plaintiffs by surrendering her tenancy on and from November 2021. The plaintiffs are in exclusive possession in respect thereof the suit premises. Lordship kindly marks, it's such an important document, even not disclosed with the plaint also. Lordship knows in the plain, we need to give a schedule of the documents we are relying. No schedule is there. I have taken the certified copy of the entire plain. Now, the very next paragraph is more interesting. On 30th October 2021, they said Vidya Devi Jaiswal had requested to relinquish the monthly rent on and from January 2019 till the date of October 2020. Well, I'll pause here for a moment. Rent is only rupees 400. For surrendering her tenancy by delivering peaceful, vacant and khas possession. And accordingly, the plaintiffs had relinquished the monthly rent from January 19 till October 2021 upon tasking delivery of possession of the said Srimati Vidya Devi Jaiswal and paid rent up to December 2018 on 30th October 2021. I've read this paragraph several times, my lord. The plaintiffs crave leave. Now, this document, my lord, they have annexed. If your lordship kindly comes, page 66. The counterpart. Well, it's an unsigned document. And the learned court grants injunction only on the basis of this document. Electricity bill, forget because the learned court.
No, but what is the significance of this? This does not say that it has been surrendered.
Doesn't say.
So, what was the significance of this?
I do not understand, my lord. And not signed. Well, lordship knows counterpart has to be signed by the
cannot
tenant.
be relevant.
This is very basic.
Yes.
And now,
no surrender letter or something like that?
Nothing. Lordship will kindly take up their injunction application now. I've also annexed that. I've taken certified copy of this, page 25. Again, the same paragraph. This is a repetition of the paragraph. Now, in the injunction, lordship knows they have to, my lord, annex the documents. Again, exclusive. The surrender letter. There is no, I haven't surrendered. This is a absolutely false story. And now, my lordship knows the basic ingredients of getting injunction on possession. I have to show possession.
Evidence Act. Okay.
And another interesting document, my lord, I am been surprised, my lord.
Yes.
The complaint to the police. Lordship will kindly see this document once. Page 69. It's in their advocate's letterhead and signed by the plaintiff themselves. Page 69, my lord. Lordship will kindly come.
Yes.
Manomendra Saharai is their learned advocate, I find.
Yes.
Very well. And an advocate can write a letter.
Yes.
Now, if your lordship kindly turns to the next page. It is been signed by Santosh Kumar Sai. He is one of the plaintiffs. I don't need to, my lord, I think, elaborate, my lord. And
we'll admit the appeal, but not grant any stay at this stage.
I understand.
Direct the appeal and the application to be heard together. We'll direct you to serve copies of memo as well as the...
Only thing, my lord, I am stuck in between the devil and the deep sea. My lord, on 25th December, when I came to learn about this, immediately I filed a detailed police complaint. Lordship will kindly come to that at page 14. Now, my lord, I have been told, the learned advocate, my lord, who is doing the criminal practice, that since there is an order of status quo on the basis of this complaint cannot move an application for inquiry under order under 156 clause 3 since the status quo. Malad, one single observation, if you kindly falls from your lordship, that this order in any way will not, my lord, prevent me from exercising my rights available to me in civil and in criminal. Thereafter, then I can, my lord, at least, my lord, try that, my lord. Because this needs an investigation, my lord. Thorough investigation is required. Lordship will admit the appeal, I'll serve them.
The defendants in a suit for what is the plaint, the schedule, the release of the plaint? Yes, I've got it.
Plaint starts. Has the lordship got it?
Yes. Right.
And my lord, one more thing: 3-4 lakhs of amount of goods are still stuck there, my lord. I don't know whether they have removed it.
Status quo, I mean, is there? কি বললাম? The defendants in a suit for declaration that the plaintiff's respondents are in exclusive possession of the suit premises and for permanent injunction restraining the defendants stroke appellants from disturbing such possession have preferred the present appeal against an ad interim order of status quo. Whose next para, learned counsel for the appellants argues that taking undue advantage of the impugned status quo order, comma, the respondents have ousted the plaintiff defendants illegally from the suit premises and have taken possession immediately after obtaining such status quo order. For next para, learned counsel argues that it will be evident from the documents annexed to the present application for stay as well as in custody of the appellants that the appellants have been in possession all along till the date of passing of the status quo order. Full stop. Next para. It is further submitted that the appellants, comma, as plaintiffs, comma, obtained the order of injunction on the strength of an averment that the original tenant, comma, predecessor in interest of the present appellants, comma, had surrendered the suit premises in favor of the
Well,
plaintiff.
she is still alive. Our mother. Vidya Devi
predecessor
Jaiswal is our
interest
mother.
তাহলে predecessor interest কে কেটে দাও।
She's 76 years old. That is why, my lord, we are taking care of her business.
So
We are her son.
she is the tenant.
He is the tenant. And she has not been made a party in this case.
That the কি বললাম?
It is further submitted that the appellants as plaintiffs obtained an order
On the strength of তারপর বলুন।
on strength of an averment that the original tenant of the present appellants
That the original tenant, that the tenant, comma, being the mother of the present appellants, comma, had surrendered the suit property in favor of the plaintiff's respondents. Full stop. Next para. However, comma, not only has no such document showing surrender been produced in the court below, comma, the documents which have been relied on in the plaint have also not been annexed to the plaint. Full stop. Next para. Upon a perusal of the documents annexed to the stay application in connection with the present appeal, comma, we find that that prima facie a strong case has been made out for hearing of the present appeal on merits, comma, since it is not evident from the documents annexed to the injunction application of the plaintiffs that the surrender of tenancy by the tenant, that is the mother of the appellants, has been proved even prima facie. Full stop. Insofar as a purported counterfoil of rent receipt is concerned, comma, the same is unsigned and does not prove anything regarding surrender. Full stop. Also, comma, a complaint lodged with the officer in charge of the local police station stands in the letterhead of the learned advocate of the respondents, but signed by one of the respondents, comma, which also raises a doubt as to the veracity of the same. Pushed up. Next para. It is well settled that both under section 114 within bracket illustration small d as well as section 116 of the Indian Evidence Act, now the BSA is applicable. Anyway, of the Evidence Act, comma, a person alleging a state of affairs which is deemed to continue under normal circumstances, as well as the severance of a tenant of a landlord-tenant relationship, is cast with the burden of proof of such severance or alteration of such circumstance, full stop, we prima facie find that in the absence of any such burden being discharged by the plaintiff respondents, comma, the impugned order of status quo is bad in law. Full stop. Next para. However, comma, granting an order of stay of operation of the status quo at this juncture would not automatically revert the defendants back to possession, and as such we desist from doing so. Full stop. Next para. However, comma, it is made clear that the impugned status quo order shall not in any way prevent the defendants appellants from taking recourse to any legal remedy available to them under the civil or the criminal law in any manner whatsoever.
I bow down.
Full stop. Next para. In view of the short conspectus of the appeal, comma, we are of the opinion that the trial court records need not be called for, comma, nor are paper books required to be prepared for hearing of the appeal. Full stop. The appeal shall be heard along with the present stay application. Full stop. The appellants shall serve copies of the stay application along with the memorandum of appeal on the respondents, indicating that the appeal shall be listed for hearing in the monthly list of March 2025, along with the application. Full stop. An affidavit of service to that effect shall be filed on the returnable date.
My lord, it will appear in the list. Lordship will
March.
have the liberty to mention, Lordship knows my possession is gone, man.
আচ্ছা তাহলে
My
in the
books
monthly
are
list
stuck there.
monthly list of March না করে ওটা করে দিন returnable on February 26, 2025.
27th, my lord. 27, my lord.
27.
26, perhaps I will not come to court.
February 27, 2025. Monthly list of
extremely
March না
grateful
করে
to you,
27th February 2020. Thank you.
I'm grateful to you, Lord.
Thanks.
My lordship has directed me to serve the stay and the memo upon my lord. All the
Yes,
response.
yes.
I shall.
It would be better if you serve a server copy of this order so that they know that the appeal
I'll
will be
do
heard.
that, my lord. I'll serve
That
the
will be
server.
best.
My lord, I shall do that. I'm extremely grateful to
Thank you. Yes.
Lord, may I please, Your Honor?
Mr. Bonik, what is the defect?
Yes, defect is my lord, the name of the learned judge is not, my lord, written. Refit of the name of the learned.
Only that?
the
I will
officer.
just check. Yes, only that. So do you know the name now?
Yes, yes,
So Adhikari knows the name?
they are aware.
Yes, very.
Now, my
Well,
lord, the defendant number 1 is the appellant before your lordship is assailing the order of order whereby my application.
before you forget, we'll just record a line granting him leave. The learned advocate on record for the appellant shall carry out the necessary correction in the preamble of the memorandum of appeal by inserting the name of the learned trial judge in order to cure the defect as pointed out by the additional stamp reporter. Next. Yes.
Yes, my lord, the application under 39, order 39 rule 4 has been rejected. Unlike, my lord, the earlier one, the 39-4 has been filed by the defendant number 1.
All right.
Now, my lord, why this application has been filed by the defendant number 1? Because, my lord, after purchase, my lord, he has, my lord, obtained the sanction plan as well as the conversion, my lord, of the property and mutated his name and purchased the my lord, the demarcated portion of the from the erstwhile co-sharer of the property, scheduled property.
Can the co-sharer sell a demarcated portion?
That is there, my lord. That is, my lord, what has been done, my lord.
Has been done.
Has been case make out by us, my lord. Now, when I was in, my lord, in substantial progress of the making my construction of my dwelling unit, my lord, purportedly the plaintiff has filed a suit for partition and, my lord, injunction restraining me from making any construction over there.
They have admitted that you have purchased a portion. Then
Yes, they have admitted,
otherwise
they have admitted that. But my case is that I have specifically purchased. Why, my lord, I am repeating this particular line? Because there are so many authorities, your lordship, I will show from this court that if the demarcated portion of the land, even not partitioned, has been purchased by the purchaser, my lord, and if he wants to, my lord, construct the property over his demarcated portion, he can. Now, my lord, the learned trial judge has rejected my application on some other footings. Since I have some other properties in some other, my lord, areas, I conceal that there are some other properties, and I started my construction.
That has nothing to do with this.
Yes, because your lordship kindly sees, my lord, the written statement first.
Show us the order first, Mr.
Yes,
Purigam.
yes, order.
The ordering portion. Let us see that first. Heard both sides from there.
Yes. Order number 40, my lord, dated 2nd of December 2024.
No, let us come to the second page of.
Yes, second page, my lord. The now
Heard both sides.
Heard both
Second or
sides.
third.
Yes,
Second.
heard both sides, considered the submission of both the sides, peruse the instant application and the written objection. This is the suit for partition, and the suit property has not been partitioned by meets and bounds in between the parties and not the co-sharers of the suit plot. And as such, each and every co-sharer of the suit plot is the owner of every inch of land in the suit plots. It is reiterated that on an order of temporary injunction had been passed by this court, while order dated 1st of February 2024 in the form of status quo to be maintained by both the sides with regard to the suit plot, as there was specific allegation from the side of the plaintiff that the defendant number 1 made attempt to encroach the land of the plaintiff. Now, though the defendant has stated that they are going to make construction of their incomplete structure in order to complete the same, which has been clearly indicated that marked as a property in the report of the learned advocate commissioner, but the defendant has not approached the court with clean hands, as he has deliberately suppressed the fact of having his alternative properties before this court, which is evident from the series of the title deeds.
No, Mr. Ponik, the court is right, because your undue hardship is based on you're making this construction for residential.
With this, all this.
Who are you?
I'm plaintiff. I'm plaintiff respondent.
You are for the respondent. You have no right of hearing at the order 41 stage.
I've filed caveat.
You have no right of hearing at the order 41 stage. We are still at the order 41 stage.
Your Lordship, kindly, your Lordship.
And we'll hear you definitely when you take up the injunction.
Your Lordship, kindly, your Lordship knows, my lord, this is the prerogative of the part of a person to choose in which property, if he has several properties, other
that
properties.
does no undue hardship is caused to you.
That
You may have a choice, but you are a co-sharer. Everyone has a share over the
but
every
my lord, I have purchased my erstwhile owner has sold the property, my lord, demarcated property, and my lord, I am enjoying that. When I have started, my lord, I have, my lord, I have
a suit for damages against your vendor.
No, that is there, my lord. I am not claiming any equity.
Moreover, there is order 39 rule 2A, so there will be complications.
Your Lordship,
Court is absolutely right.
kindly, my lord, allow me to place 3 judgments.
Yes, it will.
Then your Lordship kindly make your observation.
Yes.
First, eta de. Justice Subramanian. Similar circumstances, my lord Justice Division Bench presided over my lord Justice Subramanian Mukherjee reported in 2012 volume 2 CHN 436. Lord, I'm reading from paragraph number 12. That is the my lord German in this matter. Paragraph number 12. As per second proviso, if an order of injunction is passed after giving a party an opportunity.
This injunction was passed after hearing you?
Yes. That is admitted.
Yes.
Opportunity of being heard, the same shall not be discharged or varied or set aside on the application of said party, except where such discharge, variation, or setting aside has been necessitated by a change in circumstances, or unless the court is satisfied that order has caused undue hardship to that party. But even before, paragraph 13, but even before incorporating said provisos through Amendment Act 1976, the main portion of Order 13 and Rule 4 of the Code of Civil Procedure remained in this statute book. It is palpable that even without existence of those provisos, the court had the power to discharge or to vary or to set aside an order of injunction at the instance of any party to the suit if situation so demands. In other words, even if the condition as laid down in those provisos are absent, even then the court had the power to vary, to discharge, or to set aside an order of injunction at the instance of any party to said suit. The court has always the power to discharge or vary or to set aside an order of injunction, be it ex parte or contested, if the court is satisfied that the order requires variations, etc., for the interest of justice. I am skipping paragraph 14 and 15, 16. It is vital. At the time of hearing of petition under Order 13 in Rule 4 of the Code of Civil Procedure, there is no scope of deciding a party's title and or share in the suit property. The court has to see whether the ex parte ad interim order of status quo is causing much hardship to one of the parties, justifying variation of the same. There is no denial that respondent plaintiffs have made out a prima facie case of having 1/4 share in the suit property. It was alleged that there was no partition by meets and bounds amongst co-sharers, but it appears from the report of the learned commissioner that several portions were found to reside on suit property by constructing buildings in demarcated portions. It also came out that the appellant defendant number 6 purchased a demarcated portion through a registered Kobala and started to make construction thereupon, and that said construction came up to Linton height. Here, this is the case of my client. It is true that at the appellant defendant number 6, at the time of final hearing in the suit, it would be decided on evidence as to whether appellant defendant number 6 and some other defendants who are admittedly residing on the suit land by making construction on a demarcated portions had titled and or share in the suit property or not. Prima facie, it appears that appellant defendant number 6 is in occupation of a demarcated portion in the suit property, and that this demarcated portion is surrounded by boundary walls, and that he already constructed up to Linton height after obtaining necessary sanction from the appropriate authority. If appellant defendant number 6 is prevented from completing his unfinished construction, but later on it is found that he had the authority to make said construction, then his loss will be irreparable. On the other hand, if appellant defendant number 6 is permitted to finish his unfinished construction at his risk and without permitting to claim any equity, and later on it is found that he had no authority to possess said land, then plaintiff will be at liberty to get vacant possession of the said land after demolishing of said construction at the cost of the defendant number 6.
We'll treat this judgment with utmost respect.
Your Lordship, this is exact happened here, my lord. I have purchased.
This is just contrary
I have started construction.
This is just contrary to the law which is prevailing.
This is
palpably contrary to the law.
Thereafter, my lord,
if there is Order 13 and Rule 4, if that provision stipulates certain rights,
yes,
we don't have power to vary unless it's on a much higher ground. Much higher ground.
Yes, much higher grounds. My lord, I have invested.
This is just contrary to the prevailing law. It would not be irreparable injury for you. It's the other way around. And you get advantage. You construct on an advantage.
Your Lordship opinion after going through the second judgment. I took permission from your Lordship to show this.
No, sir. Only you have a right to do that.
Yes.
You don't require any permission for it.
Yes. This is reported in 2018, Volume 3, ICC 634. This is also the division bench judgment.
Yes.
Page paragraph number 13 onwards. 12. Your Lordship kindly see this 12. Here is the case where we find that the defendant number 1, being an admitted co-owner, is developing the B schedule property on the strength of power of attorney executed by 15 out of 22 co-sharers and the active consent of 4 out of 7 non-consenting co-sharers. The construction of G+3 storage building on the B schedule property has substantially progressed. Superstructure of G+3 storage building is almost complete. 13. The plaintiff has not approached the trial court seeking restraint order before commencement of construction. Since the construction has progressed substantially with huge investment made exclusively by one of the co-sharers, namely defendant number 1, we requested the learned counsel appearing for the plaintiff defendant number 1 to take instruction from his client as to whether she can secure the cost of construction of depositing at least rupees 50 lakhs with the court as a condition for passing a restraint order against the appellant. Learned advocate appearing for the plaintiff informed this court after taking instruction from this client, his client is unable to secure the cost of construction of the newly constructed incomplete building on the B schedule property. Now 14. Having regard to the fact of the super construction of G+3 storage building is almost complete, we, in order to prevent waste of such investment made in developing such property permit the defendant number 1 appellant to complete the said construction as per the building sanction plan, but at the same time pass some interim order for protecting the right of the appellant. Thus, the defendant number 1 appellant is restrained from transferring, alienating, encumbering, or creating any third-party interest and or parting with possession of one shop room measuring about 80 square feet on the ground floor of the newly constructed building on the B schedule property till the disposal of the suit. It is clarified that this order of injunction will neither prevent the defendant number 1 appellant from restoring the position of the erstwhile tenants in the completed building as per the contract which was entered into between the defendant number 1 appellant and the tenants of the suit properties, nor prevent the defendant number 1 appellant from selling and or transferring and or creating any third party
Yes,
interest.
Mr. Bonik, any other judgment you have
Yes,
seen?
Mr. Lordship. The third one, my lord, the Honorable Apex Court, it is, my lord, with regard to the order of injunction. AIR, sorry, 2008, volume 11, Supreme Court cases. Page টা কত? 1. Lord, I'll be referring, Lord, page, paragraph number 21 onwards of this charge. May I read?
Paragraph 20, yes.
While considering an application for grant of injunction, the court will not only take into consideration the basic elements in relation thereto, his existence of prima facie case, balance of conveyance, and irreparable loss injury, it must also take into consideration the conduct of the parties. Grant of paragraph 22, grant of injunction is an equitable relief. A person who had kept quiet for long time and allowed another to and with the properties exclusively ordinarily would not be entitled to an order of injunction. The court will not interfere only because the property is a very valuable one. We are not, however, obvious of the fact that grant of refusal of injunction has serious consequence depending upon the nature thereof. The courts dealing with such matters must make all endeavors to protect the interest of the parties. Milord, here I am pausing for a moment, Milord. I took the sanction plan in the month of September 2022, and my case is I have started my construction on and from October 2022. Now, after 3 months, after prolonged 3 months, when I have completed, Milord, substantial progress, I have.
When was the injunction granted?
Injunction granted 1st of February. Suit filed in the month of
1st of February, which year?
23. And Milord, the suit was filed in the on specifically on 16th of January 2023. So 3 months, Milord, the plaintiff waited. I completed I have invested
This
huge
could have been
amount
good
of
grounds in a challenge against the injunction order, Mr. Bonik, not in a 39-4.
Milord, I have
39-4.
Injunction I am not disputing. Why, Milord? There is a order of status quo, no injunction as such. The order of status quo was there.
The injunction, what?
I mean to say, Milord, the status quo was there. Milord, I was Milord, continuing with my construction work, my dwelling house. That is not for any other purpose.
The status quo.
That is not for any other. That is why, Milord, I filed 39.
Let the injunction be granted, and then you are coming up with undue hardship.
Milord,
Your undue hardship was available before even filing of the suit. That was available to you when the injunction order was passed.
Yes, Milord.
So subsequently, you cannot all on a sudden wake up and say, I had undue hardship since then.
But that is there. That is there, Milord. I have argued at that point of
time. We are
time.
on the same boat on that.
That has not been considered. And Milord, I have shown your lordship the judgment. That is the specific averment made by the
tried very well,
division
Mr.
bench.
You have tried very well.
I can.
We appreciate your
lordship,
trial, but you also have to face the error now.
Now, your lordship, kindly see the last 2 paragraphs only, nothing.
Absolutely.
For my.
No, definitely, please.
Milord, paragraph 26.
Yes.
Rightly or wrongly, constructions have come up. They cannot be directed to be demolished, at least at this stage. Respondent number C7 is said to have spent 3 crores of rupees. If that be so, in our opinion, it would not be proper to stop further construction. 27. We therefore are of the opinion that the interest of justice would be subserved if while allowing the respondents to carry out constructions of the building, the same is made subject to the ultimate decision of the court, the trial court is requested to hear out and dispose
Was
of
it a
the suit.
co-sharer scenario? Yeah.
Yes, yes.
In this case, it was a co-sharer scenario.
This is, my lord, the case of it a partition suit.
Partition suit.
Yeah. No, this is a suit. Yes, yes.
Partition suit.
Yes, yes.
Yes, yes.
Yes. The trial court is requested to hear out and dispose of the suit as early as possible. If any third party interest is created upon completion of the constructions, the deeds in question shall clearly stipulate that the matter is sub judice and all sales shall be subject to the ultimate decision of the suit. All parties must cooperate in the early hearing and disposal of the suit. The respondents must cooperate in the the respondent must also furnish sufficient security before the learned trial judge within 4 weeks from the date, which for the time being in assessed is at rupees 1 crore. Milord, same circumstances, milord, I milord, thought, milord, the change of modification of the milord, I have invested huge amount of money, not milord crores.
As per your averment in the order 39 rule 4, up to what level you have
Your
constructed?
lordship kindly see, milord. Your page 55, it starts from page 54, annexure E. Now, milord, the paragraph number 4, this is the milord statement has been made.
Yes.
Nalashi Dage, has your lordship got? Milord?
Yes.
নারাশি দাগে অধীন বিবাদিত সত্ত্ব দাখিলি ভূমিতে উক্ত নির্মাণ পোক্ত গৃহখানি সম্পূর্ণ করা অতি আবশ্যক।
No, no, up to what level you have
Uh,
not stated?
রহিদা ইমারতি সামগ্রী নষ্ট হইয়া যাইবে এবং অপূরণীয় ক্ষতি হইবে। Your lordship kindly see the next 3, 5, 6 lines in page number 56. The bottom portion of the paragraph of page 4, paragraph 4. প্রসঙ্গত আরো উল্লেখ যে ভবিষ্যতে হুজুর আদালতের বিচারে যদি প্রমাণিত হয় যে হুজুর আদালতের অনুমতি সাপেক্ষে অধীনে নির্মিত উক্তপোক্ত গৃহখানি বা ওই গৃহের কোনো অংশ নালিশি ভূমিতে অধীনের প্রাপ্য ভূমি হইতে অধিক ভূমিতে নির্মিত হইয়াছে তাহা নিজ খরচে ভাঙিয়া লইবে এবং তৎবাদ কোন রকম ইকুইটি দাবি করিবে না।
There is a commissioner's report.
Commissioner was appointed at the
Where is that report?
behest of that report has been manufactured because
Let us see the manufactured
yes,
report.
Your lordship kindly sees that statement has already been given.
Advocate's report is manufactured, the plaintiff is manufactured.
Manufactured means it has been at the dictum of the plaintiff, the report has been your lordship.
Whatever goes against you is manufactured.
No, that is there. Your lordship kindly see.
That is the report.
That is not against me at this.
Let us see the report.
Yes,
that
yes,
will show up to what stage you have constructed.
Yes. Page, my lord, 65. 63, 60. Sorry, 65.
63?
No, that is
65?
No, 24, my lord.
Okay.
Yeah.
25, actually.
Initially, my lord, I have stated that I am not only constructing my dwelling unit in the suit property, but also non-suited property. The two lands were, my lord, clubbed together. That was the contention initially made by me in the.
That is not canvassed. No.
Yes, yes. It is not denied that I am not making construction in the suit
Let
property.
us see up to what level you have constructed.
Lordship kindly see page 28. There is the report from with the map.
One new construction marked as A, and there have been 9 columns.
Yes.
And 6 rod tie beams. 1 feet height to the ground level, above ground.
This is two-story building. I have.
You have only not even lintel level.
That is there, my lord. I have
9
seen
columns and some rod tie beams.
My lord, I have seen the picture. I have seen the picture. That is, my lord, Linton, my lord, first floor has been otherwise completed.
But the commissioner's report says otherwise.
Yes.
You might have done. Oh, that's why order 39 rule 2A.
That is there. That is pending. That is pending.
That's why I have seen that picture.
Lord, that is they have filed the
You have
application.
violated the injunction, and
That is also
now
reflected
you
in the
seek
impugned
to
order. I'm not saying
now you seek to vary the same so that you are safe from the 39(2)(a).
no. That your lordship kindly sees, my lord. The construction has been started prior to the filing of the suit.
Yes,
That is
yes.
not that the suit has been filed. Thereafter, I have started construction. If that be so, my lord, your lordship could have, my lord, my lord.
Must have started prior to the filing of the suit. Otherwise, they would not claim any injunction.
Yes, that is why, my lord, I filed this application because I have invested. That is fact.
As your senior used to say, the plaintiff filed the suit. So construction must have started prior to the suit for the injunction to be sought. No, Mr. Uring. Console Mr. Adhikari out of court. We have heard you also, sir. But you have argued very well. I mean, our usual thing, but
your lordship, this is affidavit of service.
Affidavit of service filed today be kept on record. Full stop. The appeal is taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. The defendant in a where is the relief of the suit, Mr. Bonik? The plain reliefs? Yes, page 13. Yes, 13. Got it. Yes. You are one of the defendants in the suit?
I'm one.
Oh, no, sole defendant.
Defendant number one.
But the others have not been made parties in the application as pro forma?
Party because I am affected. My lord. This is
Pro forma defendant, parties as pro forma defendant, they won't be affected.
This has been done, my lord.
We will also say the appeal is bad for non-joiner. The one of the defendants in a partition suit has preferred the present appeal against an order whereby the appellant apostrophes application under Order 39 Rule 4 of the Code of Civil Procedure for variation stroke vacating of an order of temporary injunction has been dismissed. First up, learned counsel for the appellant argues that the appellant has substantially made a construction for which a sanction plan was obtained as long back as in the month of September 2022. Full stop. Construction was started since October 2022, but the plaintiff sat tight over the matter and filed the suit only on January 16, 2023. Pushed up. Even thereafter, the plaintiff did not make any application for injunction before February 1, 2023. Push up. Next para. Thus, having permitted the defendant stroke appellant to carry on with his construction upon obtaining a due sanction plan, the plaintiff ought not to have been granted an injunction order. Full stop. Next para. That apart, it is argued that undue hardship of the plaintiff arises from the fact that the plaintiff has invested much in getting the sanction plan and having accumulated building material on the plot of land, which would also deteriorate in the event the status quo is permitted to continue. So next para, learned counsel further argues that the learned trial judge based his order on irrelevant circumstances that to the effect that the plaintiff has other alternative properties which does not have any bearing on the present matter. Push up next para. Learned counsel cites two coordinate bench judgments of this court reported respectively at 2011 SCC online Cal 5445 within bracket namta diye and 2018 SCC online Cal 4029, as well as a judgment of the Honorable Supreme Court reported at 2008 11 SCC 1 in support of his contentions. First up, next para, it is argued that in similar circumstances, the court, in the said cases, had permitted construction to be completed. First up. Next para. We find from the impugned order that the learned trial judge has adverted to several facets of the matter. Pushed up in the present case, after having suffered an order of temporary injunction, which was passed on contest as long back as on February 1, 2023, the present application under Order 39 Rule 4 of the Code of Civil Procedure has been filed 1 year thereafter, that is on February 15, 2024, claiming undue hardship. Full stop. Next para. The learned trial judge also considered the aspect that in view of the pendency of an application under Order 39 Rule 2 capital A of the Code of Civil Procedure alleging violation of the temporary injunction order of the temporary injunction order granted against the appellant, comma, an order vacating the injunction order might create complications. Full stop. Next para. We, in fact, cannot rule out the possibility of the vacating application having been filed only upon the appellant being subjected to the risk of contempt under Order 39 Rule 2 capital A, which is also evident from the fact that the vacating application was filed 1 year, more than 1 year after the injunction order being passed. Full stop. More importantly, comma, the undue hardship within double inverted, which is now pleaded by the appellant, was also available to the appellant at the juncture when the parent order of temporary injunction was passed. Full stop. The appellant, having not challenged the said injunction order by way of an appeal and having let the same attain finality, cannot now re-agitate the self-same ground of undue hardship which was available to the appellant at that juncture itself, to seek a variation of the contested temporary injunction order. Full stop. Also, in the same tune, we find that there is no change of circumstances as rightly observed by the learned trial judge. Full stop. Insofar as the division bench judgment of this court in the matter of Shailendranath Patra is concerned, with utmost respect, although the court has held that even otherwise than the parameters set out in Order 39 Rule 4 of the Code of Civil Procedure, the court can vacate or vary an order of injunction if satisfied that it requires variation for the interest of justice, in order to satisfy such test, which will be patently contrary to the specific provisions of Order 39 Rule 4, within the limited conspectus of which a vacating order can be passed, the person seeking such variation has to satisfy a very high ground. Full stop. We do not find any such case having been made out in the present context. Full stop. Next para. Moreover, in the said case, not only had construction been made till the linton up to the linton level, the concerned portion of the property had been demarcated by boundary wall. Full stop. Next para. In the present case, we do not find any such circumstance to necessitate a vacating of the temporary injunction order passed on contest. So next para. In the case of Ashraf Jamil Supra, the division bench was, as a general proposition, considering that the right of a co-owner to develop a joint property is well established. Full stop. However, the context in which the said order was passed was that a superstructure of a G+3 storied building was almost complete, and stopping the construction at such final stage would cause more hardship than it would alleviate. Full stop. Next para. In the present case, however, we find from the report of the Advocate Commissioner, which is also a part of the record, that only certain pillars have been installed on the property and certain iron tie rods have been put thereon. Full stop. Hence, the proposed construction is still at an inchoate stage, although the appellant alleges that the sanction plan was obtained more than 2 years back in the year 2022. Full stop. Next para. Thus, we do not find as to why the appellant suddenly woke up from its slumber after having suffered the injunction order for a period of 1 year and having not made substantial progress in the construction, by filing the present application. Full stop. We do not find any other reason for such filing than to avoid the consequences of the Order 39 Rule 2 capital A application. Full stop. Next para. Insofar of the judgment of the Supreme Court, which has been cited by the appellant in the matter of Mandali Ranganna Supra, comma, in the said case, comma, the Supreme Court was dealing with grant of injunction under Order 39 Rules 1 and 2 of the Code of Civil Procedure, which is on a completely different footing than an order being passed under Order 39 Rule 4 of the Code. Full stop. In the former case, comma, it is for the first time that the court is considering the balance of conveniences between the parties and other yardsticks such as irreparable injury. Whereas in the case of the latter, comma, a contested injunction application having already been passed, comma, the scope of scrutiny of the court is extremely limited. Full stop. Only in the case of change of circumstances and undue hardship can an injunction order granted on contest be varied or modified or set aside. Full stop. Next para. Thus, comma, the tests applied in the said judgment by the Supreme Court are not at all germane for the present context. Full stop. Next para. Moreover, comma, in the said case as well, comma, at the injunction stage itself, comma, it was observed by the Supreme Court that since a construction has come up, it would be detrimental and costly to direct demolition of the same at that stage, since 3 crores of rupees had been spent by the person who had constructed the same. Full stop. We do not find any such material before us, comma, more so since the temporary injunction order has survived a year without any challenge thereto at the behest of the appellant. Full stop. Next para. As such, comma, this court is of the opinion that the impugned order of the learned trial judge was justified on every count, and as such, there is no scope of interference with the same. Full stop. Accordingly, FMAT 37 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Can 1 of 2025 is consequentially dismissed as well. No orders to cost. প্রথমে দিয়ে দিও, affidavit of service filed today be kept on.
But since all of the respondents filed their written statement, can it be expedite the suit? Suit can be expedited,
It is not even at the peremptory hearing stage. What is the age of this? No, 23 suit.
23 suit.
We are not granting in 227 also. When I sit singly, I am not.
Yes.
23 suits, no. Sorry. Thank you. Yes. Mr. Bhattacharya, you are for the appellant. There is no caveat. No caveat, no defect.
Technique. That the same, almost the same, Millard. This is Millard. I am challenging a contested Millard injunction granted Millard.
The same order. We adopt the order passed in the previous one.
Millard, what happened, Millard, in 42, Millard, there was a deed of partition admitted by the
1942.
1942. Millard, after that, Millard, perhaps partition.
There's a movie by that name.
Yes.
Oh, that's not the full name. Anyway, then what happened?
Millard,
Obviously, in your case, it's something contrary to that.
No, I'm the defendant. It is Millard, in my written statement, the fact of Millard, the 1942 Millard deed Millard has been brought.
No, the suit is for
of partition and permanent injunction.
By them.
By the plaintiff.
You are the defendant.
I'm only defendant number 3 and 4.
Right,
Others
then?
have not challenged. Now, Millard,
You say 1942 it was partitioned already.
Partitioned.
By meets and bounds, registered it.
Yes, I want to show that that word before your lordship, chinnito mote.
Registered deed.
Registered deed of partition.
Then?
Now, Millard, what happened, Millard?
So it was a contested order of injunction.
Contested after this. Now, Millard, what happened, Millard?
Go and prefer a challenge against that order.
Well, that is the challenge, Millard.
Oh, you are challenging an injunction order.
Injunction order.
Why do you say it's similar to the previous one was Order 13 and Rule
No,
4?
Millard.
There the scope is much limited.
No. Now,
how you may have a case? Yes.
Now, Millard, what happened, Millard? Till date, Millard, we filed written objection to in the year 2016.
Right.
Now, Milord, as of today, Milord, they have not amended their plaint and said that 1942 deed is void, Milord, fraud. Therefore, Milord, they are in somehow, Milord, Article 59 of the Limitation Act, Milord, is, Milord, apparent. Now, Milord, what happened? After, Milord, that Shaw schedule was, Milord, partitioned, one of the, Milord, the Shoptom party, Milord, the seventh party who was there in the partition deed, he had made, Milord, he and his brother had executed, Milord, the Shostopoko, two Milord long-term settlement, Mokarari Mauroshi Patta, in the name of one Milord Kinuram Khan. Now, Milord, what?
Getting complicated now.
Kinuram Khan. Now, Milord, what happened, Milord? Lordship knows, Milord, that Kinuram Khan was in possession. Now, Milord, after Milord Estate Acquisition Act, Milord came into Milord force. Now, Milord, the original, the Rayati, Milord, the intermediary right of the plaintiff's predecessor, Milord, got vested with the state. Kinuram became the, Milord, the direct tenant under the state. Now, Milord, as direct tenant, and we, Milord,
No, 1942, by 1942, your predecessor got a specific portion.
Our predecessor as well as the plaintiff's predecessor.
The same suit property.
Same suit property.
So in the meantime, it has vested.
Numerous Milord.
No, Kinuram became the owner. I mean the right.
Kinuram Milord, a long-term Milord settlement deed was executed in favor of Kinuram.
So Kinuram now reigns supreme over the land.
Thereafter, Milord,
yes,
several Milord transfers have taken place. Now, Milord, our point is, as of today, plaintiff has lost title over the property. Court could not have granted injunction at all.
How are you affected? You have also lost title.
No, their portion, Milord, in view of the Chaw schedule property. The Chaw schedule property, as of today, is
that was settled with Kinuram.
In Kinuram, only schedule of the Milord partition suit. In the plaint of the partition suit, only Chaw schedule property.
How was this dealt with? Two points. One is 1942 deed that has to be dealt with, and Chaw Kinuram.
Court says, Milord, these are highly disputed questions to be go to, for
1942 deed. You produce the deed
yes,
with a written
specific
statement.
Averment in our written objection and the written statement.
Did you produce the deed with your written statement? You now have to produce the document.
I have annexed it. Kindly comes to Milord, page 85, Milord.
So your primary two grounds are 1942 deed overlooked. Suit is not maintainable if that is there, and
not overlooked, looked but not dealt with.
Not appreciated properly in proper perspective, and that the court said that was highly disputed.
Yes, court says that these are facts to be decided in trial. Now, Milord, if your lordship would kind enough to look at the order, or Milord, may I look at show to your lordship the page 85. Milord, kindly see Chaw schedule. Chaw schedule, Milord, kindly see Topshil Jaha.
We find up to Chaw, yes.
Chaw, Milord, second Milord Chaw.
Chaw, yes.
Topshil.
Chaw as in the alphabet, not the numbers.
No.
Very well. Yes.
Topshil Jaha Shoptom Pokho. Kindly now, Milord, who is Shoptom Pokho? Kindly comes to Milord.
Sharat Chandra.
Yes. The
Sharat Chandra, who is he?
Page kindly comes to Milord, page 66.
No, he's the predecessor of the plaintiffs or something.
Yes. The predecessor of the defendants. Kindly see Milord, page 66. There is a type.
Your predecessor then.
Kindly comes to Milord. Shoshtho Pokho, Satish Chandra. No.
Where is Shoshtho Pokho?
No. Kindly comes to Milord, page 68. Page 68. Shoptom Pokho, there is a type copy, Milord. Kindly see at page 69. Sharat Chandra Shapui and Nirmal Chandra.
68.
69 is a type copy. 69, there is a type copy, Milord. Shoptom Pokho, Sharat Chandra and Nirmal Chandra Shapui. We are claiming from Nirmal Chandra Shapui. Now, Milord, kindly, Milord, turns to Milord, page 85. Kindly see, Milord, the Topshil Jaha Shoptom Pokho, see Sharat Chandra Shapui, অংশে ধার্য হইল।
Sharat Chandra Shapui Digor. Otherwise, you would not have any right. Because you claim through Nirmal, the other one.
Nirmal.
Sharat Chandra Shapui Digor includes Nirmal. Yes.
জেলা 24 পরগনা থানা সার্জেন্ট এলাকাধীন জেল নাম্বার 12 মৌজা মারুদহ গ্রামে সেটেলমেন্ট জরিপের 159।
And what about Kinuram's this settlement?
I'm coming to your lordship. Kindly see, Milord. Now Milord 159. Lordship has seen 159. The chaw, Milord. I was placing Milord page
159, you are placing 85.
85, Milord. The third line.
Yes, yes. 159, right.
Yes. Now, Milord, kindly comes to the schedule of the Milord plaint.
There was a map annexed to this? No.
No. Kindly comes to page
So this is
28.
Oboshisto. This is not demarcated.
This is Chinnito. The next line is there. Kindly see 159. Khotiane Namal Bad Namjada. Very Namo 53 একর 58 শতক অংশ 80 হাত হইতে রশির মাপে 162
Chinnito, yes, you have got Chinnito.
Chinnito. And now Milord kindly comes to page 28. 28. This is the schedule of the partition suit.
Yes.
Kindly see all that piece and parcel of land measuring about 46 acre 42 decimals be the same a little more or less under Moja Madurdaho Porgonas Kolkata jail number
Yes,
12.
Khotian 159 is there.
RS is 153 by 1, CS is 159. Therefore, this is the only Milord suit property. Now, Milord kindly comes to the Milord page 88.
Yes.
This is Milord kindly see Mourashi Mokarari Patta page 18. Next page is a type copy.
Yes.
Kindly see Milord the 1944 Mourashi Mokar Grohita Kinuram Khan.
This is the plaintiff's portion.
This is Milord the pro forma defendant's portion. There is I'm coming to the next deed also. Milord kindly comes to page 91. At the top, Srijukto Babu, the Patta Data is Srijukto Babu Bonkim Chandra Sapui.
Yes.
Now
Bonkim Chandra is
another party.
All pro forma defendant.
All pro forma defendant.
Plaintiffs.
Yes. Next deed. Page 100 and
all gave to Kinuram.
All gave to Kinuram. Kindly comes to Milord page 100. The next deed.
So you rely on the Estate Acquisition Act for these properties. Let us see the impugned order once.
Yes. Milord kindly comes to Milord page 108 and 109. Milord.
For what?
Milord.
Kinuram.
Kinuram's name has been.
Go by your submissions.
Kindly see Milord the decision with reasons. Upon hearing the learned advocate and after having gone through the materials on record, the court comes to hold that admittedly there is no denial of the fact that predecessor in interest of the plaintiffs were co-sharers of land in RS suit plot number 417. At the time of hearing, the defendants have come with one registered deed of partition being 465 of the year 1942, claiming that the predecessor in interest of the plaintiff and had partitioned the land in suit plot number 417 and also sold it to one Kinuram Kha, and that it is challenged by the plaintiffs as this is completely wrong. I will show to your plaintiff, show to your lordship. As of today, Milord, they have not amended the plaint. As of today,
no, that we understand, but they have produced RS the extracts from the records of rights to show their position. No. So your Kinuram case goes then.
This is Milord page 107 is there. Page 107 is there.
The RS records show otherwise.
Well, this is also RS record.
No, the court has adverted to it. Since the RS records has produced come into operation after Estate Acquisition Act, such and such, do not contain the name of predecessor.
No, kindly at Milord, kindly, if your lordship kindly sees Milord, page 107. Even if Milord their name shows, by operation of law, Milord Kinuram has become Milord the.
Well, we'll admit the appeal, but cannot stay the appeal at this.
Not at this stage. And now thereafter, Milord several deed. Oh, Milord, another thing. Kindly comes to Milord the deed which is at Milord page 121, the last annexure. Kindly see Milord 122. Kindly see 124, 122.
Yes.
Kindly see who is the Grohita Sanjeev Shapui. He is one of the plaintiff in the partition suit.
Right.
Kindly comes to Milord page 124. Who is Milord Kovala Data Shukumar Shapui, his father. Kindly see the last paragraph, Milord, of that page. অতঃপর উক্ত জ্যোতিষচন্দ্র সাফুই মহাশয় তথা নিজস্ব সত্য দখল প্রচার অন্যান্য শরিকগণের
Oh,
সহিত
1942 deed is admitted.
they admit this.
The present appeal has been preferred against an order of temporary injunction.
No, contested disposal, final disposal.
Against an order of temporary injunction passed on contest in connection with a partition suit filed by the plaintiffs stroke respondent numbers 1 to 3. Whose of next para learned counsel for the appellants, comma, who are defendants in the suit, comma, argues that the learned trial judge committed several legal errors. First, comma, a registered deed of partition of 1942 was produced by the appellants, which shows that the suit property was partitioned by metes and bounds, and demarcated portions were allotted to the different co-sharers, comma, which renders the partition suit itself non-maintainable. Secondly, comma, it is argued that several of the other parties to the partition suit had settled their portions of the property by virtue of execution of Mourasi Mukarari Patta in favor of one Kinuram. By operation of the West Bengal Estates Acquisition Act, comma, it is argued, comma, the said Kinuram acquired full rights in the property as riot thereof, and as such the plaintiffs and some of the pro forma defendants do not retain the locus standi to file the present suit or claim as co-sharers. Also, comma, in a transfer deed executed between one of the plaintiffs and his father, comma, the deed of 1942 was admitted. It is contended by learned counsel for the appellant that these aspects of the matter were completely not considered in proper legal perspective by the learned trial judge, who relegated the matter to the trial in a cryptic fashion. Next para. We find sufficient prima facie case having been made out by the appellant for hearing of the appeal on merits, and as such, the appeal is admitted to be heard on the grounds as enumerated above and the other grounds taken in the memorandum of appeal. Next para. Since grant of stay of operation of the impugned order at the present juncture would tantamount to allowing the appeal itself without it being heard, comma, the application for stay is required to be heard along with the appeal. Accordingly, the appellant shall serve copies of the stay application bearing can 1 of 2025 along with a copy of the memorandum of appeal on the respondents, indicating that the appeal along with the application shall be listed for hearing in the monthly list of March 2025, in view of the short scope of the appeal, comma, calling for the trial court records as well as preparation of paper books is dispensed with for the present. Next para. The service of copies of the application and the memorandum shall be deemed to be service of notice of the appeal as well. Appropriate affidavit of service to that effect shall be filed on the next returnable date. The appellant shall also serve on the respondents a server copy of this order along with the above copies.
Only the plaintiff respondents, not the others are on my side defendants. They have been made pro forma.
No, injunction status quo has been granted against whom? Not all the defendants.
On the principal defendants. I was also principal defendant.
You were the only two principal defendants.
No. It was contested by all, but only Miller.
No, the outcome will be, they will be affected by the outcome. They also can come and under order 41 to 33 and 22, they can
support the findings.
Support or challenge some
Challenge
particular
the
finding. Serve on all.
Very
My lord,
Yes.
is my appeal.
What is the defect?
My
Let
lord,
us first.
no defect. My lord.
It is marked as defective. Let us see what is it.
But in the list, I did not find any defect.
That is our court officer's problem.
I'm sorry.
Defect removed.
আছে? Mark.
Removed.
Yeah, put in the deficit court fees.
Oh, oh, that already been paid, my lord.
Then that is our defect. Defect cure হয়ে গেছে. Anyway, move the matter, please.
My lord, this matter, my lord, relates to the Provincial Insolvency Act, 1920. My lord, I am the
Yes.
debtor appellant.
But then a leave is to be
Leave, application for leave is
we are
there, my lord.
we are hearing this the appeal under this act. After my practice life, I have never
Lordship,
had.
lordship.
So that leave application is also there.
Also there. The can number 2 before your
Allowing
lordship.
the leave application means admitting the appeal. So just satisfy us on the grounds of the appeal. What are the grounds of the appeal? Because if you grant leave, that tantamounts to we automatically have to admit the appeal. Please satisfy us on the grounds.
My lord, ground number.
No, from the order, just place
Yes.
the order.
Lordship will find, my lord, by this order, curiously, my lord, by this order, my retirement benefits have been withheld.
Oh.
My lord, most unfortunate, that is the order number 3, dated 29th August 2024. Lordship will find the operating part.
Let us see the reasoning, please. Just place the impugned order once. Just read out the impugned order.
Lordship. The petition under section 5 of the Provincial Insolvency Act is taken up for hearing. It is submitted by the petitioner that the debtor of OP had executed one promissory note in favor of the petitioner and received a sum of rupees 5,85,000 along with 12% interest per annum. Although the debtor stock OP number 1 received a total sum of rupees 5,85,000 from the creditor petitioner with a further promise to repay the same before his retirement, that is on 31st August 2024. The petitioner is entitled to get a sum of rupees 7,52,730 along with.
No, but what we have seen, what was the evidence produced by them?
My lord, no evidence.
Promissory note they must have produced.
Promissory note. Only promissory note.
But have you annexed a copy of that?
No, my lord. Actually,
ওই সময় না র্যাকেট চলছিল র্যাকেট চলছিল একটা গ্রুপ অফ পিপল না ওরকম ফলস প্রমিসারি নোট দিয়ে এই করে এর ইয়েটা ভেঙে দিয়েছিল প্রভিনশিয়াল ইনসলভেন্সি অ্যাক্ট এটা কি আলিপুর this is Alipur at that point of time probably a racket was also going on regarding this the people were manufacturing promissory notes and many people were victimized.
My lord, my client is.
You never know anything about that promissory note. You never know the other side also.
Exactly. I'm grateful to your lordship.
But we can't grant an order of stay. If we grant an order of stay, then if you take away the money, then the entire appeal will be allowed.
Let it be admitted. At least.
We'll admit the appeal and pass the necessary directions for you to. We'll direct the application for stay to be decided along with the appeal. Then.
Lordship, I'm grateful, my lord. Lordship, kindly keep it in the month of March.
But you cannot prepare this in this matter. The lower court records will be necessary.
Oh,
that is why we'll give you liberty to. We'll ask you to prepare informal paper books without comparing with the records. Put in special messenger cost, and as soon as it is ready for hearing, just mention.
I'm grateful, my lord.
প্রথমে leave application টা নিয়ে নিচ্ছি.
Can
2 of 2024 is an application for leave to prefer an appeal under section 75 within bracket 3 of the Provincial Insolvency Act 1920. Full stop next para. Upon a perusal of the memorandum of appeal and hearing learned counsel for the appellant, we find that a strong prima facie case for hearing the appeal on merits has been made out, inasmuch as the learned trial judge, without adverting to the exact evidence relied on by the trial court, has granted an order whereby the entire retirement benefits.
No, my lord, only leave adjustment salary, part of the retirement.
The leave adjustment salary, part of the leave adjustment salary.
Encashment salaries.
Where do you find that?
Encashment salaries. অর্ডারটা বের কর না।
No, no. Withhold an amount of 7,52,730 from the retirement benefits.
Oh. 7 except gratuity and perhaps provident fund has been recorded.
That is not there in the ordinary portion.
Provident fund.
Very good. Whereby the retirement benefits now whereby an amount of rupees 7,52,730 has been directed to be withheld from the retirement benefits of the appellant, comma, who was the head of the department, Geological Survey of India, comma, central headquarter, comma, excluding provident fund and gratuity. Full stop. Next para. Accordingly, the appeal will be heard on the grounds taken in the memorandum of appeal. Full stop. Can 2 of 2024 is allowed, granting leave to prefer the appeal. Full stop. The appeal is also admitted on the grounds as indicated above and as taken in the memorandum of appeal. Full stop. Next para. In view of the nature of the order, comma, in the event an ad interim order of stay is passed at this juncture, comma, the same would tantamount to allowing the appeal before hearing the respondents. Full stop. Accordingly, we direct Can 1 of 2024, comma, the stay application to be heard along with the appeal itself. Full stop. The trial court records be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Full stop. The appellant shall also put in due requisites within a week. Stop. Upon service of notice of arrival of the trial court records, comma, on the learned advocate for the appellant, comma, the appellant shall prepare and file the requisite number of paper books within 8 weeks thereafter. Full stop. Next para. Liberty to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing.
I'm grateful.
Thank you very much. আপনি ডিস্ট্রিক্টে যখন ছিলেন তখন হয়তো পেয়েছিলেন, এগুলো খুব রেয়ার। ইন্স্যুরেন্স প্রচন্ড র্যাপিড ছিল, জালিম একটা গ্রুপ কাজ করতো, বয়স্ক লোকেদের পেনশন ফেনশন নিয়ে করেছে। 29টা কি টাইম হয়ে গেছে? 10 তারিখ। Yes.
But I am here, my lord.
Yes, Mr. Vasu.
I'm getting old, my lord. Again, third day I'm absent.
I was to answer.
Yes, they have finished.
Yes.
Yeah.
Lord, Lord, this is an appeal, my lord, against the preliminary decree of partition. My lord, I am the my lord, plaintiff respondent here.
Yes.
The suit, my lord, was for partition and the declaration, my lord, that a deed of family settlement is void.
Yes.
These were the prayers, my lord, sought by the plaintiff in the suit. My lord, if your lordship kindly takes the, my lord, the prayers once, my lord, because on the last occasion it was submitted, my lord, by my learned senior friend appearing, my lord, for the appellant, that the learned put below, my lord.
Give us half a second. এই বলছি যে কোনো নোট ফোট ছিল আমার এখানে, নোট করছিলাম এছাড়া আর Yes, sorry.
Bal has taken a note, if I'm not wrong.
I also think so, but I can't find it. That's a difficulty.
It is that matter interpretation of the document. Today it has been surfaced. Family settlement we have said. Court said is a gift, so it is rejected.
Yes, yes.
My submission was that even if not a family settlement, is a will.
হ্যাঁ, এটা যথেষ্ট লম্বা নোট নিয়েছিলাম আমি। Very well, let us hear Mr. Rai. Mr. Rai, let us not detain you further. Yes, move the matter. Yes, what is your case?
Yes. My lord, we had, my lord, filed a suit, my lord, seeking a decree for partition.
Right.
And my lord, for a declaration that, my lord, a deed of family settlement said to have been executed by our predecessor in interest, my lord, is void. My lord, the learned court below, my lord, held in our favor, saying that the suit, my lord, the suit property is joint in nature and therefore, my lord, deserves to be partitioned. My lord,
Why void?
my lord, it held the jointness, my lord, was disputed only on
No,
the
why was it void, according to you?
Yes, according to us, it was void, my lord, because we said that it was never executed. And, my lord, the document is forged. My lord, the Honorable Learned Court, my lord, held that the execution is valid. But, my lord, despite holding that the execution is valid, the Learned Court below, my lord, found that it did not amount to, my lord, any kind of transfer, my lord, being effected in favor of the defendants in the suit, which, my lord, which could, my lord, obstruct my decree for partition being granted. Lord, if it was in the nature of a document creating any kind of title in them, then in that case, my lord, my case for partition would have been, my lord, annulled. But, my lord, that was not the case. Lord,
Oh, this is where Mr. Basu argued that either it's a will or a family.
Yes, now, my lord, that it is a will, it was said that the learned court below went wrong in not observing that if it was not a deed of settlement or not a deed of gift as what was argued by the defendant before the court below, the learned court below should have held that it is a will. My lord, before I proceed to answer this, my lord, as a matter of proposition, my lord, I would humbly submit that, my lord, when a court is, my lord, in session of a matter and is, my lord, going to adjudicate a suit, my lord, the relevant inquiry, my lord, undertaken by the court would be to assess as to whether, my lord, in the given set of facts, a decree can be granted. And what would be the facts, my lord, which would, my lord, debar the court or prevent the court from granting the decree. My lord, here in this case, if, my lord, a case is set up by any of the parties that a document brought to the notice of the court is of such nature that it creates a title such that, my lord, it prevents, my lord, the party, the property from being a joint property.
They are challenging a preliminary degree.
Yes, they are challenging a preliminary degree.
So even if it was a will, that would not be germane for this concept.
Yes, that is.
There would not be any present transfer.
I'm absolutely on this, my lord, because their case in the written statement was that it is a family settlement. They argued that it is a gift. And, my lord, the learned court below held that it is not a gift because there is no transfer in presenti.
So either it's a gift or it's not a gift. There is no transfer. That's only germane for
Yes,
this
yes, my lord, and I would show it from my lord the evidence as well as from the plaintiff, my lord, that the parties went to the suit with full knowledge that this is the case that we have pleaded. This is the case that we are going to prove. My lord, today in the appellate court, he cannot by way of surprise, my lord, say that no. This is a will, and the learned court below went wrong in not deciphering it as a will, although, my lord, no case was made out.
Even if it was deciphered as a will,
that would have not made any difference, my lord. That was not a relevant inquiry. That was my lord. That is my first submission. That is my lord. Your lordship will kindly take, my lord, the plaint case once. My lord, page. I'll just, my lord, take your lordship very quickly through snippets, not the entirety of it. My lord, kindly take, my lord, page 4 of the paper book.
Translation পরে কথা আছে যদি Yes.
Paragraph 5.
5.
1 নম্বর বিবাদী এই বাদীর বিরুদ্ধে মিথ্যা উক্তিমূলে কল্যাণস্থ মাননীয় সিভিল জাজ জুনিয়র ডিভিশনের আদালতি নালিশি গৃহ হইতে উচ্ছেদের প্রার্থনায় এত নম্বর দেওয়ানি মোকদ্দমা দায়ের করিয়াছেন। Lord, I am leaving all of it, Lord. Kindly have a look, Lord, at 4 lines from bottom. About the extreme end, right hand side, Lord, of the 4th line.
অত্র মোকদ্দমা
My Lord, fourth line from bottom of paragraph 5.
অত্র মোকদ্দমা
My Lord, yes. অত্র মোকদ্দমার বাদী তাহার উকিল বাবুর নিকট প্রথমবার উক্ত কথিত পারিবারিক নিরূপণ দলিলের অনুলিপি দেখিয়া দলিলের নম্বর লইয়া বহু খোঁজ করার খবর করিয়া গত ইংরেজি 7/1/2001 তারিখে ধানতলা অবস্থিত রানাঘাট 2 এডিএসআর অফিস হইতে উক্ত কথিত পারিবারিক বন্দোবস্ত দলিল সহি ময়রার নকল তুলিয়া উক্ত কথিত দলিলটি দেখিয়া আশ্চর্য হইয়া যান। Therefore, my lord, this is the case that it is a family settlement. Now, my lord, kindly take, my lord, page 6. I am not, my lord, troubling your lordship with all of it. Page 6. Lord, 10 line, my lord, from the bottom of the paragraph at page 6. এমত অবস্থায় নালিশি। এমত অবস্থায় নালিশি সম্পত্তি হইতে বাদীকে বঞ্চিত করিবার কোনো কারণ বা ইচ্ছা মনোরঞ্জন বাবুর ছিল না, বা সে কারণ কোনো ইচ্ছা মনোরঞ্জন বাবুর কখনো প্রকাশ করেন নাই। যদি পক্ষগণের পিতা উক্তরূপ কথিত কোনো পারিবারিক নিরূপণ দলিল করিতেন, তাহা হইল উক্ত কথিত দলিলের সহিত সম্পাদনের পর তিনি উক্ত কথিত দলিলের তফসিলভুক্ত 3 শতক ভূমি এত নম্বর দলিল মূলে কালিদাস ঘোষালের স্ত্রী মীনা ঘোষালের বিক্রয় করিতেন না। Lord, therefore, my Lord, I went to the court with the knowledge that there is a family settlement alleged to be, there is a document alleged to be a family settlement, and I say, my Lord, that it is void. My Lord, this was the case set up by me. My Lord, kindly take page 9. These were the prayers.
Yes, you have seen the prayers also.
Yes. My Lord, the first prayer is for partition. Second prayer is, my Lord, for partition by meets and bounds. Third prayer, my Lord, is তফসিল ভুক্ত কথিত পারিবারিক নিরূপণ পত্র দলিলটি ভুয়া
So
তঞ্চকি
not only limited to fraud and this misrepresentation, but also not binding.
Yes. So, my Lord, this was the case, and my Lord, kindly see the written statement once.
Yes.
Page 17.
Yes.
My Lord, 10th line from top.
Hmm.
The plaintiff when. Lord, about right hand side, my Lord.
Yes, the
Wife
plaintiff.
in UK thereafter. The plaintiff, when was in distressed condition, requested the defendant number 1 on 8/1/2009 to permit him to reside in a portion of the suit house, as at that time defendant number 1 along with defendant number 2, his unmarried sister, became the owner of the property by family settlement deed dated 9/12/1992 as executed by the father in their favor voluntarily and out of own accord. Lord, this was the case, Lord, made out by them, Lord, in the written statement. Now, my Lord, your Lordship will kindly have a look at the evidence, my Lord, adduced by the parties. Lord, kindly take, my Lord, page 35. This is the chief of the plaintiff.
Yes.
Lord, paragraphs 11, 12, 13, and 14. Lord, all, my Lord, are about deed of family settlement. Then
This is your chief.
This is my chief. And Lord, kindly have a look at the questions, my Lord, which were put to me in cross. Lord, kindly take, my Lord, page 50. First line, my Lord.
Yes.
First line. I did not know that my brother-in-law transferred his properties to the defendant numbers 1 and 2. My Lord, last 3 lines.
Yes.
Not a fact that I did not come to know for the first time about the family settlement deed from the plaintiff TS 84 of 2008 by the term forged. I wanted to state that the family settlement deed was not executed by my father-in-law. So, my Lord, it was a case of family settlement.
That was a higher case, but you could not prove that
No, I
clearly.
could not prove.
But it is not binding, no
Yes.
title passed.
Yes. Now, my Lord, kindly have a look at, my Lord, the defendant's evidence. My Lord, kindly take, my Lord, page 62. Lord, paragraph 6. Choy, আমাদের পিতা মনোরঞ্জন মিত্র, entirety of it, my Lord, is about family settlement. This is the chief. My Lord, page 63, paragraph 13. And page 64, paragraph 14. My Lord, kindly take, my Lord, page 67. This is not in the witness box. Chief again. Manoranjan, I'm sorry. Manoranjan Mitra was my father. He executed one family settlement deed. This is the deed which was written as per instruction of my father. This deed was written by Indu Bhushan Babu. My father read the deed in our presence, put the signature. This deed bears the signature, such and such, such and such. But now kindly take note, page 70, cross. Not about 8 lines from bottom.
This was heard by some other bench previously.
No, my Lord, your Lordship. Lord, maybe, my Lord, at the time of initial moving, yes.
He was born in England, doctor, these are underlined. Must have been some.
Lord, 8th line from bottom at paragraph 70. I cannot say from where the stamp was purchased from which the deed of settlement was written. I cannot say where the deed of settlement was registered. I cannot say whether Indubhushan Bandopadhyay Sheresta at such and such. I know Indubhushan Babu, it is not a fact that Nirmal Mitra does not have any property anywhere than the suit property. Lord, page 72. I cannot say whether the family settlement deed was executed upon informing Nirmal Mitra about the same or not. I do not know anything about any previous suit. It is a fact that Nirmal Mitra came to know about the family settlement deed only in course of earlier litigation between him and his brother. Nirmal Mitra was not aware about such family settlement deed previously.
Mr. Rai, this now boils down only to the interpretation of the family settlement deed.
Yes.
Nothing else. If that goes, then that's not
Absolutely,
binding, then
Lord,
you
that
get
is-
a partition degree.
Yes, yes, I have got that. Lord.
Only that, and it's a question of interpretation. So we
Yes,
should
and
look
Lord,
into
kindly
only
see
the family settlement deed only, I suppose.
Yes, 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 absolutely, my lord. That is
So
it.
that is the scope of argument of Mr. Basu as well as must be you also.
Lord, Mr. Basu, my lord, went a step further, my lord, and he said that the court went wrong in not interpreting it as a will.
Yes, right. So it revolves around that deed.
Yes. Now, my lord, kindly have a look, my lord, at the issues, my lord, which were settled.
Where is that?
Page 31. My lord,
These were not recast later.
no.
Because
And Lord, because in the judgment also, your lordship will find
same
the
issues, yes.
Yes, yes.
Because
Lordship,
once we
page 100.
Ah.
Page 100. My lord, 4 and 5 is what, my lord, should clinch the case. Whether plaintiffs have right, title, and interest over the suit property, are the defendants absolute owners and occupiers of the suit plot. My lord, this issue would not be decided even if it was a will. My lord, even a probated will, my lord, will not give a title. My lord, that is also settled today. Even if it is probated, my lord, that by itself.
Not that a probated will not give title. Not
Lord, if
that.
it is disputed.
Because Section 41 of Evidence Acts comes in.
Yes, yes.
Legal character by virtue of that document.
Yes.
It's not that, but question of title is not decided by a probate.
Probate court. Yes.
That does not mean that.
That is what my submission was, my lord. If it is a probated will.
If it's a probated will, it would be different. Could be different because Section 41 says legal character arising from that.
It is brought to the notice of this court, which is deciding title. This court will decide title, my lord, in this partition suit. And
yes,
if that
absolutely.
probated will is brought to the notice of the
court, that has to be exhibited and marked.
Yes. No, my lord, if this case is not made out, my lord, it will be an irrelevant inquiry for the court to undertake. My lord, why would the court take such exercise, my lord? Why would it do, my lord? The case is only whether it is a family settlement or at best a gift, my lord. That is what the case run was.
More appropriately, whether any transfer, whether any title was transferred.
I bow down to your lordship, my lord. Like kindly have a look, my lord, at the observations, my lord, of the judge of the learned court.
Mr. Rai, suppose we decide this case, all this is over. Now they, on the premise that that's a will, even without any court holding that, they get a probate. Then what will happen? This will be upset then.
My lord, if they get a probate.
If they get a probate.
My lord, because your lordship, my lord, is well aware, my lord, that mere execution or valid execution of a will not ipso facto mean genuine will being genuine. Genuineness.
Execution, valid execution as you proved and genuine.
Yes, and even if it is validly executed, my lord, the genuineness will be a different thing. My lord, I may have validly, signature may be mine, but the circumstances in which the signature were put, whether, my lord, he had the capacity to sign or not, all these things, my lord, will be taken into consideration.
If a probate is granted, those come within 68 and Section 63.
Yes, therefore, my lord, this here. If
a probate is granted subsequently, then that will take care of itself. I mean, whatever, then they can file a suit probably on that.
If your lordship goes through the document, there is no executor appointed here. Therefore, my lord, it will be a case of letters of administration.
Yes.
Where, my lord, the legatee itself will have to prove the will.
Right.
Now, my lord, here the witnesses also are not legatees. The two sisters, my lord, who have deposed, they are not legatees. They are not beneficiaries.
Not only that, we are in doubt whether the attesting witnesses can be found now. Anyway, let us not go into those wishful thinkings for Mr. Basu. Yes.
So, my lord, this is the
so let us see how the court did.
Yes.
For 4-5. All are taken together, obviously.
Yes, 106.
Yes, 106.
all these issues are taken taken up for simultaneous consideration as they are inextricably interwoven. During argument, learned lawyer for the plaintiffs mapped the journey of his clients to the suit by saying that the suit property was purchased by Manoranjan Mitra in the year 1950. He constructed a house thereon. He continued to possess the same along with his 2 sons and 6 daughters till his death on 7/2/97. Nirmal Mitra, the younger son of Manoranjan Mitra, filed instant suit against his elder brother being defendant number 1 and 6 sisters being defendant numbers 2 to 7. The wife of Manoranjan Mitra breathed her last during lifetime of Manoranjan Mitra. He claimed that upon demise of Manoranjan Mitra, each of his children became owner of 1/8 share of the suit property. Nirmal Mitra had been residing in the suit plot with his wife and 2 daughters. The defendant number 1 went to UK in the year 1961 and joined a job thereat. His children were born in UK and used to stay there. The defendant number 1 previously filed one suit being titled suit number 84 of 2008 before the Court of Civil Junior Division Kalyani, praying for eviction of the plaintiff from the suit property on the strength of one family settlement deed.
What is this?
You know, it is this deed only on the basis of which he sought my eviction. I mean the plaintiff's eviction. In course of the said suit, Nirmal Mitra became aware.
What happened to that suit?
That was dismissed for default, my lord. I do not know whether it has been
Oh,
restored or
therefore the legality of the family were not the same.
In course of the said suit, Nirmal Mitra became aware of such family settlement deed. According to him, no such family settlement deed was ever executed by Manoranjan Mitra, and the same was a spurious one. Other than Nirmal Mitra and the members of his family, only defendant number 2 used to stay in the suit property. Said defendant is a spinster. Other daughters of Manoranjan Mitra stayed in their respective matrimonial house. Manoranjan Mitra during his lifetime inducted one tenant in a part of the suit property. Though the tenant was changed on many occasions, the defendant number 2 kept on collecting rent from said property, to which Nirmal Mitra never raised any objection. Nirmal Mitra and his wife used to take care of Manoranjan Mitra after demise of his wife. On the contrary, the defendant number 1 did not have good relationship with Manoranjan Mitra as he went to UK against the will of his father. The relationship between the original plaintiff and the defendant number 1 also became sour when he reminded the defendant number 1 that he had duty towards his father. It is claimed that if at all Manoranjan Mitra wished to settle his property in favor of the defendant numbers 1 and 2, he would never had sold 3 decimals of land in the suit plot to Meena Ghoshal. Learned lawyer for the plaintiffs for the claim that the deed of family settlement was never acted upon. The plaintiff on 6/12/2010 requested the defendant number 1 to effect partition of the suit property amicably, but the said request failed to yield any dividend. It is alleged that the defendant number 1 on 28/2/11, with the aid of some unknown persons, took measurement of the suit property and disclosed that he would sell a part of the suit property to a promoter. Finding no other alternative, Nirmal Mitra took recourse to law by filing the instant suit. Learned lawyer for the plaintiffs admitted the letters proved by the defendants as exhibits B and C series. In fact, he took placed reliance on some of these letters. According to him, Nirmal Mitra, the original plaintiff, and the members of his family had excellent relationship with Niharendra Mitra, his wife and children. In fact, whenever they came to India, they used to accept hospitality of Nirmal Mitra and his wife. Niharendra Mitra on many occasions helped the original plaintiff and his family financially.
How are these relevant?
Not relevant. I'll take your lordship, Lord, to the points which is relevant.
Yes.
Lord, I am not taking a lordship, Lord, to the arguments made. I am taking a lordship, Lord, to the findings. Lord, the arguments made by the defendants are important, Lord, because your lordship will kindly take page 113. Lord, I am excluding this because the part where he may not lay stress on the deed, if lordship kindly take 114. 6 lines from top.
Yes.
Lord, he put great emphasis on exhibit A, marked deed, being the deed of family settlement, by saying that the deed was actually a deed of gift, by virtue of which the suit property was gifted to defendant numbers 1 and 2 in its entirety. According to him, the attesting witnesses of the said deed deposed before this court, wherefrom it would be crystal clear that Manoranjan Mitra on his own volition executed the deed of gift in favor of elder son of Manoranjan Mitra and unmarried daughter Ranju Mitra. According to him, the testimony of DW1 and DW2 were of paramount significance insofar as they declared upon entering the witness box that their father executed exhibit A marked deed on his own volition in favor of defendant numbers 1 and 2. Counsel for the defendant numbers 1, 2, 4, 5, 6, and 7 claimed that the evidence of these witnesses must be relied on since they deposed against their interest, as in case exhibit A turns out to be invalid. those witnesses would stand to gain by virtue of inheritance from their father. He asserted that Manoranjan Mitra was of quite sound mind while executing the impugned deed. Had he not been of sound mind, then how could we execute deed of sale in favor of Meena Ghoshal, that too after a gap of almost 4 years? My lord, again, my lord, about 4 lines from top. He claimed that Exhibit A was actually a deed of gift, though the same was termed as a deed of family settlement. So this is the case all over. Now, my lord, in this background, the learned court, my lord, several judgments are cited. Kindly take note, page 120. Last paragraph. In this suit, the legality and validity of Exhibit A is of pivotal significance, as in case the same stands the scrutiny of law, the entire situation would be different. If, however, the said deed cannot be sanctified, the property would devolve upon all the heirs of Manoranjan Mitra following the rule of Hindu succession. In order to find out true purport of Exhibit A marked deed, I went through it repeatedly, scrutinized it carefully, and studied it meticulously. The heading of the deed states that it was a deed of family settlement. However, with the authorities propounded by the defendants, I am of the opinion that such heading is not required to be given much credence. In this regard, I am to adhere to the good old Latin maxim, animus moninis est anima scripti, which means that the intention of party is the soul of the instrument. The deed, however, in its 4th and 5th pages, repeatedly and vividly manifested that the executor of the deed, namely Manoranjan Mitra, allotted shares in the suit property in favor of defendant number 1 and 2, and he directed the deed would come into operation only after his death. At this juncture, it is thus imperative to understand what a gift actually means. Section 122 of the Transfer of Property Act defines gift as under. Lord, therefore, definition of gift is quoted. Lord, I'm not troubling your lordship with that. And Lord, he my lord dwells on it, page 122, as to whether there has been an acceptance of gift or not. My lord, ultimately, he comes to hold, Lord, at page 124. Bare perusal of the definition makes me feel that the deed in question has got no resemblance with the theory and concept of onerous gift as codified in section 227 of the Transfer of Property Act. Through the deed in question, Manoranjan Mitra did not transfer several things to defendant numbers 1 and 2, out of which one or more was burdened with an obligation. Thus, the contention that an onerous gift was made by Manoranjan Mitra through Exhibit A merits rejection. In regard to the present controversy, section 124 of the Transfer of Property Act is of some significance. Said section says that a gift comprising both existing and future property is void as to the latter. In the celebrated case of such and such, it was observed that there cannot be a gift of future property. For such gift can only be a promise, and a promise not supported by consideration is invalid as a contract. Though in suit no future property was proposed to be transferred, but existing property was expressly transferred on a future uncertain date. The said transaction cannot fit into the 4 corners of the definition of gift as is given in the Transfer of Property Act. In the case of such and such, my lord, he discusses the cases, and ultimately, my lord, page 126.
Yes.
Consequent to the discussion held above, I am compelled to reach at the irresistible inference and inescapable conclusion that by executing Exhibit A marked document, Manoranjan Mitra did not validly gift his property to defendant numbers 1 and 2. This is all the more so as far as he subsequently transferred 3.5 decimals of land out of the said property in favor of Meena Ghoshal. Zeroing in my attention to the claim of defendant numbers 8A and 8K and 8Kha that they are not necessary parties of the suit as their predecessor in interest purchased such and such, my lord, I am not troubling your lordship with this. And then, my lord, he ultimately holds the suit property is thus held to be undivided property, and my lord passes a preliminary decree of partition. Now, my lord, I'll take your lordship, my lord, very quickly through the deed. Your lordship has been taken to the deed, my lord, by my learned senior friend on the other side. Kindly take note, page 206.
Yes. 213?
206.
What is 213?
213, my lord, is a part of the deed only.
No, it's a typed copy of it.
My lord, 215, my lord, is important. Which is what, my lord, does not make it a gift or a settlement. Lord, 7th line from top. আমার জীবদ্দশায় সম্পত্তি হস্তান্তর করিবার প্রয়োজন হইলে আমি আইনসম্মতভাবে হস্তান্তর করিব, তাহাতে অপর কেহ প্রতিবন্ধকতা সৃষ্টি করিতে পারিবে না। Lord, he keeps the right to himself. After his death, Lord, it could have been a will. But even if it is a will, my lord, in a suit for partition, till such time that a specific defense is taken by the defendant that I have a will which has been probated and which therefore becomes a document of title, so far as this case is concerned, my lord, the court will not inquire into this. Why should? My lord, your lordship is well aware, my lord, of this. My lord, just for the sake of completion, I'll cite, my lord, that generally, my lord, appellate power, notwithstanding, my lord, the broad contours, my lord, of section 107, and Lord Order 41 Rule 33, would interfere not when the court is not right, but only when it is absolutely wrong. My lord, not interpreting it as a will not make the judgment wrong. I would say that it is also not in the caption not right. It is right. But my lord, even if it is not right, my lord, it does not merit interference at the appellate
You're
stage.
citing judgments for that.
Not, I'll not.
Side.
Lord,
Just complete.
because
Don't cite soon to it.
not so many, my lord. I thought, my lord,
Cite one or two which sound good, or we shall embellish our judgments also.
this, my lord, I thought to take, my lord, because of Justice Iyer's, my lord, language.
Oh, then definitely. I have a weakness for justice.
Yes,
Many people have a weakness for
yes,
justice.
even I have, my lord. That is why, my lord, I thought, my lord, I'll.
No, I am afraid, my lord, for reading that judgment.
Now, after the conflict between the ex-CJI and Justice Nagaratna on Justice Krishna
No. Only
and Justice Dhulia.
if I have to read Justice Iyer's judgment, my teeth are broken. That's the problem.
Yes.
Lord, here, my lord, the language is.
No, also for his philosophy.
Yes, that's good.
Lord, paragraph 4.
Reference বল না রত্নেশ।
Citation হচ্ছে 1975 2 SCC 730. Paragraph 4, my lord.
Yes.
Lord, moreover, Lord, about 4th line from the bottom. Moreover, there is a prudent.
Yes. Middle of that paragraph.
Yes. Moreover, there is a prudent condition to which the appellate power, generally speaking, is subject. A court of appeal interferes not when the judgment under attack is not right, but only when it is shown to be wrong.
Right.
These twin principles serve as backdrop to our approach, my lord. So this.
And also there are several judgments.
Yes.
Appellate court will not substitute its own views.
Yes, my lord. There are several, my lord, which
That's a corollary of this actually.
my lord. This was the main judgment, my lord. So, my lord, in my very respectful submission, my lord, even if the court had held that it was a will, my lord, the result would have been the same. Therefore, the court would not go that far. My lord, the best case that they could have made out, my lord, if that has been annulled, the weaker case, my lord, need not be inquired into. My lord, why would I, my lord, undertake that exercise, my lord, if I know that it is doomed to fail? Unnecessarily, my lord, the court will not waste judicial time.
And their consistent case was it was a gift deed.
It was their consistent, and I need not cite judgments, my lord, that your lordship will decide only on the basis of the pleadings issues raised. There are cases, my lord, where leases have been, my lord, interpreted to be licensed, but there is somebody, my lord, who says that it is a license. Court of its own, my lord, or my lord, if the court holds it in one way, then in that case, it will be a question of granting or not granting the relief on the basis of such interpretation. My lord, here even that is ruled out.
Yes.
Lord, I rest my case at this.
Yes. Reply, Mr. Bas. Rather rejoin.
Yeah. Can it be on the next date or?
No, to finish it.
Finish it. So far as the proposition, my lord.
There is not much in it. You have already cited so many judgments.
Yes, I have cited the judgment on the proposition and judgment which has been cited, my lord, I concede. Not fitted in the case.
Mr. Bas, yes.
One, my lord, the judgment, my lord, which was cited.
If you want to add something, Mr.
Yes.
My lord,
yes.
PK Mohan Ram judgment, my lord, which
PK Mohan Ram, yes.
Lord, that not supports my case. My lord, it shows that it is not a settlement.
No, that my lord has already distinguished and I also concede to that. Because there he reserved his entire right till he dies. Here,
yes.
my lord, the predecessor has.
Yes, that helps.
Not only said, he also distinguished. Only one thing, my lord, your lordship, so far as these matters, this is a preliminary decree.
Yes.
So it will go thereafter. If your lordship affirm is already going to be a final decree, there is a proceeding. Today, it appears to us, even if my lord declares or not declared, that this document is not a family settlement. And I don't know who has made out a case of gift that has been nullified, rightly nullified. Even if today is not a case of, my lord, the family settlement, then, my lord, this document before the court court will interpret the document. To find out whether it is a family settlement or not, court has to interpret. If while interpreting, court finds that this is not a family settlement, but is a desire of the testator, last will. The contents, I'm not stripping the word will, his desire has been reflected by a document. So that, my lord, the court will not give, my lord, a thought that the respect to the last desire of the person should be adhered to. I am not asking your lordship to decide here whether it is a will or not, whether I shown to your lordship for the purpose of this that execution was never denied. In the evidence, my lord, execution of this document was never denied, but it loses its character as family settlement.
The execution was also denied.
No, my lord,
but
I
he
have
could
shown
not
to your
prove
lordship,
it.
if I'm not wrong, my lord taken note of, in evidence, they have said the document was
Also,
executed.
evidence. All right.
Evidence they have said. So evidence will, my lord, if document is, their execution is admitted, and document while dealing with a court of law finds that it is not a family settlement, the court, the party has gone to a proceeding with wrong conception, court will not correct it. I'm asking the question to myself. On the face of it, this document is an will, if not family settlement. Then my humble submission, the court will, my lord, must correct it. And what we are praying, today everything is clear. My lord is of the view, express your lordship's view in the court that this is not a family settlement. At best, it can be an will. In that context, my lord, I will be praying for a short accommodation to file an application for letter of administration. Executor is not there. I am not saying that your lordship can grant the will provided here. No.
Why not? If we can grant that liberty, we can also grant the letter of administration.
No, I am not asking your lordship to give that liberty. I am asking for an adjournment at best. Because the case which has been made out.
If we adjourn it for letters of administration, it will not be adjourned sine die. It
No,
will
no,
be
no.
adjourned. It will be adjourned I may die. We never know when it will be ended.
No, no question of adjournment. There I can pray for an injunction. If your lordship grant me a month's accommodation for deciding this list, I will go and file and get an order. Only thing I will be praying before lordship, this decision will not preclude me from granting a probate. If I am
Rather, we'll dispose of the appeal and direct the trial court to dispose of the suit as early as possible, so that you cannot do that.
Then having found
your consistent case is give deed, and now you
this is
want to go
I
and
don't
file
know.
a letter.
My lord has seen the written statement. Who said this?
We'll
give
ensure
deed?
that it is done before you can get a letter of administration.
The lawyer's own, my lord, perception. Nobody has.
That very lawyer sent the matter to you, so you should not grumble.
No, but this is not the case made out by the parties. Parties, the defendant proceeded on the basis that it is a family settlement. But it appears from the stipulation in the family settlement, as it appears to my lord also, and the judgment which has been cited in the bar, it appears that when he has in presenti reserved his right, not only that he has transferred, there is no vesting in the presenti. If it is not, then it will go after the death of the testator. The person concerned who had written this document, I should say, written this document. Yes. So, my lord, this is our case made out. I have not precluded from filing an application for granting probate. If that is, my lord, saved, my lord, I have no problem with that.
Thank you, Mr. Basu. We'll close arguments.
Grateful to my lord.
Hearing is concluded. Judgment is reserved.
Grateful.
সব লক স্টক ব্যারেল ধরে পাঠিয়ে দেবেন
দুটো তো জাজমেন্ট দেখেছি, লক স্টক ব্যারেল করতে আসছে।
Death is uncertain. We never knew when he would die.
No, when is yes, death is certain, when uncertain. That is Mr. Sen's contention. Death is certain, when that is uncertain.
Yes. Oh, achha, right. You're right. Event is not uncertain.
That I'm saying.
That's on the event horizon. Yes, next one. Thank you. Yes, Mr. Mukherjee, now your turn.
on the last day, we are just going through the judgment, Your Lordship.
Yes.
That is page 146, 64 to 174. There are 169 on the last day. which
Yes,
saw-
exactly. 169.
but
Right.
I'm reading it. Defendant number 3. Defendant number 3, the husband of original plaintiff entered appearance and contest the claim of plaintiff by filing a separate written statement. Defendant number 3 is the uncle. His positive case is that the original plaintiff executed registered power of attorney in favor of defendant number 3.
On the last occasion, my lord.
Oh, আমাদেরটা দিয়ে দাও।
Yes.
We
We
opposite.
filed an application under order 4127. This is the opposition.
Yes, we are also got reply. দিয়ে দাও, দিয়ে দাও। হ্যাঁ। আমি দিই। কি? Reply, হ্যাঁ দিয়েছি। কপি তো দিয়ে এসছে।
Right. Yes.
And executed a deed of gift in favor of defendant number 1 voluntarily with full knowledge in presence of witness after the document was read over and explained to her by advocate P.C. Tandon, and her thumb impression was attested by her husband, that is defendant number 3, and defendant number 1 accepted the gift by signing it. It is the further case of the defendant that the claim of application is false and suit is liable to this. Evidence adduced. Plaintiff on her part examined her son, Durga Prasad Chaudhary as PW1, who corroborated the plain case and proved the original registration slip with AD card, bearing signature of defendant number 2 and exhibit 1 and 1 by 1, AD card and disposal registration slip of a letter dated 28 June 1991 sent to Ramchandra Chaudhary, that is the elder brother, father of Ashish. Exhibit 2 and 2 by 1, copy of letter bearing signature of PW1, Exhibit 2 by 2, registration slip of letter dated 6 August 1991, addressed to defendant number 2, Exhibit 3. Copy of the letter, Exhibit 3 by 1, letter of Ramchandra dated 21st August 1991, along with an envelope, Exhibit 4 and 4 by 1. This is they want to mean Ramchandra Chaudhary wrote a letter. Yes, this is wrong. And this is very important, my lord, to point you out, lordship, that in this context, just I show the document. They filed an application for receiver on the basis of that letter. They say Ramchandra Chaudhary has accepted all this. Now, when Ramchandra Chaudhary came to know the contents of the letter from them, he filed an affidavit on this basis of that letter. That no, this is not my signature. The contents of the letter, so far I find it was typing. I have no occasion to write Dear Durga or to anybody else. And it is not my signature. Now, this I am just touching it, then I will go for elaborate discussion.
The refer which my language is referring to is not on record.
I will show it, all right.
That was not produced.
Yes, I will show it. Copy of letter PW1 sent to defendant number 2 dated 4th June 1991 along with postal slip, exhibit 5 and 5 by 1, letter of defendant number 2, that is Ashish, addressed to PW1 dated 26 June 1991, along with envelope Exhibit 6 and 6/1, later dated 25th September 1991 of defendant number 2, along with postal envelope Exhibit 7 and 7/1, certified copy of lease deed dated 26 July 1961, by which the original lease was given. That is Exhibit 8. This witness was cross-examined in full and discharged. The plaintiff herself deposed to the learned commissioner as PW2. My lord will clearly, my lord, kindly mark it. PW2 is the plaintiff. He is coming first. PW2, that is his son. And court has, my lord, although a objection was raised, court has relied on 1978 Odisha, 228 or something, but court has omitted in one. Law Commission has discredited this, and why this has been introduced. Rather, it has been said mandatory. Court hold it, oh, it is a directory, so it can be done. In any case, thereafter evidence of PW2, the plaintiff was taken up. I will give it, my lord. Just I am touching.
PW1 was his son.
Son, he is not the plaintiff. He is the initiator of all this, all the correspondence. Always Durga is, and no other son.
All right.
The plaintiff herself deposed to learned commissioner as PW2. The defendant on their part examined defendant number 1 as DW1, one Sadhan Kumar Rai as DW2. DW1 is the donee, right? Sadhan Kumar Rai is an attesting witness of the deed. And Puran Chandra Tendon is the advocate who actually prepared, who actually explained, read over, and all these things in the registration office at the time of execution. As we do, and defendant number 2, that is Ashish, as DW4. Defendant proved the lease deed dated Exhibit 13, 26 July 1961. Signature of husband of original plaintiff on the deed of gift dated 27 May 1985, Exhibit A. Tax bill of July 1990 to September 1990, Exhibit C. Application under 187 of CMC Act dated 22nd July 1988, Exhibit D. Later dated 20th March 1985, Exhibit E. LTI of plaintiff on deed of gift dated 22nd May 1985, Exhibit F. Signature of defendant number 1 on the deed of gift dated 22nd May 1985, along with signature of witness on this deed and the deed itself, Exhibit F/1 to F/4, later dated 25th September 1991, with postal receipt and ID card Exhibit G, G/1 and G/2, certified copy of affidavit filed in FMA 798 of 1998. This was very relevant in the sense she was a party, she was executing document in the court for affirming an affidavit in different cases. That means she was quite active lady, not that because she is putting her thumb impression, so she is totally ignorant on anything he has got. Decision with reasons. These issues are related to maintainability of the suit. That a counsel for defendant in their argument argued the suit is bad for non-joiner of necessary party, as Nomita Devi Chaudhary, the other signatory of the lease deed, the mother of Ashish. For non-joiner of necessary parties as Srimati Nomita Chaudhary, Kolisi and CITU were necessary parties and must have been impleaded. Your Lordship, I am just reminding your Lordship will remember in the plaint, a point was taken, no permission was sought for from the Calcutta Port Trust.
Yes.
I'm sorry, Calcutta Improvement Trust, yes. And
chairman of the board.
Yes, chairman of the board. So you are putting these allegations against them, why they have not said, and we have done all this, it should be cancelled in other way. But you are not making them party. And In this context, my lord, I will also, my lord, this is on record. I will just, my lord, put some of the words that subsequently the plaintiff wanted to transfer this property about a half share in favor of his son, for which she wrote a letter, give me permission. They did not they did not practically dispose of or do anything. Ultimately, they came before this Honorable High Court. We are not a party there. Ultimately, Honorable High Court directed to give them a hearing. On hearing, they call for it, my lord, report the law officer from the registration office, not the department. They are say, no, we don't find any endorsement, no doubt. This is from the registration office before the
Sir,
registrar.
but you can complete the judgment
All right,
and
all
then
right.
when you make your submission, otherwise there will be an unnecessary
All
repetition.
right,
You say that,
all right.
again you argue on that.
All right.
Let us complete the judgment, then make your arguments
All right.
in a nutshell.
Further argument of plaintiff, the plaintiff has got freedom to choose an adversary. No relief is sought for from Srimati Nomita Devi Chaudhary Kolesi, CIT, and the transaction and relationship original plaintiff with these two persons are admitted by both sides. So there is no defect of parties. Learned Counsel of Defendant argued that the suit is barred by limitation as per provision of Section 59 of Limitation Act. To this, Learned Counsel of Plaintiff replied, according to Article 59 of Limitation Act, the period of limitation of 3 years starts from the date of knowledge as well as the date when it first came to this knowledge. And in the instance case, plaintiff has specifically pleaded that she came to know of the fraud by defendant number 3 for the first time on receipt of letter dated 21st August 1991, that very letter which was marked exhibits for the court, and 25th September 1991, Exhibit 7, respectively. So, for her limitations started running not before 21st August 1991. And she filed the suit on 26th August 1992. So, the suit is not barred by limitation. The counsel for the defendant argued that the suit is undervalued, and as the plaintiff has claimed for cancellation of deed, computation of court fees is actually to be done under Section 748 of Court Fees Act, Court Fees Act, and not under Article 17 as referred to a decision of the Honorable Court to this effect, reference 2013 1 SCC 579. To this, Learned Counsel for Plaintiff argued that the suit is filed for declaration and permanent injunction. So it is actually by Section 74B by the Court Fees Act and referred to 2006 1 CHN 526, whether the Honorable Court has held that when the suit is filed for declaration simpliciter and relief for setting aside deed is consequential, suit is not required to be valid on valuation of property. Issue number 2, 3, and 6 are accordingly decided in favor of the plaintiff. Issue number 1, 4, and 5, these issues being interrelated, are taken up together for brevity and convenience of discussion. The only bone of contention is whether the original plaintiff executed registered deed of document on 22nd May 1985, knowing it to be a deed of gift in favor of defendant number 1, or whether she executed it believing the same to be a power of attorney, or in other words, whether the stated deed of gift dated 22nd May 1985 is legal, valid, and binding, or whether it is illegal, void, and not binding on plaintiff. In their argument, learned counsel for defendant has argued that both the sides of the deed of gift and the advocate who drafted and prepared the deed of gift have deposed as DW2 and DW3, and both these witnesses have deposed that the deed was prepared as per instruction of original plaintiff, namely Rama Devi Chaudhary and her husband, defendant number 3, Radha Krishna Chaudhary, and that it was read over and explained to the original plaintiff and the document was registered. So the whole story put forward by plaintiff is concocted, imaginary story, and plaintiff has failed to establish the same. Learned counsel for defendant referred to the deposition of plaintiff's witness in this context and pointed out that PW1, that is son of original plaintiff Ramadevi Chaudhary, admitted on oath that he was not present at the time of execution of the deed in question. So this statement as regards the understanding of Ramadevi Chaudhary about contents of document, about the process of preparation of documents cannot be taken to be sacrosanct. Moreover, defendant has examined the witness to the deed as well as the advocate who stated that he has prepared the deed as per instruction of original plaintiff and her husband. So defendant has duly established that the deed was prepared and executed as per desire and knowledge of the plaintiff. To this, learned counsel for plaintiff argued that he has proved the letter sent by Ramchandra Chaudhary dated 21st August 1991, Exhibit 4 and 4/1, and it transferred from the letter that defendant number 2 and 3 misguided the plaintiff and made her execute a deed of gift in the guise of executing a power of attorney. It was further argued by plaintiff that original plaintiff was examined on commission, and during her examination on cross-examination, he has stated that she never gifted suit property to defendant number 1. So she has proved her case. It was further argued by plaintiff that his witness has deposed on oath that she had bitter relation with her husband and he used to torture and beat her, and the advocate examined by defendant has deposed that they drafted the deed in question as per instruction of the husband of original plaintiff.
After saying so many things, Mr. Mukherjee, the court comes to the conclusion that permission was not taken from the CIT. That's why it's bad. That is the crux. And this long judgment, the actual decision of the court is in 2 pages.
My lord, the difficulty is, my lord, the Calcutta Improvement Trust, in spite of having the knowledge, they discarded their contention. They did not bring the report from their own office. We have got the made it exhibited. Some of the correspondence showing we required to give the visit of.
Mr. Mukherjee, you could have called for the document. I could have called for a witness from the office of the CIT.
My lord, that could have. CIT is not a
party. It is your burden because you rely on that document.
CIT is not a party.
Need not be.
Proceeding.
Could be a CIT officer, could be a witness.
My lord,
it's your burden.
I cannot newly, my lord, improve my case. What has been done. But
yes, because you rely on that document, it's your burden and onus.
I can at best. This is the first appeal, first pending court, and the court to do justice.
Mr. Mukherjee, this appeal should take 2 minutes to decide. You have proved nothing to indicate that there was any prior permission from CIT.
Everything is oath against oath. And
so no question of oath against oath. You rely on a document. You have shown nothing to indicate that there was a permission from the CIT. Where is the permission? Written permission.
Well, the contention of them was that this void document not void. They are not.
Let us ignore. There are 2 conditions. One is void, manufactured. Those have not been taken by the court. Court says this clause is there not to assign or transfer in any way without the previous consent in writing of the chairman of the board. You only had to bring in writing.
That is why Order 41, Rule 27 also filed.
The writing of chairman is there in the Order 41, Rule 27.
That the document which has been given so that we can call for it.
What prevented you from doing it throughout the course of the hearing?
That is not a
in Order 41, Rule 27A is hit.
It probably being a defendant.
That was your brainchild, Order 41, Rule 27, Mr. Mukherjee, after you came.
After when?
Or your learned friends.
Yes, when we found, my lord, after filing the appeal that everything is on record.
But you cannot satisfy the court that despite due diligence you could have.
No, because of the fact that they had no knowledge. Because by this time, the DW3 died.
Couldn't you have summoned somebody from the CIT? Couldn't you have asked for the document?
That is after, my lord, when after the record came here, and when we found all this, then we filed this application. We have stated in that.
That is not a good ground under Order 41, Rule 27AA.
You appreciate. These are all housewives.
Housewives don't get a privilege over husbands.
My lord,
insofar as civil rights are concerned.
doubt of it. But
In fact, if you go to my house, my wife is much more, I mean, prudent than me.
nowadays,
Not
previously-
nowadays. Previously also it happened. Previously it was not disclosed. That was a secret kept by the women. Previously also women were much more intelligent and much more worldly wise than men.
no doubt of it, but your lordship will appreciate one thing.
Yes, if it is a lady from the village who is really Pardanashin in the real sense, then yes, this is not a Pardanashin lady or a.
Which one?
Nobody here is Pardanashin, neither the men nor the women.
You admitted that from the marriage I am in Jhargram.
Jhargram, that means Jhargram is much more educated than us.
That is her claim.
Midnapur and Jhargram is much more educated than Calcuttans.
That is her claim that I do not know how to read, write, and they have done all these things because I am coming from village. This is the statement.
Yes, Mr. Mukherjee. You can continue.
Today?
No, today, yes. Finish it as fast as possible.
Yes.
We have already made our mind.
Yeah.
But you have to dispel that notion of ours.
Because further argument advance on behalf of plaintiff that the letter written by the son of original plaintiff to defendant number 2 on 4th June 1991 goes to show that the plaintiff knew and believed that she has actually executed only a power of attorney.
Yes. Violation. The scope of argument actually, Mr. Mukherjee, is whether this clause is inviolable. I mean, whether non-compliance of this clause, that is the only scope of your argument actually.
I can show.
Because the decree has not been passed, it has not been believed that it's a manufactured document or something like that. Only ground ultimately made out by the court was that this clause was violated. Now, if you can show us, you can argue on this that whether this clause is mandatory or you could argue probably that it's directory.
Not only that, that I'll do.
That is the only scope of argument in this appeal.
There was no penal cost, nothing else. That if you don't comply, and this I will show you, my lord.
But it's couched in a negative language.
Unfortunately, the power of attorney, as I told your lordship, already executed. That was not in mark, although it is on record, because it was produced on behalf of defendant number 3, who filed written statement.
Power of attorney, all these things do not matter. If there is no permission from the CIT, you have to argue whether that permission is mandatory. That is the only scope of this appeal.
That no doubt of it. But
nothing else
your
matters.
lordship will find
Fraud, misrepresentation, not proved, not accepted by the court. Only that violation is there. You can see the bold letters from page 175 onwards. That is the only crux of the judgment. The entire rest of the thing is like what learned counsel for the parties have argued. That has been quoted by the judge for 12 pages.
If your lordship find the lease deed, there is nothing in the lease deed that there will be any penal cause or it is not done.
That is the scope, a real scope of argument. You come to that directly.
I will
do that. Why waste time?
Firstly, my lord, I want to appraise your lordship all exhibited and unexhibited which are already on record.
Mr. Mukherjee, if the court had accepted that it's a forged or manufactured document, if there was a clear finding on that, then that would be very germane. Court has proceeded from page 175 to 177. We have seen in different languages the same thing has been said. If you say it's binding, that clause has been violated.
Without applying the evidence, my lord, itself, what has been stated and what is the, my lord.
No, only scope is then you have not lost on the ground of the deed being forged or manufactured.
Yes.
Only on the ground that this was violated.
That
This
was
clause.
one of the 3 points.
Court has not said that.
The 3 points. One, this no permission.
Mr. Mukherjee, that was their point. That is not accepted by the court anywhere. Show us that the court has accepted. Page 175, the bold letter is the only judgment of the court, decision of the court. Show us that the court has accepted, said that yes, it was a fraudulent document. Show us that from the findings of the court. Court has not found that. Up to page 175, second last paragraph, it's only learned counsel for the such and such arguments. And
my lord, 3 points has.
They took 3 points. Only one was accepted that this clause was violated. Just come to page 175, the bold letter. Mr. Mukherjee, we hope we'll be able to convince you on that. Only clause para 6 of that court has said defendant were trying to establish legality. Onus was on the defendants to establish that it is a lawful document legally executed having binding effect on plaintiff, but you have failed to establish, defendant has failed to establish the same. And that also does not say it's a manufactured document. Every other clause of the judgment portion of decision portion of the judge is CIT that document, CIT permission not taken.
But where is they have also not able to prove that I have not taken the permission of CIT. It is
Negative
there
proof.
also
They will prove negative proof that you have not
no,
taken.
no.
What are you arguing, Mr. Mukherjee?
Right, yes.
They'll prove negative proof that
No,
you have not taken permission.
They have made the allegation this was not taken. But
Mr. Mukherjee, this is not expected from you. Are they expected to show that you have not taken permission? How can they prove a negative fact?
What? No. What?
You had to show that you had taken written permission.
Understand, madam.
Or you can argue alternatively that we are also giving you, supplying you with the arguments which you can make. That this clause is not mandatory. Argue only on this and dispose. Let us dispose of that.
But
Only on these 2
one
points.
thing your lordship will appreciate, the CIT was not made a party there.
Need not be. Why should CIT be made a party?
Naturally, further CIT when gave a hearing to them, CIT, my lord, even
it's a title suit between you two. Why should CIT be made a party?
That is, my lord, the permission has not taken. That is being, my lord, being this.
That's a relevant fact. That comes within relevancy clause of the Evidence Act. But CIT is not a necessary party in the matter.
No doubt of it. But your lordship will find, well, we have taken permission and everything. Yes, ultimately we could have, my lord, brought any officer from the CIT board chairman to prove that document.
Show us any written permission, we'll grant you, we will allow the appeal.
Should be.
Show us any written permission from the CIT, we'll allow the appeal. In the alternative, you, Mr. Mukherjee, you satisfy us that this clause was directed, not mandatory. These are the only scopes of arguments. Please confine to that.
Is the document
Please confine to that.
1962.
Because we have so many, we are heavy in our hand with so many appeals pending.
62.
Anyway, Mr. Mukherjee, we have got so many appeals, we cannot give further time to you on arguments. Please argue on these 2 points we are pinpointing. One, that whether there was any written permission. Alternatively, that this clause was not mandatory, it was directed.
Yes.
Show us that and get an... do it right now.
Right now, my lord, kindly go through the list.
We hope that you had prepared yourself on these 2 points. These are the main 2 points. So argue on that only. Let us forget the rest of the judgment. Yes. Page 51 of part 2.
Page 51.
And that clause is at page 52 of part 2. Clause 6.
This is the legislator. Second.
Mukherjee, we expected arguments from you on conditional transfer, whether it can be done on these aspects of the matter.
The findings of the trust court trust made a findings. So I brought it on record that the findings itself by port trust at the time of that, they have taken note of it. Yes, the report was called for from the register and no endorsement was found by the registrar to that sort, not from the CIT. Even they did not search it out. And they say we cannot entertain because it has already been transferred. That document is on record. They did not mark it exhibit, although they filed in it court below. That was during the pendency of the suit. That is why, my lord, I have very little scope at that stage, my lord, to bring out, because unless that unexhibited document, I, my lord, brought to notice of your lordship, my lord, because your lordship will have to understand the documents of 1962, 64, 61. So how the difficulty and how the mention is being made, but practically it had been, my lord, at that stage, the trial of the suit, which was commencing from 2003, it should have been more better for us to bring it on record, because nowhere CIT...
Where is your transfer deed?
My transfer
in your favor?
Yes. That is Exhibit A, page 61. 60.
Where have you stated there that any written permission was taken from the CIT? In your deed, registered deed, was that?
My lord, why can it not be done by your lordship? To pass an order to direct the chairman kindly to show.
No.
If it is so resolved, it can be.
No question of that. We are sitting in appeal. Is there any mention in your deed? It was your owners. We won't fill up your lacunae.
All right.
Nowhere it's stated in even your document that any permission was taken, any consent was taken.
No, this has been, my lord.
Love and affection only, which made you blind.
It has been that in the, by paragraphs, if it is found that without waiving another thing, my lord, the defendant number 3 also, my lord, filed a written statement where the doctrine of waiver he has taken. That practically the doctrine of waiver should be applied in this case. Well, that the same are partly matters on record of the DWs and documents relating thereto, and are partly facts of relationship. This defendant denies anything contained in the paragraphs of the plaintiff under reference which are contrary to the contract. Specifically denied that the plaintiff advance any sum or initial stake or installment of any premium as alleged, or she constructed a house on the premises in question as alleged in para 4 of the claim. The plaintiff is put to the strictest proof thereof. She had funds to contribute towards the premium or cost of construction and did not make any such construction as alleged in the paragraphs. My lord, can I, my lord?
We'll continue tomorrow, on Monday.
Monday? My lord, will your lordship, my lord, my friend is going to Combo. He will return on Tuesday. If it is Wednesday, my lord, that is not
one day so that I can.
The matter is heard in part, Pushab, on the prayer of learned counsel for the appellants. The same is adjourned till February 13, 2025 for further hearing. Affidavits in opposition and reply filed in connection with the application under Order 14 Rule 27 of the Code of Civil Procedure today be kept on record.
With your lordship's leave, my lord, may I mention a matter, my lord?
Yes.
But your lordship's passed this judgment yesterday, my lord. Just some correction, my lord, with the order of the names, our names as appearing in that order.
Yes.
I've indicated that, my lord.
It will appear as to be mentioned then tomorrow.
I'm grateful, my lord. Tomorrow.
Kalke to be mentioned হিসেবে দিয়ে দেবেন এটা. Oh, not tomorrow. Cannot be
Monday.
tomorrow. Monday. Monday it will appear as to be mentioned. To be mentioned bracketed for correction.
My lord, may I permit to give a lord?
Yes.
My lord, I have filed on review application with server copy, but the department is not giving. I have applied for certified copy.
Leave is granted. Leave দিয়ে দিন to file with server copy.